Gintod pilak, inaakit ang iyong mga mata.
Court was convened on May 18, 2026. For the record, since then, the court has issued summons and conducted pre-trial proceedings which are all made part of the records of this case. Resolution number 39, or the Rules of Procedure of Impeachment Trials as amended, shall continue to apply.
Your Honors, we are now ready to hear the statement of the Senate President.
Before we begin, with the court's kind indulgence, I wish to deliver a brief opening statement. Ladies and gentlemen, distinguished senator judges, sa araw na ito, binubuksan natin ang pagdinig sa kasong impeachment laban sa pangalawang Pangulo ng Republika ng Pilipinas, ang kagalang-galang na Sara Duterte, alinsunod sa ating saligang batas. Sa pagtupad natin sa tungkuling ito, malinaw ang panata na ating sinumpaan to do impartial justice according to the Constitution and the laws of the Philippines. Ibig sabihin nito, ang bawat pasya natin ay dapat nakabatay lamang sa saligang batas, sa ating mga batas, sa mga alintuntunin ng hukumang ito, at sa mga ebidensyang ihaharap na walang kinikilingan at walang pinapanigan. Impeachment is a constitutional mechanism that holds the highest public officials of the Republic accountable to the people. We cannot achieve accountability, nor can we faithfully serve justice without the truth. Karapatan ng sambayanan na malaman kung may katotohanan ang mga paratang laban sa pangalawang Pangulo. Tungkulin nating timbangin ang mga ebidensyang ihaharap at tiyakin ang ating magiging pasya ay nakabatay lamang sa batas at sa mga katotohanang mapatutunayan sa paglilitis. Ipagkakaloob ng saligang batas sa Senado ang natatanging kapangyarihang dinggin, litisin at pagpasyan ang lahat ng kaso ng impeachment. Kakibat ito ang pananugutang tiyakin na ang paglilitis ay isinasagawa ng may integridad, kaayusan at buong paggalang sa proseso. Sisiguraduhin natin na magiging maayos, bukas at madaling maunawaan ng ating mga kababayan ang prosesong ito. Pagkakaloban ang magkabilang panig, ang prosecution at ang depensa ng sapat at makatarungang pagkakataon upang magharap ng ebidensya, magsuri at magtanong sa mga testigo at mailahad ng buo ang kani-kanilang mga argumento. Sa ganitong paraan, may hiharap sa taong bayan ang malinaw na batayan upang maunawaan ang mga isyong nakapaloob sa Articles of Impeachment. Sa kasabayan ng paghahanap sa katotohanan, ang tungkulin natin tiyakin, iginagalang ang mga karapatan ng bawat panig, lalo na ang karapatan ng respondent vice president sa isang patas at makatarungan paglilitis. Due process and fair play must remain paramount at every stage of this trial. Let us be firm in the search for truth. Let us remain faithful to the rules of this court, the rule of law, and above all, the Constitution. Nakatutok ang buong sambayanan. Bawat kilos, salita, at pagpapasyang ating gagawin ay huhubog sa kasaysayan. At ang kasaysayan ang huling huhusga kung tayo ay kumilos ng tapat at nararapat. Nais kong bigyan ng katiyakan ng lahat, lalo na ang ating mga kababayan. Gagampanan ko ang aking tungkulin ng patas at may katapatan. Magalang kong hinihikayat ang bawat senator judge naway ito pa rin natin ang ating tungkulin ng may dangal at pananugatan sa ating konstitusyon upang maging karapat-dapat tayo sa tiwalang ipinagkaloob sa atin ng sambayanang Pilipino. Thank you, distinguished Senator Judges. Pursuant to Rule 2, Paragraph 2 of the Rules of Procedure on Impeachment Trials, as amended, we now proceed to the election of the presiding officer of the impeachment court. Senator Judge Panfilo Lacson is recognized for the election.
Point of order, Mr. Presiding Officer.
Yes, we recognize the gentleman from Taguig.
Thank you, Mr. President. Mr. President, Mr. Senate President and Presiding Officer, as the preamble of the Constitution said, imploring the aid of the Almighty God, and as you said yourself, that every stage of this impeachment, we have to make sure na patas, we have to make sure na may due process, we have to make sure that it is fair. It is very clear in the Constitution of the Philippines that the presiding officer is the Senate President. Section 3, Paragraph 6 of Article 11 of the 1987 Constitution, the Senate shall have the sole power to try and decide all cases of impeachment. When sitting for that purpose, the senator shall be on oath or affirmation. When the President of the Philippines is on trial, the Chief Justice of the Supreme Court shall preside, but shall not vote. No person shall be convicted without the concurrence of 2/3 of all the members of the Senate. I will go to that other 2/3 inquiry later on because this is another threshold issue, Mr. President. But to further the point of order with the indulgence of Senator Lacson so that we can discuss this intelligently. On the final question of whether impeachment, on the issue of who shall preside, under the Constitution, it may seem that it does not say who should preside. But if you look at the records of the Constitutional Commission, number 40, 26 July 1986, the framers deliberately chose the phrase, sorry, Mr. President. I am referring to Section 6, Article 11, and then Constitutional Commission number 41, 27 July 1986. The presiding officer, Mr. Treñas, Commissioner Davide is recognized. Thank you, Mr. Presiding Officer. I have some proposed amendments on Section 3, subparagraph 5. The presiding officer, Mr. Treñas, the gentleman may proceed. Mr. Davide, who later became Chief Justice, this is without prejudice to whatever amendments may be accepted by the committee when the Aquino amendments will be taken up. It would consist in adding a new sentence on line 20 before the phrase "no person shall be convicted," inserted the following: all other cases, the President of the Senate shall preside. The presiding officer, what does the committee say? Mr. Munsod, it is not understood, is it not understood that when the President of the Philippines is on trial, it is only time when the Chief Justice of the Supreme Court will preside? It is necessary to say that the Senate President shall decide during all the time. Presiding Officer, Mr. Davide, Mr. Presiding Officer, I precisely presented this because we had a distinction when it comes to the Chief Justice Supreme Court. But with that clarification, that in all other cases, it should be the President of the Senate who shall preside, I withdraw my amendment. So it is but elementary, Mr. President, in statutory, especially construction of the Constitution, that the spirit as well as the letter is followed. The spirit of the Constitution is that it is the Senate President who will preside. This is not an ordinary statement, dictum, or it was not a capricious statement in the discussion, precisely because the Senate President is elected by the majority. As an example, when Senator Pimentel did not like the vote and did not vote with the majority, he offered to resign. So the point, Mr. President, is this. Number one, institutional integrity. We need to protect the legitimacy of these proceedings. Even with the substitute presiding officer acts fairly, a conviction or acquittal reached under constitutionally defective process would invite judicial challenge and cast doubt on the validity of the entire trial. Do we want to go 30 weeks? If we follow the number of days submitted in the pre-trial, 62 and 30, and 3 days every week, so 30 weeks yon. Then after the 30 weeks, we'll end up in the Supreme Court kasi kune-question natin kung tama ba kung sinong nag-preside. Why is it important? Why can't any of the 24 preside? Remember, under our very rules, hindi ko nababasahin para mas umikli. In our very rules, the presiding officer can decide on the spot, or he can throw it to the body, or he can call a caucus or whatever you call it, to be able to decide. And we experienced that during the Corona trial. And that's one reason why everyone acclaimed the late Senate President Enrile, not only because of how he carried it himself, but how the consensus and how he carried it with the minority. Secondly, jurisdiction and regularity. The Senate's jurisdiction over an impeachment trial is constitutional. The exercise of jurisdiction must conform to the Constitution, and the Senate's validity adopted impeachment rules. We cannot say we're following the Constitution, then we will not follow the Constitution. If the Constitution and its framers prescribe who shall preside, who are we to change the Constitution here today? We cannot enlarge or diminish the Constitution arrangement through internal rules or through ad hoc resolution. Lastly, due process. Kailangan malinaw po sa lahat ng partido, both to the prosecution and the defense, kung ano yung korte, kung ano ang two-thirds, kung ano ang charges, kung sino magpre-preside. So kung now during the first day we're going to change who's going to preside, and it's against the Constitution, what more changes are we going to do in the next few days? Ano ang limit ng pwede natin palitan sa Constitution at hindi? The authority must come from the Constitution or the governing law, not from the vote of a tribunal. A litigant is entitled to have the case heard by the decision maker, designation by law. The law cannot say that ang mag-hear kay Senator Marcoleta ay Sandigan Bayan, tapos sa Court of Appeals natin siya dadalhin. Hindi pwedeng sabihin sa RTC dapat i-hearing si Juan de la Cruz, tapos sa Sandigan Bayan natin dadalhin. Hindi pwedeng sabihin tatlo sila sa CA, pero in this case, nagbotohan kami, isa lang kaming mag-hearing. Proceedings before a judge or hearing officer who lacks the legal authority are invalid regardless of fairness of the proceedings. A judgment rendered by court without jurisdiction is null and void and may be attacked anytime. It creates no right and produces no effect. It remains basic fact that in law, the choice of the proper forum is crucial, as the decision of a court or tribunal without jurisdiction is a total nullity. A void judgment for want of jurisdiction is no judgment at all. All performed pursuant to it and claims emanating from it have no legal effect. Tan versus Cinco, GR number 213054, June 15, 2016. Penned by Justice Perlas Benabe, First Division. The constitutional authority, Mr. President, is very clear. Now, let's put that aside for a moment. But we're not allowed to do that. But for a moment, let's put that aside, that the Constitution is not clear and does not tell us what to do. The rules of the Senate says that any amendment should be presented a day before. And that's why the then minority, when I was Senate President, walked out, because your contention was, when we gave it to the Committee on Rules, kahit mahigit isang araw na at binabalik ng rules, we did not follow the rules. So on the rump session or alleged rump session on June 3, first of all, you did not have a quorum of 13. But let's assume for the sake of argument, I'm not giving you that point. As far as I'm concerned, it's in the Supreme Court, walang quorum on 12. Assuming my quorum on 12, you did not follow the rules. There was not a one-day notice for the rules. And then if you look at the records, this impeachment court adopted the rules on May 18. So that means that it is this impeachment court that now has to adopt any amendment to the rules. We did not debate that amendment to the rule. We cannot now just change the rules. We're here for the opening statements. We're here for the trial. Are we here to change the rules? We're changing the rules here today, Mr. President. So, Mr. President, later on I'll ask permission to talk about yung two-thirds because both the issue of the presiding officer and the issue of what constitutes two-thirds of all members is a threshold issue. Para maintindihan na lang po ng lahat, lalo po sa mga kababayan natin na nanonood, Merriam-Webster, simple definition, a threshold issue is a preliminary question, minimum requirement, or foundation condition that must be met or resolved before proceeding to the substantive merits of a case, project, or process. In this initial criteria, if this initial criteria is not satisfied, further action is typically dismissed or halted. I want to avoid that this impeachment trial will be declared null and void. I want to avoid walkouts. I want to avoid any delays, Mr. President. The Senate President is more than capable. He said he is willing. He said he is ready. He has been in many situations in his life that people say you cannot do it, but he has done well. He has studied. So what is the issue? Why do we have to vote for a presiding officer, Mr. President? Why can't we follow the Constitution? So the point of order, Mr. President, is that amending the rules, implementing a null and void rule, and violating the Constitution will endanger this whole hearing, Mr. President. So please rule on the point of order, and I hope that the Senate President, who is more than able, will preside.
Thank you to the gentleman from Taguig. Before I express my views on the matter, let me just put into the record the facts on when we amended Rule 2 of the Rules of Procedure on the impeachment trials. On June 3, 2026, Senator Juan Miguel Zubiri proposed Senate Resolution number 430, and that was adopted during that time. And then, on the same day, the same resolution was adopted and renumbered to Resolution number 40. It was published on June 9, 2026 in the Philippine Daily Inquirer as well as Malaya. During that time, in June 3, when we amended the rules, everyone had the opportunity to express their views regarding the proposed resolution. And since no one objected, we adopted Resolution number 430 and renumbered it to Resolution number 40. That is anchored on our Constitution, Article 6, Section 3, Paragraph 8 of the Constitution, that the Congress shall promulgate its rules on impeachment to effectively carry out the purpose of this section. So my view to the good gentleman, let me just finish, sir. My view is this resolution has been duly approved, and everyone was given an opportunity to discuss that, to object. However, it was no one objected to that resolution, and it was duly approved by the body. So any discussion regarding this resolution should be discussed in plenary when the Senate convenes as a legislative body. In the past precedents, during the ERAP impeachment, November 15, 2020, the body as well approved the rules of impeachment in plenary. During the Corona impeachment, March 23, 2011, Once again, resolution number 39 was adopted in plenary. So any issues pertaining to this resolution should be discussed in plenary when the Senate convenes as a legislative body. So that is the position of the chair and the view of the chair on this matter.
Sir President, first, may I dispute that you used the word fact. It is not a fact that the rules were changed because it is being disputed that first, there was no quorum at that day. Second, if we are going to amend the rules of impeachment for the impeachment trial in plenary under the rules of the Senate, Section 136, second paragraph says, the rules may be amended by means of a motion that should be presented at least 1 day before its consideration. It was not presented on June 2. So we did not follow our rules. So a rule that was passed that did not follow our rules, or amendment that was passed that did not follow our rules, is void. You cannot get anything out of it. It is a nullity. So if today we pass a change in our rules and we do not follow our own rules in changing that rules, we cannot follow that rules. Secondly, Mr. President, the impeachment court already adopted our rules. Iba po ang plenary, tama po kayo doon, I agree with you there. Iba po yung impeachment court. So is the impeachment court now hostage or subject to whatever changes the legislative body does and we will not adopt? Then why did we adopt the rules when we took our oath? We adopted it because the impeachment court is not powerless to talk about our rules. But finally, Mr. President, for the sake of argument, just for the sake of argument, wag na natin tignan yung mga amendments. It's against the Constitution. So can the impeachment court disobey the Constitution? If the Constitution says the presiding officer should be the Senate President, can we now say na no, pagbotohan natin kung sino? Because if we say that we can, what next? Will we add to the articles of impeachment? Will we lower the bar of the quantum of evidence needed? Will we say that baliwala na yung pre-trial brief at bahala na si Batman? So, Mr. President, I thought that's why we have the rules. Because when we have the rules, it dictates fair play. And the rule says it is the Senate President who will preside. So if now we're not going to follow the rules, anong pinag-uusapan natin patas? Anong pinag-uusapan natin due process? Anong pinag-uusapan natin na fairness? It is who we chose as Senate President is a political. So we made our case doon na we would have a more fair. You made your case, you got the majority. Now you got the majority, we will give you all the support, Mr. President. But we have to follow the Constitution. We cannot have a trial where we do not follow the Constitution, Mr. President. I think pinaka-basic po yun. Saan sa Constitution po nakalagay, Mr. President, that ang nakalagay dito po, only in case the President. Let me give you a hypothetical. God forbid, God forbid. God forbid may mangyari sa Pangulong Marcos. Maging Pangulo ngayon po, si Sara Duterte. My view is tuloy yung impeachment. Pero, ang magpre-preside na yung Chief Justice. O pwede ba tayo magbotohan na wag yung Chief Justice ang wag yung Chief Justice ang mag-preside? So how is it possible that today, we're starting out on the wrong foot by arguing who will preside when the Constitution already settled it, Mr. President? So I appeal to my colleagues. There are a lot of accommodations, there are a lot of things, may bigayan talaga dito. May botohan, may caucus, may in-camera discussions. Pero pagdating kung sino magpre-preside na malinaw sa konstitusyon, wag na natin pag-awayan yon. The prosecution is here. I think they're ready. The defense is here. I think they're ready. Let's give the Filipino people, a fair trial. Hindi po fair kung pipiliin natin kung sino ang kahit sinong magaling, kahit ako piliin nyo. Hindi ko po tatanggapin yon kasi mali po yon. Hindi po yun ang nakalagay sa Constitution natin. Very, very clear po sa records ng Constitutional Commission. Walang makaka-amend doon. We are not given any latitude on this matter, Mr. President. I appeal to you, Mr. President. This is your Senate presidency.
Thank you. Thank you for that, those views to the good gentleman from Taguig. Kanina po, nabanggit ko ho na in my manifestation as the Senate President, that Resolution number 39 or the Rules of Procedure on Impeachment Trial as amended shall continue to apply. So in other words po, rin-recognize ho nitong impeachment court yung amendments na ginawa ho natin noong June 3. At kagaya ho ng nasabi ko kanina, the humble view of this presiding officer is if there are any discussion on resolution number 43 as adopted as resolution number 40, it should be done in plenary. Because doon ho natin in-amend yung at doon ho natin in-adopt yung impeachment rules of impeachment, doon rin ho natin inamendahan. At nabigyan naman po ng oportunidad ang bawat isa para magkomento, magbigay ng pahayag, magbigay ho ng kanilang legal opinion. Pero at that time, wala naman po ang nag-object at inadapt po ng Senado in a legislative body. So the position of the chair, if there are any comments, any legal opinions, any issues, it should be done through the legislative body of the Senate.
Mr. President, there is no conflict, Mr. President. With your permission, Mr. President. There's no conflict. If you want to discuss it, in 3 weeks may session na tayo. So all we have to do today is follow the Constitution. You preside. Then pagdating ng plenary, then we can debate whether we are allowed to amend the Constitution or not. Because, Mr. President, that's why I premise this not as a parliamentary inquiry or as a point of information or whatever we may call it. That's why it's a point of order. A higher point of order than the point of order in the rules is a point of order in the Constitution. The Constitution says it is the Senate President who will preside. So are we saying now, Mr. President, that the rules can amend the Constitution? Is that the ruling of the chair?
Before I make my final ruling on this matter, may I recognize the gentleman from Pampanga, Senator Kiko Pangilinan.
Thank you, Senate President. Mr. President, with all due respect, the Constitution does not provide that the Senate President must preside in cases of impeachment trial. What the Constitution provides is that when the President is undergoing impeachment, going through the trial, is being tried, the Chief Justice must preside. Nowhere in the Constitution, in the provisions on public accountability and impeachment, does it say that the Senate President must preside when the Vice President is under trial or any other impeachable officer. And precisely because of this, and precisely because the Constitution likewise allows Congress, not the impeachment court, Congress, to promulgate its own rules, which is what the Senate did in June 3. We proposed amendments to the rules under our rulemaking power, which, by the way, was subsequently ratified when we convened in a special session on June 17. The June 3 journal was ratified unanimously on June 17 when we had our special session. And in the June 3 minutes and the journal, precisely, we approved the amendments to the rules. This was further ratified on June 17. Therefore, it is considered regular. The presumption of regularity now comes into force. But having said that, Mr. President, the good gentleman from Taguig has brought this matter before the Supreme Court. And we agree with the point earlier raised by the Senate President. This matter should be either discussed in the Senate in plenary as a legislative body, or if he has questions which may in fact turn out to be valid, he has brought this matter before the Supreme Court. And therefore, this impeachment court is not the venue for this debate, Mr. President. If there is anyone who is out of order, with due respect, I think the proper process is the matter is pending before the Supreme Court. There is no temporary restraining order. There was a request for a status quo ante order. It was not granted. And therefore, the presumption of regularity behooves us as an impeachment court to proceed. And finally, Mr. President, allow me to reiterate, the point of order is improper. In fact, the debate on this matter here in the impeachment court is out of order, Mr. President.
Sir
For the record.
President.
So,
Sir President,
so
before you decide, Mr. President.
the chair has already
Sir
ruled.
President, before you rule,
That the chair has
Senator
already
Plea wants
ruled.
to ask for the floor.
Just
And
2 minutes.
And may I respond to
May I-
Senator
Well,
Pangilinan?
allow the gentleman from Taguig to rebut for 2 minutes, and then we will make the final
Yes.
ruling.
Before I rebut, I'm from Ateneo Law School. And what they taught us there is that pro claro. But let's call someone from UP Law to see whether they were taught the same thing, Senator Pia. May I ask that Senator Pia be
We
recognized
recognize the
before I get my
gentlelady
2
from
minutes?
Taguig, Senator Pia Cayetano.
Thank you, Mr. President. It's not an Ateneo UP issue, but always happy to stand before our colleagues and share our experience in the UP College of Law. I was prepared to address this to all our members of the bar in the Senate, but since it is Senator Kiko, my schoolmate, my teammate actually in the UP volleyball varsity team who stood up, I'll also specifically address it to Senator Kiko. So dear Senator Kiko and our colleagues in the majority, knowing that you have members in the majority that are lawyers, and for those who are not lawyers, you definitely have consultants who are lawyers. Wala naman siguro ni isang senador dito na walang consultant na abogado. Kahit ako abogado, ang dami ko hong staff na abogado din. Why? Because these are legal issues. We need to talk to the experts. Kung pag-uusapan natin ng mental health, physical health ng Vice President, then of course we will not listen to lawyers. We will listen to doctors, di ba? So this is a legal issue. Let's hear what the lawyers have to say. But let me just quote, because I know the Senate President doesn't have time to call on all the lawyers. So if you ask your lawyers in your staff, I'm sure nag-abala sila to look at the constitutional records, to look at the journal. I'm sure. And if they did not, please take your cell phone now and text your staff. What does the constitutional journal, the records of the debate show? Sinabi na po ni Senator Alan Cayetano, you can question him, you can doubt him, ask your staff. May I ask you, dear colleagues, let's do our job well. The same way when you stand up and you tell me to do my job well and you disagree, I disagree with your point of view, I will listen intently to your point of view. And I'm looking at each one of you because this is our solemn duty. What does the Constitution say? Nakalagay doon, the Chief Justice, pag the President. Silent nga po sa iba. So sabi ng iba, at yan ang sinasabi ng Senate President natin na mukhang pwedeng iba. So we looked at what the constitutional framers said. What did they say? Nagdebate na po sila, colleagues. Nagdidebate tayo dito. Pag sinabi ng sponsor, ito na yung paliwanag, yung nag-i-interpolate at nagbibigay ng amendment, sinasabi niya, okay, yung pala paliwanag mo, okay na ako. No need to amend. Yun at yun din ang sinabi. Let's place ourselves in that position. Because that happens to us every day. Every day, somebody stands up and says, ano ibig sabihin nito? And the sponsor will explain. Pag hindi maliwanag, sasabihin nung nag-i-interpolate or nag-a-amend, ay papa-amend ko kasi hindi maliwanag or I want to improve it. Pero kung nagkaintindihan naman, okay na. Eh yun nga yung binasa, tanungin nyo naman po yung staff nyo. Or let's pause, let's all get a copy. Let's show it. Because this is the foundation of this trial na tama yung nakaupong presiding officer. So that's my first point. Mag-abala naman tayo. Read it yourself, ask your staff to print a copy. In fact, on that note, may I ask Senator Allen's staff to print a copy and give it to all our colleagues. Mabilis lang yan, hindi na yan mapapatagalan. Show it. We can take judicial notice naman po siguro of it. Siguro naman, alam na natin ang ibig sabihin ng judicial notice. You can go to the actual records. Nandito na makakuha naman natin yun kung pagdududahan nyo yung ipapaprint ko. So that's my first point. My second point, Mr. President, is addressed to His Honor. If His Honor will insist that we have to call a regular session, we have to be in session to amend the impeachment rules, di tawagan niyo po ang Malacanang. Nagpa-special session naman po siya, di ba, with all due respect, to pass the National Orchid Law. To pass, what else? Ano, tatlo yun eh. Oo nga, yun nga, yung waling-waling as National Orchid, ano pa yung dalawa? No, I know, I'm not questioning it. I'm saying that there was a special session called to pass 3 laws. Naalala ko yung waling-waling because I love it. This is important. O ano pa yung dalawa? Unfortunately, hindi ko na maalala. Dalawang naturalization. Sports-minded po tayo. Love po natin yun. Nagkaroon ba ng laban between now and July para mag-special session tayo para doon? Hindi ko alam. But in any case, ito importante to, di ba? Di kung pa-i-insist nyo na yung impeachment amendment na yan kailangan gawin ng special session, mapapatawag tayo ng special session. Mukha namang very supportive naman ang Malacanang sa majority. Di ho ba? Pero I take the position that we are in impeachment court. We are already in impeachment court. Therefore, the amendments must happen here. Medyo common sense din naman po yan. I rest my case. Yun lang po. But as soon as the copies come, I will give it to you. Colleagues, look at it. Huwag tayong majority-minority botohan. Ayusin natin yung pagboboto natin dahil pinapanood tayo, pinapaniwalaan tayo, umaasa sa atin ang taong bayan. Maraming salamat po.
Once again, it is, again, before the chair rules, let me acknowledge a former Senate President, Senator Tito Soto.
Thank you, Mr. President. Tama-tama yung sinabi ng distinguished lady from Taguig. Tanungin daw yung mga legal staff. Binigay nga sa akin ng legal staff ko, eksakto ganito eh. Article 11, Section 6, page 154. Constitution is silent regarding presiding officer of Senate impeachment. However, the Constitution expressly provides that the Chief Justice will preside if President is on trial. O ngayon, yung mga graduate ng Ateneo at saka ng mga UP, ito ngayon yung legal maxim. Expressio unius et exclusio alterius. In other words, the express mention of one thing is the exclusion of another. Palagay ko, naintindihan nyo lahat ganyan. Itong akin, sa publiko yung sa akin. Ang sinasabi ng publiko ngayon, nanonood sa atin, dapat you should not resort in too much technicalities kasi ang public interest ang iniisip nila rito. They want to expedite the proceedings. They want the trial, not rules. They're interested in the trial, not rules. In the interest of justice, sabi nga nila, sometimes rules are not sacrosanct. But itong nangyayari ngayon dito, ang publiko ang importante rito. Where does the Constitution emanate from? From the public. From the people of the Republic. So, desisyonan nyo na to, Mr. President, para matapos na.
Sir President, can I have my 2 minutes?
Once again, let me reiterate the position of the chair. My humble position is that this matter should be discussed during plenary when the Senate is convened as a legislative body. And may I ask the gentleman from Taguig if he is objecting to this position?
Yes. I'm objecting that position and will call for a vote. May I explain? I think under the rules, I can explain why I'm asking
We'll
for a
call
vote.
for a vote first. And
Mr.
then
President,
we'll allow...
Mr. President, under the rules, I can explain why I'm calling for a vote first so that I can convince them to vote for me.
No, under the rules,
When you object,
there's
Mr.
an objection. The vote will proceed without any explanation.
President,
and after that,
under the
we will
rules-
allow the gentleman from Taguig to explain his vote.
Mr. President,
So we call for
Mr.
a
President,
division of the
President.
House. So those who are
Mr. President, when you
Wait,
object, you're
those-
allowed to explain your
Senator-
objection and state
Senator
your
Lacson
objection.
is recognized.
Thank you. Your Honors, pursuant to Rule 2 of the Rules of Procedures on Impeachment Trials, as amended, I move to elect Senator Judge Francis Joseph Guevara Escudero as the presiding officer of this impeachment court.
Objection, Mr. President, and may I allow to...
We proceed
Objection,
to...
Mr. President, I'm allowed to object and I'm allowed to
Yes,
explain
you're
my
allowed to
objection.
object. You're allowed to object, but we will
No,
proceed
Mr.
with
President.
the division
Mr.
of the
President,
House.
point of
So
order.
those who are,
Point of order,
those
Mr.
who are in
President.
favor of the
Mr.
motion
President,
of Senator
you're allowed to
Lacson,
explain para
please-
ma-convince mo nga
please
yung
raise
iba.
your hand. We will vote by raising of hands. So those who are in favor of the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand. The clerk of court is directed to count the votes.
No, in our rules parliamentary procedure.
How many? How many?
Explain my vote, Mr. President.
Hold on. Allow the chair to make a ruling. Those who are against to the motion of Senator Lacson electing Senator Chis Escudero as the presiding officer, please raise your hand. Ilan? The official count is 12 in favor, 8 against. The majority, those who are in favor, has it.
Mr. President,
The
may I
court
explain?
resolves to elect Senator Chis Escudero as presiding officer of the impeachment court. The duly elected presiding officer shall, under the same oath taken on May 18, 2026, immediately assume and exercise all powers, functions, duties, and prerogatives pertaining to or vested in a person presiding over the impeachment trial under the rules of procedure on impeachment trials, as amended, and shall give full effect to the powers inherent to the courts under Rule 135, Section 5 of the Rules of the Court.
Mr. President, may I now explain my vote?
You're allowed to explain your vote. You
Mr.
have 2
President,
minutes.
first of all, we cannot violate the Constitution. We put the whole impeachment trial at risk here. What Senator Tito Soto, former Senate President, what his staff did not tell him is that there is such a thing as procedural due process, and that who presides goes into due process and fairness. The Latin term that he mentioned was for enumerations. That when there are enumerations at hindi kasali doon, in this case, there was a statement that in only one case it would be the Chief Justice, because member of the Constitutional Commission who became Chief Justice Davide was going to amend precisely the Constitution to state the Senate President shall preside. But upon explanation by the sponsor that it is understood that it is the Senate President, then it should be the Senate President. And dun sa sinabi ni Senate President Soto that ang gusto ng tao ay mag-umpisa na, precisely, kanina pa dapat tayo nag-umpisa kung nag-preside ang Senate President. Secondly, this is when you have threshold issues, issues that go into due process fairness. If we're going to say that ang gusto ng tao i-convict na lang, then let's just blurt it out. Now, if we're going to say we want a fair trial, let's make sure that every aspect of this trial is fair. So that's why, Mr. President, if you read the rules, the presiding officer shall have the power to make and issue by himself or by the Secretary of the Senate all orders, mandates, writs authorized by these rules of the Senate, and make and enforce such other regulations, orders, premises that the Senate may authorize or provide. Nandito din, Mr. President, that the Senate President may by himself or bottom line, Mr. President, pwedeng mag-decide ang Senate President o sa atin. And Mr. President, there are issues that goes into fairness. You know, the AMLA will be a witness here. And I have information that the 20 years AMLA records of Senator Escudero and his credit cards and bank accounts were all opened up in the office of the Senate President, where members of the Blue Ribbon Committee was here. Then we're going to ask him to preside. So there's a problem with, this is my explanation. This is my explanation. This is my explanation.
To the gentleman
This is
from Taguig.
factual and this is my explanation. So I will stop there.
With all due respect, your statement's already out of order. It has nothing to do with the topic on hand.
No, Mr.
And
President.
the presiding officer will strike off.
It has
the-
all to do with this.
will strike off
It has all to do.
The
I do not,
statements
Mr. President,
pertaining to Senator
Mr.
Escudero.
President, kaibigan ko si
I
Senator
direct the
Escudero.
stenographers to
I
strike
don't
off
doubt
these
him.
statements.
He is the victim here. I'm not doubting him. I'm not doubting he will be fair. I am saying,
we will,
do we want
will
a fair
suspend
trial
the
or not,
session
Mr.
for a few
President?
minutes to request the presiding officer, Senator Chis Escudero, to ascend the rostrum. Session
Mr.
suspended.
President. Mr. President.
What is the pleasure of Senator Judge Cayetano?
Mr. President, I'm explaining my vote.
The lady has 2 minutes.
Thank you. Dear colleagues, my explanation includes a reminder to all of you na kung di nyo kasundo si Alan, malamang kasundo nyo ako. So, if sarado ang pag-iisip nyo na si Alan nagpaliwanag, ako naman ang magpapaliwanag. Pagbigyan nyo naman ako. But what I'm saying is not new from what Senator Alan Cayetano expressed. And I have here copies of the constitutional verbatim debate on this provision. And as Senator Alan read, sinabi ni Mr. Monsod, is it not understood that when the President of the Philippines is on trial, it is the only time when the Chief Justice of the Supreme Court will preside? Is it necessary to say that the Senate President will preside during all other times? Ulitin ko yung tanong, kasi yun ang tanong natin today. Is it necessary to say in the Constitution that the Senate President will preside during all other times? Ang sagot ni Mr. Davide, Mr. Presiding Officer, I precisely presented that because we have a distinction when it comes to the Chief Justice of the Supreme Court. But with that clarification, that in all other cases, it would be the President of the Senate who will preside, I withdraw the amendment. Kaya clear sa Constitution that in all other cases, the President of the Senate will decide. Wala, hindi ho applicable dito yung excluso unos. Hindi ko na-memorize yan kasi I graduated in 1991 and we took that up in 1987, but the phrase is, pag hindi kasama, excluded. Hindi po applicable yon. With all due respect to our former Senate President, it is the intention of the framers that matter. I will ask the page to help me distribute this among our colleagues. I have also asked our staff to actually copy. I am environmentally friendly, so ayoko sana ng papel. Pero alam ko na hindi po lahat sa atin gumagamit ng digital, ng electronic gadgets, kaya pinapel ko na lang. Pero kailangan ko pakita sa inyo yung mismong nasa journal, yan din yon. Yan din yon, my dear colleagues. Yun lang hiling ko sa inyo, intindihan naman natin yung nandito. Bumoto na. Pero intindihan naman natin kasi this is just the first day. We cannot disregard the Constitution, and I continue, Mr. President. we have enough jurisprudence, more than enough, to explain to us, even in layman's term, what basic legal principles are. And one of the most fundamental principle of constitutional construction states that we give effect to the intents of the framers of the Constitution. With this vote, did we give effect to the intentions of the framers of the Constitution? Sinabi nga Senate President ang magpe-preside. Hindi na siguro napakalaking bagay yon dahil kahit sinong ipalit nyo, maayos naman ang mga kasama natin sa colleagues. Sa colleagues natin, maayos naman. Di ho yun ang point. The point is, what are we required to follow? That's why may Constitution. And I will now state for the record a few cases that point out that this is what we are supposed to do. Give effect to the Constitution. Lambino versus Commission on Election in GR number 174153, the Supreme Court looked explicitly to the Constitutional Commission deliberation to determine the nature of people's initiative. Because the text was debated, the court used the framers' explicit intention. I repeat, the court used the framers' explicit intention revealed in the plenary debates to prevent deceptive or misleading petition processes and establish a stringent full text requirement. So anong ginawa sa kaso? Tiningnan ang intent ng framers of the Constitution. Another case, Calderon versus Carale, GR number 9163. God bless his soul. Si Dean Carale was my dean. And Senator Imis as well. Senator Kikos as well. He was with my father in the University of Michigan. So, pagbigyan niyo na ako a moment of remembering him. In GR number 91636, the court resolved a dispute regarding the President's power to make appointments without confirmation by the Commission appointment. The court examined the historical and textual context of Article 7, Section 16 of the 1987 Constitution, noting that the clear and express intent of its framers was to exclude presidential appointments from confirmation except for those expressly mentioned. So, balik ko sa kasong to. What was the clear intention? That the Senate President presides. That is the clear intention. Dear colleagues, umpisa pa lang. I beg all of you, makinig naman tayo. Masumunod naman tayo kung ano yung sinasabing trabaho natin. The Constitution, the intention of the framers, and then the clear construct. O, another case. Gold Creek Mining Corporation versus Rodriguez. This is a very old case. So yung mga binanggit sa inyo, bago-bago pa yun dahil si Dean Carale, buhay pa naman as of the pandemic. So 2,000 plus. Ito, 66 Philippines, 259. So for lawyers and law students, pag sinabing Philippines, pag yan yung ni-record, alam mo ng 50s, 1940s, something like that. Justice Jose Abad Santos articulated the definitive rule. The fundamental principle of construction is to give effect to the intent of the framers of the organic law and of the people adopting it. Dear colleagues, I can stand here and read more cases to all of us. We have law students. We have freshmen law students, we have fresh graduate, we have bar reviewees listening to us. Tapos tayo pa lang, hindi natin mabigyan pahalaga ang very clear legal principles. Pati yung prosecution and defense nakikinig. Sana po, huwag niyong abalahin yung oras namin. Bigyan niyo naman kami ng maliwanag na mga arguments ninyo because we are willing to listen. Pero colleagues, patunayan naman natin that we are willing to listen. Hindi yung pagpasok natin, nag-prejudge na tayo. Kasi sad to say, mukhang ganon. I tell you, there will be times I probably will not vote with the minority because I believe tama yung sinasabi ng majority. Sana po, yun ang pakita natin sa taong bayan. So, hindi ko na abalahin yung time dahil kakaupo pa lang ng bagong presiding officer, pero ang dami pang kaso that says, look at the intent of the framers of the Constitution. And today, we disregarded the intent of the framers of the Constitution. Magandang hapon po, gaya ng pag-uumpisa ng hearing na ito.
We know the remarks of Senator Plea in connection with their explanation of vote. What is the pleasure of Senator Judge Soto?
I'd like to explain my vote also, Mr.
The
President.
gentleman may proceed and he has 2 minutes.
I have
Kindly
one
be
line.
mindful of the timer.
I have one line to say. That's the reason I voted in favor. Because the minutes of the Constitutional Commission are merely research source.
What is the pleasure of the Honorable Padilla?
Ginoong,
Will the gentleman explain his vote?
opo.
The gentleman may proceed. You have 2 minutes, sir.
Maraming salamat po, Ginoong punong tagapamahala. Mga mahal kong kasama, sa loob po ng 4 na taon na ako po ay ibinoto ng ating mga kababayan at nagsilbing senador, ako po ay naging tagapangulo ng komite ng Constitutional Amendments. At tuwing meron pong pagdinig, ang lagi po naming pinapatawag ay yung mga sumulat ng konstitusyon. Bilang sila po ang nakakaalam kung ano ang puso, ang diwa ng konstitusyon. Malinaw po na kung meron tayong pakikinggan, ay yung creator. Hindi po ba? Tayo naman po lahat ay naniniwala sa Panginoong Diyos, kaya tayo po ay naniniwala sa salitang creator, tagapaglikha. At ang lumikha po ng konstitusyon ay itong mga taong nabanggit sa ipinamahagi ng ating mahal na Senadora Cayetano. Malinaw po dito. Nasabi na po sa English ito. Mainam po ay sabihin po natin sa Tagalog upang mas maintindihan po ng ating mga kababayan. Humingi po ako ng tulong sa Google kasi legal terms po ito. Hindi naman po ako nagtapos sa UP, hindi rin po ako nagtapos sa Ateneo, nagtapos po ako ng criminology at UP rin sa University of Prison. Ang sabi po dito, sa Tagalog po Ginoong Presiding Officer, eksakto ko itong hinihain dahil nagkaroon tayo ng pagkakaiba pagdating sa punong maestrado ng Korte Suprema. Ngunit sa paglilinaw na iyon, na sa lahat ng ibang mga kaso ay ang Pangulo ng Senado ang mamumuno. Kaya binabawi ko ang nasabing susug. Ang nagsabi po nito ay ang dating Justice Davide. Ngayon, mga mahal kong kasama, at sa ating po mga taga-subaybay, ang batas po ay precise. Hindi po ito pwedeng iba-ibahin o baluktutin. Kung ano ang sinabi lalo ng saligang batas, ay sana po ay panghawakan natin. Ngayon, sa loob po ng 4 na taong ko dito, lagi pong sinasabi yung tradisyon. Minsan, yung rules na yan, nawawala yan Ilang beses na ho ako naguluhan dito dahil, teka, sundin natin yung tradisyon kaysa yung rules. 2 beses na po nagkaroon ng impeachment. Yung unang impeachment, ang nag-preside ay yung Chief Justice, yung kay Pangulong Estrada. Yung sumunod po, nandito na po ako nun. Ang nag-preside ay ang mahal na Bicolanong kaibigan ko, Senador Chis Escudero. Yun po kasi yung nasasabi sa saligang batas at tradisyon. Yun na po yung nangyari. Ngayon, gusto ko pong tanungin yung mga kasama ko sa majority. Personal na tanong po ito. Nung hinihikayat po akong sumama sa majority, isa lang ang sinabi ko. Kung si Senator Chis Escudero ang kababayan kong Bicolano ang gagawin yung Senate President, lilipat ako sa inyo. Ang hindi ko maintindihan, bakit ngayon pinipilit natin ng ating presiding officer, si Chis Escudero. Ba't hindi natin siya ginawang Senate President nun? Yun lang po ang tanong ko. Maraming salamat.
The remarks of the gentleman is noted. Senator Marcos, what is your pleasure, ma'am? The lady may do so. You have 2 minutes, ma'am. Kindly be mindful of the clock.
Yes, thank you very much. Ang sabi sa atin ng bata tayo, kapag mali ang umpisa, mali na ang lahat na susunod. Ayoko naman magkamali sa umpisa pa lamang na napakahalagang paglilitis na ito. Unang-una, paulit-ulit na nating sinaad na ang ating saligang batas ay hindi maaring baluktutin. At napakaklaro nito. At ang sinasabi ng ating Constitution of 1987, Article 11, Section 3, Number 6, all other impeachable officers ang sinasabi, carving out therefore the exception that proves that rule, that the Chief Justice is the single exemption, and otherwise the presiding officer should be the Senate President. It is the exception that proves the rule. Palibasa na uso ang Latin, may kabaliktaran din sa kinote ni Senator Soto, expressio unius est exclusio alterius. Palibhasa, hindi naman in-exempt, ibig sabihin na laging dapat ang Senate President ang presiding officer. Ikalawa, nakita naman natin ang mga debate, ang listahan ng mga sinabi at paliwanag nung dating Chief Justice natin, si Mr. Davide, nung panahon, nung convention. Contextual reading and the thorough debate do not allow for any interpretation whatsoever. And we should abide by that. Ikatlo, yung kaduda-dudang quorum nung June 3 na pinapaliwanag ng aming minority leader na hanggang ngayon nakatenga pa rin. Kung tutuusin, nung sinasabing na amyenda, yung Supreme Court petition ay pending pa. Kaya hindi karapat-dapat na yon ang sundan. Ikalima, it's not the impeachment court but the Senate that amended the rules. Kaya para sa akin, napakaraming dahilan. Huwag sana nating sayangin itong napakahalagang responsibilidad natin at huwag mag-umpisa sa mali itong paglilitis. Maraming salamat.
Thank you, Senator Marcos. Duly noted and entered into the records. The pleasure of Senator Legarda. Senator Judge Legarda, rather.
Thank you, Mr. Presiding Officer. Where the Constitution is
The
silent,
lady will explain her vote or make a manifestation.
it's a manifestation, which,
The lady may proceed with
which
her
seems like
manifestation.
an
She has 2
explanation of
minutes.
vote. Thank you. Where the Constitution is silent, the intent of the framers should guide the choice of the presiding officer. Any departure from the traditional arrangement must be approached with caution, as it may place the validity and the legitimacy of the entire impeachment in doubt. Mr. Presiding Officer, I also respectfully place on record that there is a pending challenge before the Supreme Court involving the June 3rd Senate proceedings, including the authority of the body then that adopted Senate Resolution number 430. This manifestation is made to place on record that we are not yielding our position in the pending case and is without prejudice to the final determination of the Supreme Court. Thank you, Mr. Presiding Officer.
Thank you, Senator Legarda. The presiding officer would like to make a statement. Sa mga ginagalaan kong kapwa Senator Judge, sa ating mga minamahal na kababayan, sa mga partido sa kaso na kabinbin ngayon sa Senado, isa pong maganda at pinagpalang hapon sa ating lahat. Sa araw na ito, muling gagampanan ng Senado ang isa sa mga pinakasagradong tungkuling iniatas ng saligang batas, ang pag-upo natin bilang isang impeachment court para litisin at husgahan ang pangalawang Pangulo. Kinikilala ng ating saligang batas na may mga opisyal na may hawak ng kapangyarihan at pananagutan na napakabigat para sa kanila lamang itinakda ang impeachment bilang tanging paraan para sila ay panagutin. Article 11, Section 2 of the Constitution enumerates these officials: the President, the Vice President, the members of the Supreme Court, members of the Constitutional Commissions, and the Ombudsman. They are not ordinary public officers. According to the late former Senate President Juan Ponce Enrile, they hold, quote, the highest and most sensitive offices of government. They may be removed from office only upon conviction for offenses of the highest constitutional gravity: culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of the public trust. Impeachment is a means to preserve constitutional government through the removal and disqualification, if so warranted, of an unfit official from a position of public trust. 5 opisyal pa lamang ang na-impeach ng Kamara de Representantes sa ating kasaysayan sa ilalim ng 1987 Constitution. Una, si dating Pangulong Joseph Estrada noong 2001 na ang paglilitis ay naungusan ng mga pangyayaring humantong sa EDSA 2. Ikalawa, si Ombudsman Mercy Gutierrez noong 2011 na nagbitiw bago pa man mabuksan ang kanyang paglilitis ng Senado. Ikatlo, si Chief Justice Renato Corona noong 2011 din na nilitis na patunayang nagkasala at inalis sa tungkulin ng impeachment court bilang punong mahistrado. Ikaapat, si dating COMELEC Chairman Andres Bautista noong 2017 bagamat nagbitiw siya sa pwesto bago pa man mapadala ang articles of impeachment sa Senado. At ikalima, si Vice President Sara Duterte noong 2025. Subalit ang nasabing articles of impeachment ay idineklara ng Korte Supremang null and void ab initio kung kaya't ito ay inarchive ng Senado. Siya ay muling na-impeach sa kasalukuyang taon at ngayon nahaharap sa paglilitis na ito. Ipinakikita lamang na maikling talaan ito na ang impeachment ay hindi isang pangkaraniwang kaganapan. Turing nga ng Korte Suprema, quote, it is the most difficult and cumbersome mode of removing a public officer from office. Subalit, ang paglilitis na ito ay hindi lamang hindi pangkaraniwan. Ito ay tunay na bukod tangi. Bakit? Una, si Vice Presidente Sara Duterte ang kauna-unahang opisyal na 2 beses na na-impeach ng mababang kapulungan. Pangalawa, siya ang kauna-unahang Vice Presidente na haharap sa paglilitis ng isang impeachment court at pangalawang opisyal lamang na halal ng sambayanan na sasailalim sa prosesong ito. Pangatlo, siya ay hinahalal ng may pinakamalaking mandatong pinagkaloob ng sambayanang Pilipino sa sinumang kandidato sa ating kasaysayan. Mahigit 32 milyon o 61% ng kabuuang boto para sa ikalawang Pangulo. Pang-apat, ang articles of impeachment laban sa kanya ay inendorso ng 277 na miyembro na kumakatawan sa ating mga mamamayan mula sa iba't ibang distrito at sektor at ng ating bansa, na katumbas ay mahigit 80% ng kabuuan ng Kamara de Representantes. Terminating an elected mandate before the end of its term is among the most drastic acts our constitutional democracy can undertake. This is why the trial must be guided with prudence, tempered by caution, and marked with unquestionable impartiality. We must avoid even the appearance of impropriety and observe the cold neutrality of an impartial judge at all times. May I therefore caution my fellow senator judges, the prosecutors, the respondent, and their respective counsels and witnesses to refrain from making any comments and disclosures to the public pertaining to the merits of this trial as mandated by the impeachment rules itself. Let us heed the words of the Supreme Court that said, impeachment is not a chance to settle political scores. It is not a stage for political theater or personal attacks, because when the focus shifts to the person rather than the alleged wrongdoing, the process loses its integrity. As presiding officer, I shall do my part to uphold the fairness and integrity of this process and shall see it through to its proper conclusion. At this point, I would like to thank my colleagues for their trust and confidence. I did not seek nor did I ask for this responsibility, but neither will I shirk from fulfilling this duty without fear or favor. This now brings me to the threshold questions that will guide the conduct of this trial and the rulings of the chair. First, what is the number of votes needed to convict the respondent? Second, what is the quantum of proof required to sustain a judgment of conviction or acquittal in these proceedings? Third, how strictly or liberally will this court apply the rules in resolving questions of procedure and evidence? On the first issue, the Constitution provides that no person shall be convicted without the concurrence of 2/3 of all the members of the Senate. With 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. This literal interpretation finds direct support in the 2000 case of Bayan versus Zamora, which concerned the Senate's compliance with the 2/3 vote required to concur in a treaty. Despite having only 23 incumbent senators at that time, then Senator Gloria Macapagal Arroyo was elected as vice president. Therefore, there were only 23 senators. The court held the charter provides that the Senate shall be composed of 24 senators. Without a tinge of doubt, 2/3 of the figure, or not less than 16 members, is an unquestionable compliance with the requisite number of votes mentioned in Section 21 of Article 7. It behooves, therefore, all of us to observe the same fidelity with the Constitution in this trial, which affects not only the mere ratification of a treaty, but more so affects the substantial rights of the respondent, as well as the sovereign will of the people as expressed in the overwhelming mandate given to her. This is the prevailing law today, and whether we agree with it or not, we must abide by it. However, those who disagree are not without recourse, because this is without prejudice to the right of any party who holds a different view to seek judicial relief. And should the Supreme Court, who possesses the sole authority to interpret the Constitution by virtue of its power of judicial review, render a different ruling on this question other than what the chair has stated, this court and this representation shall faithfully abide by that ruling of the Supreme Court. On the question of quantum of proof, given that impeachment is a sui generis constitutional proceedings, the standards of proof that govern administrative, civil, and criminal proceedings do not apply. However, this does not mean that senator judges shall rely solely on their conscience in deciding this case. No less than the Supreme Court also said that, quote, decisions regarding whether to acquit or convict must be based upon clear charges supported by sufficiently clear and convincing evidence. Furthermore, let me be clear that the burden of proof in these proceedings rests upon the prosecution. It does not and will not shift. The respondent is afforded the presumption of innocence and has no obligation to disprove the charges against her. Finally, we turn to the application of the rules of court in these proceedings. Rule 1, Section 6 of the Rules of Courts provide that the rules shall be liberally construed in order to promote their objective of securing a just, speedy, and inexpensive disposition of every action and proceeding. We are also guided by the Supreme Court's bench book for trial judges, which reflects a long-standing principle of adjudication. In case of honest doubt about the admissibility of evidence, it is a better policy to rule in favor of admission and let the senator judges decide whether to give it little or no weight when deciding upon the case in the final outcome. But let me be clear. A liberal construction of the rules is not a license to ambush the opposing party, bypass due process, or introduce unverified evidence that would prejudice the fair and orderly conduct of this trial. Accordingly, consistent with the demands of due process, fair play, and the orderly administration of justice, the chair will construe the rules liberally so that, number one, the prosecutors may be able to adequately present their case, that the respondent may be able to rigorously test it. Number three, that the senator judges may be able to weigh the evidence for themselves. And fourth, so that the Filipino people may hear the whole and impartial truth regarding the allegations against the Vice President. Let us remember what our oath requires us, to do impartial justice according to the Constitution and the laws. Hindi po tayo nandito upang itaguyod ang anumang pampolitikal na adyenda. Hindi tayo narito upang paglingkuran ang kagustuhan ng alinmang panig. Narito tayo upang alamin ang katotohanan at sa pamamagitan nito, mapairal ang hustisyang walang kinikilingan. Ang tungkulin natin bilang mga hukom ay hindi maaaring talikuran. Sa gitna nito, batid ko ang mga problemang kinakaharap ng ating bayan na patuloy natin dapat pa ring pagtuunan ng buong pansin at hanapan ng solusyon. Tayo ay mga senador bago tayo umupo bilang mga hukom at mananatili tayong mga senador na patuloy na magsusumikap na tugunan ang mga pangailangan ng ating mga kababayan bilang Senado at hindi mababago ito. Kaya't aking hiling at dalangin na huwag sana malunod ang diwa ng pagkakaisang nagbigis sa atin gaano mang katindi ang mga debate at pagtatalo sa hukumang ito. Dahil anuman ang magiging kalabasan ng paglilitis na ito, laging kinakailangan ang Senadong nagkakaisa. Dalangin ko po na sana pagkalubad tayo ng katatagan, karunungan, pagpapakumbaba at pag-unawa upang magampanan nating lahat ang ating tungkulin bilang mga hukom. Pagpalain na po lahat sana tayo ng poong may kapal. Maraming salamat at magandang hapon po.
Sir Presiding Officer.
Before we continue, Chair would like to make of record that Senator Joel Villanueva will insert his explanation of vote into the records. If there are no objections, Chair dispenses with the reading of the minutes of the Journal of the May 18 Proceedings, 2026, and consider the same as approved. On the motion? There being no objection, Journal is hereby approved. Senator Cayetano?
Mr. President, let me thank you and just make the manifestation that this representation believes that it is a threshold issue, the number of senators to convict and 2/3, the logical, fair, that would give justice to the Constitution 16. So I thank you for that statement. And as you mentioned, it is a statement of the court, not only of the presiding justice, because napaka-importante na sa umpisa pa lang, alam na ng prosecution at alam na ng depensa kung ilan. Having said that, Mr. President, as to the issue of the presiding officer, not to take up more time, I'd like to register a continuing objection, but instead of giving my arguments, may I submit it in writing, with basically saying that violation of the Constitution is not a technicality. But if our dear colleagues would allow, we will just submit it in writing, Mr. President.
The
Whoever wants to
continuing
join.
objection of the gentleman is noted, and he may so submit his extended written explanation in writing for the record. Senator Cayetano?
Thank you, Mr. President. Just a few administrative matters with your indulgence, dear colleagues.
The lady may proceed.
Thank you. I read that we have rules for our resource panel and also our prosecution and defense that no drinks and food allowed. May I respectfully request that they be allowed to have water. It's a basic human right naman siguro na makainom ng tubig. I read something. I'm just saying, I saw it in the rules. So I'm making clear because knowing them, they will follow our rules, and I think it's not right to not allow drinks. And then, there may be some who are pre-diabetic or diabetic and need to eat something. So, if they have to have crackers or whatever it is that they need to have, I think we should allow them to do that, Mr. President. Sama-sama ko na yung rules ko, ha. And then they should also be allowed to have a bathroom break. I don't want them to also, may ibang klaseng sakit naman yung hindi nakakapunta sa banyo, so may automatically be allowed. I think they're responsible enough to, they're a whole team. There's like a dozen of them here. And then finally, sitting is the new smoking. May we also allow them without them having to ask for permission to stand up, stand in the back, and to stretch their legs, because it is not healthy to be sitting down for 2, 3, 4 hours, and I think our hearings will go on for a long time. So that is my humble submission for the health and wellness of our prosecution and defense panel. Thank you, Mr. President.
Noted, and we will discuss the matter with the parties. Senator Pangilinan.
Yes, Mr. President, if I may be likewise allowed to submit a written explanation of my vote, particularly on the matter of referring to the Constitutional Commission when the debates of the Constitutional Commission, Mr. President, where I believe there is a contrary opinion, which the Supreme Court, in fact, ruled in previous rulings, the Chavez case, Mr. President, for the records.
Noted, the gentleman may do so. If there are no other matters, we now proceed to trial. The clerk of court will please call the case before this impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Zimmerman Duterte.
Appearances for the prosecution.
Good afternoon, Your Honors. We are 11 House prosecutors and 15 private prosecutors. I am Representative Jervil Jinky Pitrix Luistro, appearing for the prosecution. We are ready, Your Honor.
May we get the names of the other panel of prosecutors as well as the counsel for prosecutors one by one for the record?
Good afternoon, if Your Honors, please. We have already submitted the names of the public and private prosecutors who have formally entered their appearance. Ako po si Representative Jose Manuel I. Diokno, magalang pong humaharap sa Senate Impeachment Court. Ready po.
Noted.
Good afternoon, Your Honors. I am Representative Laila De Lima from the Mamamayang Liberal or ML party list, respectfully appearing as public prosecutor. We're ready.
Good afternoon, Your Honor. I am Congressman Joel Chua, respectfully appearing for the public prosecutor representing the 3rd District of Manila.
Good afternoon, Your Honors. I am Arlene Kakabagaw from Dinagat Islands, representing the public prosecutor, Your Honor.
Good afternoon, Your Honors. I am Representative Lawrence Rivera Defensor from the 3rd District of Iloilo, respectfully appearing as public prosecutor.
Good afternoon, Your Honors. Representative Jonathan Keith Flores of the 2nd District of Bukidnon as public prosecutor, Your Honor.
Good afternoon, Your Honors. Representative Isabel Maria Jorge Zamora from the Lone District of San Juan City as public prosecutor.
Good afternoon, Representative Terry Don of Bicol Saro Party List. We are ready, Your Honor. Maraming salamat po.
Good afternoon, Your Honors. Representative Ramon Rodrigo L. Gutierrez of One Ready Party List, respectfully entering appearance for the public prosecution.
Good afternoon, Your Honors. Representative Lordan Swan of the 1st District of Cagayan de Oro City, respectfully appearing for the prosecution.
For the record and for the information of our prosecutors, the term used in our rules for the public prosecutors, as you so mentioned, should be panel of prosecutors of the House of Representatives. And insofar as I've been hearing the term private prosecutors, the private lawyers will be referred to as counsel for the prosecutors. You may proceed.
Good afternoon, Your Honors. I'm Attorney Lorna. Good afternoon, Your Honors. I'm Attorney Lorna Pataho Kapunan, counsel for the prosecutors, under the control and supervision of the panel of prosecutors from the House.
Magandang hapon. Ako po si Attorney Amando Virgil D. Ligutan ng Sapayan Lim Alvarez and Ligutan Law Offices or sa Legal Law from Cebu City. We are under the direct control and supervision of our honorable prosecutors from the House of Representatives. Ready, Your Honor.
Good afternoon, Your Honors. I am May Sancho Divina Gracia of the Co and Divina Gracia Law Offices and I am respectfully entering my appearance as counsel for the prosecutors.
Your Honors, good afternoon. I'm Attorney Lino Chris Patao Kapunan, respectfully appearing as counsel for the prosecutors, acting under the direct control and supervision of the panel of prosecutors of the House of Representatives.
Good afternoon, Your Honors. Attorney Sonia Castillo, private prosecutor, under direct control and supervision of the public prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. Attorney Dina Melissa Lorenzo Singyan, for counsel for the prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. I'm Attorney Marfor T. Fua, appearing as counsel for the panel of prosecutors. Good afternoon. We are ready, Your Honor.
Good afternoon, Your Honors. I am Attorney Erwin G. Matib, respectfully appearing as counsel for the prosecutors. We are ready.
Good afternoon, Your Honors. I'm Attorney Justine Lamarca, respectfully entering my appearance as counsel for the prosecutors. We are ready, Your Honor.
Good afternoon, Your Honors. With respect, James Brian Ibrahim Ali of Pecca Barlo, formerly Ponce Enrile Reyes and Manalastas, appearing as counsel for the prosecutors. We're ready to proceed today, Your Honor.
Good afternoon, Your Honors. I'm Attorney Reynaldo Robles of the law firm of Chan Robles and Associates, appearing as counsel for the prosecutors under the control and supervision of the public prosecutors. Ready, Your Honor.
Good afternoon, Your Honors. Bettina Nepomuceno Zamora, respectfully appearing as counsel for prosecutors. We are ready.
May it please the court, Attorney Theodore Te, appearing as counsel and under the control and supervision of the House panel of prosecutors.
Good afternoon, Your Honors. Attorney Benjamin Sigua Tolosa Jr., respectfully appearing as counsel for the prosecutors, acting under the direct control and supervision. The prosecution is ready, Your Honors.
No other entry of appearances? That's it? How many in all, Representative Luistro? 11 on the part of the House insofar as the panel of prosecutors is concerned, and
We understand, Your Honor, that only 13 private prosecutors entered their appearance today. Nevertheless, Your Honor, as manifested by the Honorable Jokno, the written entry of appearance has been filed already with the Honorable Impeachment Court.
nevertheless, as they appear or will be participating in the trial, kindly inform them to enter their formal appearance during the trial.
Your Honor, the entire 15 private prosecutors have filed already their written entry of appearance with the impeachment court. The articles of impeachment will be presented by 4 separate teams, Your Honor, and that explains why the House prosecutors or the panel of prosecutors are joined by 15 private prosecutors, Your Honor.
Noted. Thank you, ma'am. Senator Cayetano, what is the pleasure of the lady from Taguig?
Yes, Mr. President, I just have a question for the prosecution panel. I understand that there is no requirement for the members of the House who form part of the prosecution to be lawyers. But may I know if they are all lawyers, and if some are not, may we know who are not lawyers? Thank you.
Your Honor, all the 11 House prosecutors are members of the legal profession.
Does that satisfy the Senator Judge?
Yes, I was just curious, Mr. President, because it's not a requirement, so I was just curious if, in fact, they are lawyers. Thank you.
Duly noted. The response of the lead prosecutor is duly noted.
Your Honor, may I just enter a correction to the earlier manifestation?
The lady may proceed.
Instead of 13, 14 private prosecutors are able to enter their appearance today. Nonetheless, all the 15 have filed their written entry of appearance with the impeachment court, Your Honor.
Noted. Appearances for the respondent.
Good afternoon, Your Honors. I am Sheila Sison, respectfully appearing for Vice President Sara Zimmerman Duterte. With the permission of the court, my co-counsel will enter their respective appearances.
You may proceed.
Gregorio Y. Narvasa II.
Christine R. Ferrer for the Vice President.
Good afternoon, Your Honors. Michael Wesley Poa for the Vice President.
Good afternoon, Your Honors. Carlo Joaquin T. Narvasa for the Vice President.
Good afternoon, Your Honors. I am Mark C. Vinluan for the Vice President.
Good afternoon, Your Honors. Justin Nicole B. Goulart for the Vice President.
Good afternoon, Your Honors. Lyndon Miguel C. Bacuel for the Vice President.
Good afternoon, Your Honors. I am Ralph Borja Bodota for the Vice President.
Good afternoon, Your Honors. Roberto Narvasa Batungbakal for the Vice President.
Good afternoon, Your Honors. David Runel M. Gully VII for the Vice President.
Good afternoon, Your Honors. Carol Grace G. Oroseo for the Vice President.
Good afternoon, Your Honors. Clarlene Radok for the Vice President.
Good afternoon, Your Honors. Francesca Marie V. Flores for the Vice President.
Good afternoon, Your Honors. Miguel Carlos Albar Fernandez for the Vice President.
Chair notes the entry of appearance of the counsels for respondent Vice President Sara Zimmerman Duterte, and Chair likewise notes that the Vice President is not physically present but represented more than adequately by her counsels who entered their appearance. On May 19, 2026, the court, pursuant to Rule 7 of our rules, issued the summons to Vice President Sara Zimmerman Duterte to answer to the articles of impeachment. On May 20, 2026, the Sergeant at Arms served the summons on the Vice President and made a return of service under oath before the Secretary of the Senate. Let the return be entered at large into the records pursuant to Rule 8 of the Rules of Procedure on Impeachment Trials. So ordered. Likewise, the court received pleadings, comments, manifestations filed by the parties. All such pleadings, comments, manifestations, and requests filed by the parties, as well as all issuances and orders of the clerk, as well as the clerk of court, made through the presiding officer, are hereby deemed read into the records of the case. So ordered. At this juncture, the chair would like to direct the parties to prepare for their opening statements. We will start with the prosecution. May I know from the prosecution who will deliver the opening statement, and from the respondent who will deliver the opening statement? Under our rules, only one lawyer shall deliver the opening statement for either side. I presume Representative Luistro, you will deliver for the prosecution and for the part on the part of the respondent?
I will deliver the opening statement for the defense, Your Honor.
Representative Luistro from the panel of prosecutors of the House of Representatives is now recognized to deliver her opening statement for the prosecution. You may proceed, ma'am, and you have 15 minutes.
Your Honor, before I proceed, the prosecution respectfully moves for the reading of the 4 articles of impeachment and the entry of the corresponding answer or plea for each article of impeachment, Your Honor. Your Honor, this is consistent to the Senate rules on impeachment, particularly Rule 7, Your Honor, the last paragraph of which mentions about failure to appear, failure of the lawyer to appear, and failure to file answer. There should be an entry of plea of not guilty. Likewise, Your Honor, under Rule 9 of the Senate Rule of an Impeachment, which says that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. In this rule, Your Honor, it was likewise provided that the name of the person appearing in behalf of the respondent should be entered into the record. And by the answer, Your Honor, it is humbly believed that it pertains to the particular plea of whether guilty or not guilty of the respondent, Your Honor. Likewise, Your Honor, under Rule 21, Your Honor, the trial of all the articles of impeachment shall be completed before the senators vote on the final question of whether or not the impeachment is sustained. It is gleaned from these rules, Your Honor, that the senators will be voting on a per article basis, Your Honor. And that is why it is the humble submission of the prosecution that there should be reading of the article and entry of the particular plea per article, Your Honor. This likewise, Your Honor, manifests our complete adherence to the mandate of the Constitution sa pagbasa po ng mga artikulo ng impeachment at pagpapasok ng sagot ng respondent, maipakita po natin sa sambayanang Pilipino ang ating pagsunod sa mandato ng Konstitusyon. Likewise, Your Honor, it upholds due process not only of the respondent but also of the Filipino people. Sa pagbasa po ng mga artikulo ng impeachment, she will be informed of the nature of the accusation against her bago pa po siya sumagot whether she is guilty or not guilty, Your Honor. Likewise, Your Honor, ang 4 na artikulo po ng impeachment ay nakabase sa iba't ibang alegasyon ng facts at iba't ibang nature of accusation or cause of action, Your Honor. And with that, Your Honor, it is perceived that there is a possibility that the plea of the respondent to each and every article will be different from one another, Your Honor. And lastly, Your Honor, this is consistent with the Senate rules on impeachment because the senator judges, the honorable senator judges, Your Honor, will be voting on a per article basis after the conclusion of the trial of this impeachment case, Your Honor.
The chair will respond. Unless the counsel for respondent would like to say something about the motion of the distinguished lead prosecutor.
Yes, Your Honor, may I comment?
The lead may proceed.
Before the presiding officer can rule on the motion or request of the lead prosecutor. But before I give my comment, may I just clarify if the lead prosecutor is now making a motion to arraign the respondent accused.
Your Honor, whether this is arraignment or otherwise, the motion of the prosecution is very much consistent with the Senate rules on impeachment.
I think the question, Your Honor, is very simple.
As I have
It's
mentioned,
answerable
Your
by
Honor,
yes or no, Your Honor.
Rule
Is the
7,
lead prosecutor,
Rule 9,
is the lead
Let
prosecutor
this not be a debate between the
requesting
counsels.
for the respondent accused to
Counsel
be
for
arraigned, Your Honor?
respondent, kindly make your comments and avoid asking questions from the counsel for the prosecutor. We will recognize the counsel for respondent for her comments on the motion and the manifestations made by the lead prosecutor for the House. You may proceed, ma'am.
Thank you, Your Honor. I believe I have a standing question to the lead prosecutor, and I would like to ask her for the legal basis for requiring the respondent to be arraigned today. Because, Your Honor, I note that in her request earlier and manifestations given for the respondent to be arraigned today, she cited Rule 7, Rule 9, and Rule 21.
However, in Rule 7, it very clearly states that if the person impeached after service shall fail to appear either in person or by counsel on the day so fixed, or appearing shall fail to file his answer to such articles of impeachment, the trial shall proceed nevertheless as upon a plea of not guilty. Well, this rule is clear. It does not talk about any arraignment. And if we take a look at this sentence, everything here has been satisfied. The respondent accused is here, has attended through counsel. She may not be in person, but the notice given to the defense is that she may appear through counsel. Second thing is that the respondent accused was also able to file her answer. And so Rule 7 does not support the request of the lead prosecutor that the respondent accused be arraigned today. Now, on the matter of Article 9, counsel also say that the person impeached shall then be called to appear and answer the articles of impeachment against him or her. And if he or she appears, or any person for him or her, the appearance shall be recorded, stating particularly if by himself or by agent or counsel, naming the person appearing in the capacity in which or he appears. If he or she does not appear, either personally or by agent or counsel, the same shall be recorded. And for all intents and purposes, respondent is present today through counsel. There is also nothing in Rule 9 that requires the reading of a 23-page articles of impeachment, which will be a waste of judicial time. Now, finally, under Rule 21, Your Honor, may I just correct the manifestation earlier by counsel, because it would seem to me, unless a reading of the transcript would say that I'm mistaken, but I seem to have heard the lead prosecutor claim that the voting on the articles of impeachment will be per article. Well, that's true, but the first sentence of Rule 21 says, the trial of all the articles of impeachment shall first be completed before the senators vote on the final question on whether or not the impeachment is sustained. Now, honestly, I do not see how Rule 21 is related to the motion now being requested or propounded by the lead prosecutor. And at any rate, Your Honor, given that the respondent is represented by her counsel today, and this is consistent, her appearance is consistent with the notice given and in accordance with the rules on rules of procedure of this court, then we can enter her plea on her behalf.
The arguments of the parties are duly noted. Chair will now make its ruling. The articles of impeachment were deemed read and spread into the records when it was referred by the Senate to the Committee on Justice for the proper issuance of summons. And a plea of not guilty will only be entered in accordance with our rules in behalf of the Vice President if she does not file an answer. But in this case, she has filed an answer and in fact has appeared through counsel. Insofar as the reading of the articles of impeachment is concerned, it will be done at the final resolution of this case when it is put to a vote by the senator judges, where each article of impeachment will be read before a vote shall be taken thereon. For those reasons, the motion is denied, and the lead prosecutor, Representative Luistro, may proceed with her opening statement. Kindly be mindful of the clock, and before recognizing you, ma'am, may I remind the counsels for the parties to kindly address the chair with respect to anything and everything they want or wish to say before the court, and not to address each other. The lady may proceed. Representative Luistro, you are recognized, and you have 15 minutes for your opening remarks.
We thank the court, Your Honor.
Mr. Presiding Officer, the Honorable Cheese Escudero, the Honorable Senate President, Honorable Win Gatchalian, sa atin pong mga kagalang-galang na Senator Judges, mga minamahal na kababayan, sa loob ng bulwagan o sa labas man, mga nakatutok sa telebisyon, sa cellphone o sa radyo, saang sulok man ng mundo, kayo naroroon. Maraming Pilipino ang nagtatanong ngayon, bakit mahalaga ang paglilitis na ito? Ano ang kaugnayan nito sa buhay ng ordinaryong Pilipino? Lubos po naming nauunawaan ang mga tanong na yan. Sa katunayan, may isang driver na nagtatanong, paano sasapat ang kita sa pasada upang mapakain niya ang kanyang pamilya? May isang OFW na nagtatanong, hanggang kailan kailangan lumayo upang mapaaral niya ang kanyang mga anak? May isang guro na nagtatanong, paano pagkakasyahin ang kanyang sahod sa dami ng utang na hinuhulugan? May isang manggagawa na nagtatanong, hanggang kailan magtitiis sa pansamantalang trabaho at kakarampot na sweldo? Sa unang tingin, maaring sabihin na malayo sa buhay nila ang paglilitis na ito. Ngunit hindi. Hindi po. Sapagkat ang usapin ngayon ay patungkol sa isang bagay na pag-aari nilang lahat. Ang kanilang pera, ang kanilang tiwala, ang kanilang karapatan na maningil ng pananagutan mula sa mga pinuno na kanilang pinagkatiwalaan. Kapag ang isang empleyado ay nagkamali ng paggamit ng pera ng kumpanya, siya ay pinagpapaliwanag. Kapag ang isang barangay treasurer hindi maipaliwanag ang nawawalang pondo, siya ay iniimbestigahan. Kapag ang isang principal ay naglustay ng pera ng bayan, kahit 5,000 lang yan, siya ay pinaparusahan. Natural lamang na magtanong ang sambayanan kung ang ordinaryong Pilipino ay pinapanagot. Bakit hindi ang pinakamakapangyarihan na opisyal ng pamahalaan? Ito ang dahilan kung bakit mahalaga ang paglilitis na ito. Hindi upang usigin ang isang tao, hindi upang maghiganti sa kalaban, hindi upang manalo sa politika, kundi upang sagutin ang isang tanong na napakahalaga sa kinabukasan ng ating republika. May saysay pa ba ang pananagutan sa ating bansa? Sapagkat ang kasong ito ay higit at lampas sa sino mang opisyal. Higit at lampas sa anumang partido. Higit at lampas sa alinmang administrasyon. Your Honors, the framers of the Constitution understood that there may come a day when extraordinary power would be entrusted to extraordinary office. They also understood that there may come a day when trust would be broken. And that is why they gave the House of Representatives the power to impeach and the Senate the duty to judge, not to punish political opponents, not to settle political scores, but to protect the republic itself. That is why the Constitution declares public office is a public trust. Ang kapangyarihan ay hindi pag-aari ng sino mang opisyal. Hiram lamang ito sa taong bayan. At ito ang dahilan kung bakit naririto tayo ngayon. Your Honors, the prosecution will present exactly what the Constitution requires. Evidence. Hindi chismis. Hindi haka-haka. Hindi propaganda. at lalong hindi SOCMED narrative. Evidence, official records, financial documents, government reports, video recording, statements under oath, independent findings of institutions created by law. Mga dokumento na hindi bumoboto. Mga records na walang partido. Mga katotohanan na walang kulay pampolitika. Sa unang tingin, maaring magmukhang magkakahiwalay ang 4 articles of impeachment. Confidential fund, unexplained wealth, bribery and corruption, threat against constitutional order. But these are not 4 separate stories. These are 4 chapters of the same story. Story about power exercised without accountability. Story about public trust betrayed. Story about public office that stopped answering to the public. On the first article of impeachment, the evidence will show that more than 612 million pesos in confidential fund entrusted to the office of the Vice President and the Department of Education were disbursed, transferred, and liquidated under circumstances that cannot withstand scrutiny. 612 million pesos. Hindi ito pera ng gobyerno. Pera ito ng sambayanan. Pera ng manggagawa. Pera ng magsasaka. Pera ng OFW. Pera ng guro. Pera ng bawat Pilipino na nagbabayad ng buwis at nagtitiwala na gagamitin ito ng tama. The evidence will show liquidation reports supported by questionable documents. The evidence will show acknowledgement receipts bearing names government records could not verify. Names that transformed accountability into a mockery. Pananagutan na naging kalokohan. Names that insulted the intelligence of the Filipino people. Mary Grace Piatos, Milky Sikuya, Kokoy Villamin. On the second article of impeachment, the evidence will show financial transactions involving billions of pesos associated with the respondent and her husband. Billions. Hindi milyon, bilyon. At habang milyon-milyong Pilipino ang nagtratrabaho at nag-iipon buong buhay upang magkaroon ng sariling bahay, makapagpaaral ng mga anak, magkaroon ng kaunting seguridad para sa pamilya. Aba, bilyon-bilyong piso ang dumaan sa mga bank accounts na hindi maipaliwanag ng maayos. This article is not about wealth. This is about accountability. This is about explanation. If wealth was lawfully acquired, where is the lawful explanation? If transactions were proper, where is the complete accounting? If numbers truly add up, then why do they refuse to reconcile? On the third article of impeachment, the evidence will show bribery, graft, and corruption through the distribution of cash payments and monetary gifts to officials under the supervision of the respondent. This article is not simply about envelopes. This is about institution. This is about whether loyalty was purchased rather than earned. Government cannot function if loyalty is purchased instead of earned. Kapag nabibili ang katapatan, nawawala ang integridad. At kapag nabibili ang opisyal, nabubudol ang bayan. Perhaps the greatest tragedy is where the conduct allegedly occurred. In the Department of Education. Tama po sa DepEd. The institution entrusted with teaching future generations honesty, responsibility, integrity. On the fourth article of impeachment, the evidence will show culpable violation of the Constitution, high crime, betrayal of public trust through conduct that threatens constitutional order. Among all allegations before this court, none strikes more directly at the heart of constitutional order than this one. Ito na po ang pinakamatindi. And unlike in many cases, which depends upon competing accounts, this evidence comes substantially from the respondent's own recorded public statements. The court will see them. The court will hear them. The court will judge them. Public officials may disagree. We may criticize one another. They may compete fiercely for power. That is democracy. But democracy ends when violence begins. Sa kasaysayan ng ating republika, walang vice presidente na may kaibigan na hitman. Ngayon lang. Walang vice presidente na nagpapapatay ng Pangulo. Ngayon lang. Walang vice presidente na handang magpapatay para lamang makaupo sa pwesto. Ngayon lang. The Constitution provides many means on how to resolve political conflict. Election, legislation, public debate, judicial review, and even impeachment. But it does not permit threats. It does not permit violence. It does not permit people entrusted with power to place themselves above constitutional restraints. Your Honors, at the center of this case lies a simple question, perhaps the most important to any republic. When the people entrust power to a public official, does the public official remain accountable to the people, or do the people become accountable to the public official? The Constitution's answer is very clear. Power belongs to the people. Public office is merely borrowed. And every borrowed power carries with it the obligation to account for its use. If a barangay treasurer must account for public fund, then so must the vice president. If an ordinary public servant can be investigated, then so can the highest officials of the government. If ordinary citizen is expected to obey the rules, then surely those who govern them must obey them first. Otherwise, what lessons do we teach our children? That there is law for the powerful and another for everyone else? That accountability exists only for the weak? That public office grants immunity against accountability? Your Honors, this is not the republic envisioned by the Constitution. This is not the republic deserved by the Filipino people. Therefore, the prosecution asks only this: look at the evidence. Listen to the witnesses. Examine the records. Follow the evidence wherever it leads. Judge this case not by politics, not by popularity, not by fear, not by loyalty. Judge this case by the Constitution. Judge this case by the evidence. Years from now, future generations will not remember today's political alliances. They will not remember today's headlines. They will not remember today's slogans. What they will remember is when accountability was tested, the institutions of the Republic stood firm. They will remember only one thing: what this court did when the Constitution called. Future generations will not ask how powerful the respondent was. They will not ask how loud the political debate became. But they will ask one thing: when the Constitution called, did the Republic answer? Your Honors, this is that moment. This is the moment the Constitution anticipated. This is the moment when accountability must mean exactly what it says. This is the moment when public office must truly remain a public trust. This is the moment when the Republic must demonstrate that laws are applied equally to the powerful and the powerless alike. At matapos marinig ang mga saksi, matapos masuri ang mga dokumento, matapos matimbang lahat ng ebidensya, ang prosekusyon ay naniniwala at naninindigan. Isa lamang ang maliwanag na konklusyon: ang tiwalang ipinagkaloob ay nilabag. Ang kapangyarihang ipinahiram ay inabuso. At ang konstitusyon mismo ang humihingi ng pananagutan. Amid the clarity of the mandate of the Constitution, political noise continues. Political squabbles continues. Political division continues. Please, let me conclude. Salus populi est suprema lex. The welfare of the people is the supreme law. Thank you, Your Honor.
The opening remarks of the prosecution through the lead counsel is duly noted. Opening remarks for the respondent. Counsel for respondent has 15 minutes, and we will give you the same latitude we gave counsel for the prosecution for an additional 3 minutes, should you so need it. You may proceed, ma'am.
Thank you, Your Honor. Your Honors, fellow Filipinos, good afternoon. As we begin today the impeachment trial of the Vice President, and in the days ahead, this court will undertake its constitutional task of receiving and weighing the parties' evidence, and ultimately to decide whether these pieces of evidence justify either a judgment of conviction or acquittal, guided only by its members' conscience and their solemn oath to do impartial justice. The present undertaking of this court, therefore, not only carries the weight of the Constitution, but also the imprint of our nation's history, because the Filipino people have shown that they never forget. We, as a nation, never forget. But why is the act of remembering important? What does it matter to our history and to ordinary Filipinos? Because in this trial, the prosecution proposes that we unseat the Vice President elected to office by more than 32 million Filipino people, more than the number of votes cast for the sitting president, and much greater than any of the votes secured by each of the members of the House of Representatives who now are here to prosecute her and seek to undo this people's choice. Sa makatwid, ang malinaw na layunin sa likod ng mga paratang na ito ay ang pagpapatalsik sa isang vice-presidenteng inihalal ng mahigit 32 milyong Pilipino at bunga ng kanilang malayang pagpapasya. Whatever one's political persuasion is, the reality is that the prosecution now comes before this court to remove a vice president chosen by an overwhelming number of the electorate. You all have heard the prosecution say repeatedly that this is because they seek accountability, that the people have a right to hold their leaders accountable. This is not a matter of debate. Indeed, the people have a right to demand accountability from their leaders. What we have yet to hear from the prosecution, however, is this. When the Constitution declared under Section 1, Article 11, that public office is a public trust, and that public officers and employees must at all times be accountable to the people, serve them with utmost responsibility, integrity, loyalty, and efficiency, act with patriotism and justice, and lead modest lives, the Constitution does not only speak to the Vice President. It also demands the same standards from the prosecutors. Being public officers themselves, the public prosecutors and the members of the House of Representatives are also held to the same constitutional standard. And so we must remember what history tells us. This is not the first time that members of the House of Representatives have attempted to remove the Vice President, and in a manner not compliant with the Constitution. In a July 25, 2025 decision, the Supreme Court unanimously declared in Duterte versus House of Representatives, GR numbers 278353 and 278359, that the impeachment proceedings in the House of Representatives were tainted with grave abuse of discretion, rendering the articles of impeachment that the House transmitted last year to the Senate as void ab initio. Early this year, the Supreme Court unanimously denied with finality the House of Representatives' motion for reconsideration of that decision, with a reminder that while impeachment is a powerful democratic process to call out corruption and grave abuse, impeachment can be abused, and that impeachment should never be abused to maintain the hegemonic dominance of greed by shaming those who occupy high government positions into preventing them from doing what they were sworn to do. But perhaps the most enduring reminder of the Supreme Court that we must not forget is the rule of law that does justice is our lodestar, and that justice includes accountability. Justice includes fairness. Without fairness, there is abuse. This fairness is what our democracy is all about. It is in light of these reminders that we draw attention to certain fundamental legal principles that we think we must not forget throughout this trial. Mga batayang prinsipyo na dapat nating tandaan sa buong panahon ng paglilitis na ito, anuman ang ating kulay o politika. If we are to be true and honest to our proclaimed values, such as the pursuit of accountability, justice, and integrity in our system of government, then we must remain possessed of an unyielding resolve to ensure that the trial and judgment in this case are done in accordance with the command of the Constitution, the majesty of the law, and the discipline required by the rules. Otherwise, those who stand in sanctimonious judgment of the Vice President will send a clear message that the law can be bent when it suits the convenience of the powerful, and that justice can be sacrificed at the altar of partisan interests. Mahalagang tandaan ang mahigpit na paalala ng ating Korte Suprema. Impeachment is not a purely political proceeding. It is primarily a legal, political, and constitutional mechanism. Ibig sabihin, kailangang naayon sa batas at konstitusyon ang anumang proseso nito. According to the Constitution, it is the Senate that shall have the sole power to try and decide all cases of impeachment. This power is not shared. The Constitution gives no other body, department, tribunal, agency, or a mere committee of any of these institutions the power to try an impeachment case. The House merely initiates, the Senate tries. Yet, we have seen the Committee on Justice conduct what its chairperson, the lead prosecutor in this case, described as a mini trial, which, as we all had witnessed, became a vast fishing expedition of alleged evidence that were not even part of the impeachment complaints under its consideration and which the respondent accused was made to answer. In that mini trial, we saw how the purported pieces of evidence were curated to construct a narrative against the Vice President even before this case reaches trial. The articles of impeachment presented before this court as an exercise of the House's power to initiate impeachment cases are therefore, in sober truth, the product of an impermissible intrusion of clear constitutional boundaries. Over the course of the impeachment trial, the prosecution will attempt to convince this court and the court of public opinion that the allegations in the articles of impeachment are supported by materials they obtained during their mini trial and that evidence exists to sustain a judgment of conviction. They will claim that the notices of suspension and disallowance issued by the COA and the COA decision denying the Vice President's appeal of that disallowance support their accusations, with the release of that decision by the COA conveniently timed and coinciding with the committee hearings. They will claim that the certifications of the PSA confirm their allegation that recipients of the confidential funds do not exist, even though they listed one Mary Grace Piatos in their pre-trial brief as among their witnesses, or that the liquidation of the confidential funds in a span of 11 days was allegedly swift as to invite suspicion. The prosecution will assert that the supposed NBI findings of similar signatures across a number of acknowledgement receipts submitted to the COA are supportive of their conclusion that the disbursements of the confidential funds were irregular. What the prosecution avoided informing the public so far are these: that it was the then Secretary of the Department of Budget and Management, Amena Pangandaman, who issued a memorandum for the President through Executive Secretary Lucas Bersamin on October 18, 2022, recommending the approval of the Office of the Vice President's request for confidential funds. That the Office of the President did in fact approve that recommendation of the DBM through a memorandum from the Executive Secretary dated November 28, 2022, and signed by the former Executive Secretary Lucas Bersamin by order of the President. That on December 13, 2022, the DBM issued a special allotment order number SARO-BMB-C-22-001-2004, signed by former Secretary Amena Pangandaman to cover the request of financial assistance, subsidy, and confidential funds of the OVP that, notwithstanding the impending end of the fiscal year, the confidential funds were nonetheless released to the OVP on December 20, 2022 under this documented approval process. That the COA decision is far from being final, that there is a pending motion for reconsideration of that decision, that, assuming arguendo, the COA denies that MR today, or while this trial is ongoing, as could plausibly happen under the circumstances, the respondent accused still has legal remedies available under the law and rules and can file a petition to question the validity of any forthcoming resolution of the COA on the MR under Rule 64 via petition for certiorari under Rule 65 of the Rules of Court, and more importantly, that nothing in the notice of disallowance or COA decision states any findings of supposed misuse of confidential funds as confirmed by attorney Gloria Camora when she was asked on this point during the committee hearing on April 14, 2026. Across all other articles, the prosecution will lay a landscape of what it deems to be their evidence in support of their speculations and conclusions. We are not strangers to all these accusations, precisely because this was not the first time these narratives were foisted into the minds of the general public. We have heard the same tales and stories of these accusations since 2024, when the House conducted its Quadcom hearings and most recently the mini trial of its Committee on Justice. But what we must not forget amid all these accusations is the fundamental legal principle that the burden of proof never shifts. The burden of proof never shifts. He who accuses must prove his allegations with evidence that meets not only the degree of proof required, but also meets the evidentiary standards of admissibility, credibility, relevance, materiality, and competence. We therefore should not lose sight of the core principle that the burden of proof is on the prosecution, and unless it discharges that burden, the accused need not even offer evidence on her behalf, and she will be entitled to an acquittal. This is the law then. This is the law now. And the underlying principle for this burden of proof is simple. Under our Constitution, every accused is presumed innocent until proven otherwise. An accused has in her favor the presumption of innocence, which the Bill of Rights guarantees. This also brings to fore the reality that, in the words of the Supreme Court in People versus Pagal, the individual citizen is but a speck of particular molecule vis-a-vis the vast and overwhelming powers of government, and his only guarantee against which shield him in times of need. Sa madaling salita, kinikilala ng ating saligang batas na sa bawat paglilitis, ang isang individual ay nahaharap sa malalim at napakalaking makinarya ng buong Estado. At ang tanging sandigan lamang niya laban sa anumang pang-aabuso ng kapangyarihan ay ang kanyang mga batayang karapatan sa ilalim ng ating konstitusyon. Kaya't mahalagang linawin na sa gitna ng pagtatangkang ikondisyon ang kaisipan ng mamamayang Pilipino at sa gitna ng walang humpay na komentaryo sa mga pampublikong espasyo, wala pang maituturing na anumang ebidensya o alegasyon na napapatunayan ng prosekusyon sa simpleng dahilan na ang bawat ebidensya ay kailangang dumaan muna sa paglilitis at pagsusuri ng korteng may tanging kapangyarihan sa ilalim ng ating saligang batas. Higit sa lahat, ang anumang paglilitis ay kailangang naayon sa itinatakda ng ating batas at konstitusyon at hindi lamang sa kagustuhan ng iilang may hawak ng kapangyarihan. One might ask, why is it important that we must not forget these basic principles? The ruling of the Supreme Court tells us why. The Bill of Rights applies to the entire impeachment process because inasmuch as our court recognizes that impeachment is a political process, it reminds us that it is not a purely political process, but a legal and constitutional mechanism. Thus, if we are to uphold the rule of law, serve justice, and invoke the accountability mechanism, then this court and we as a people must guarantee that all efforts to hold our leaders accountable must be done right. This we must not forget. I thank the court and the public for the privilege of your time. May God bless our country.
Opening statement of the counsel for respondent is duly noted and entered into the records. The court will now proceed to dispose of some of the incidents that were brought up during the pre-trial conference, as well as other pending matters and motions. First, on the sequence of the presentation of the articles of impeachment. The pre-trial order stated that the prosecution has a free hand to determine the sequence of the presentation of the articles of impeachment. However, respondent will be similarly accorded the same right insofar as the presentation of their evidence and witnesses in chief is concerned. May we now learn from the public, from the panel of prosecutors rather, what will be the sequence of presentation of the articles of impeachment that they intend to pursue? Attorney Jokno is recognized. You may proceed, sir.
Thank you, Your Honor. The first article we will be presenting will be Article 4 on grave threats. Second will be confidential funds, Article 1. Third, bribery, that is Article 3. And the fourth is unexplained wealth, Your Honors. That's Article 4.
No, 2.
I'm sorry, Article 2. I stand corrected.
So the sequence of presentation shall be Article 4, Article 1, Article 3, and then Article 2.
Yes, that is correct, Your Honor.
So I presume that beginning tomorrow, once we issue the subpoena for your first set of witnesses, you shall begin with Article 4.
Yes, Your Honor.
Again, Chair rules that the respondents have the same and equal privilege of presenting its case as it so desires when it's time to present its evidence in chief shall come. What is the pleasure of the counsel for respondent?
Thank you, Your Honor. May I ask if the prosecution is ready to present its first witness today because the defense is ready today, Your Honor?
Duly noted. We will get to that later.
If Your Honor,
item in the
please.
agenda.
If Your Honor, please.
Yes,
I
Representative
have just
Jokno.
noticed that Your Honor had already directed the counsel for the defense not to propound questions to the prosecution. This is already the second time that she's doing that. She appears to be assuming or arrogating the powers of the court, because as I understand the rules, it's only the court that can propound questions to the counsels.
Your Honor, may I comment?
The lady may comment.
I
Counsel
take
for respondent may
exception to
comment.
that. Yes, Your Honor. I take exception to that manifestation of the good counsel. In fact, the record would show, and if we can run the transcript back, my question was addressed to the presiding officer, Your Honor.
Let us move forward, gentleman and lady. Next item for us to dispense with, the witness disclosure rule. The prosecution proposed a 3-day witness disclosure rule. The respondents proposed a 5-day witness disclosure rule. But I understand the prosecution is amenable to the 5-day witness disclosure rule. Would that be
Yes,
correct,
Your Honor.
Representative Jokno?
We are amenable to the 5-day disclosure rule.
Chair therefore rules that insofar as disclosure to both to either party of a witness to be presented, not mentioned in the pre-trial order and/or briefs of the parties shall be for 5 days. This is subject also to the chair's reminder that at the end of every week, that would be a Wednesday while we are on recess, we will ask the party presenting their case in chief to enumerate the witnesses they intend to present for the following week with the corresponding motion for the request of issuance of subpoena to be submitted the day before or on Tuesday, so that we can act on it before the last day of the week so that the subpoena can be properly issued in due course and in due time. So ordered. On the examination of a witness by more than one counsel as propounded or proposed by the prosecution, the rules of the Senate are clear. Article 15 of the Rules on Impeachment states, witnesses shall be examined by one person on behalf of the party producing them and then cross-examined by one person on the other side. Court therefore rules that as a rule, only one person shall present a witness. However, in the exigency of the delivery and administration of justice, and under certain exceptions, the court may allow more than one counsel to examine and or propound questions to a witness. To cite an example, just for the sake of the record, if, for example, the panel of prosecutor disagrees with how the counsel for prosecutor is handling the case, the panel of prosecutors or one of them can take over, and that is but proper and should be allowed and will therefore be considered as an exemption to that rule. And other similar exigencies will be allowed in order to afford the orderly administration of justice and of these proceedings. So ordered. Insofar as the BIR box is concerned, what is the pleasure of? Insofar as the BIR box is concerned, this box was turned over to the Senate as part of the documents including the articles of impeachment. However, the court is not yet in custodia lehis of this box, given that there is no lawful order issued by the court for this box to be turned over to the Senate. More so that it is not yet offered in evidence, not even as of yet marked. The chair therefore orders that the BIR box, closed, sealed, and as it is received, be sent back to the BIR or the Bureau of Internal Revenue without prejudice to any action that the court may take if a motion will be filed by either party for the issuance of a subpoena, and we shall await action, if any, by the BIR Commissioner should that time come. So ordered. Now, insofar as the subpoena requested by the prosecution for the two NBI agents, may I request the clerk of court to kindly read the motion for the issuance of subpoena ad testificandum.
The prosecution, through the undersigned public prosecutors, respectfully requests the issuance of subpoenas ad testificandum, directing the following witnesses to appear and testify before the Honorable Impeachment Court on July 6, July 7, and July 8, 2026 at 2 p.m. as their testimonies are material, relevant, and necessary to establish the allegations under Article 4 of the Articles of Impeachment, as well as matters necessarily incidental thereto, and for purposes of the identification and authentication of other evidence before the Impeachment Court. Number 1, Attorney Jeremy C. Lotok, Regional Director, National Bureau of Investigation. Number 2, John Mark Kalilong, Senior Agent, National Bureau of Investigation. Respectfully submitted, Quezon City for Pasay City, July 1, 2026.
We are not in receipt of any reservation or objection on the part of the respondent, counsel for respondent rather. However, Chair would like to ask the prosecutors, do you only request for a subpoena ad testificandum or a subpoena duces tecum as well?
If I understand the record, Your Honor, please, it is a subpoena both for ad testificandum and duces tecum.
The motion filed
Your
by the
Honor.
prosecutors is only for a subpoena ad testificandum. That's why the chair is clarifying.
Your Honor.
I stand corrected, if Your Honor, please. It's just
Counsel
for
for
ad
respondent?
testificandum.
Counsel for respondent?
If I may, Your Honor, just to set
Please
the record
proceed.
straight, the presiding officer earlier inquired mentioned that the court is not in receipt of any objection from the respondent. But just to set the record straight, the respondent has not received any copy of the request for subpoena being mentioned today, Your Honor.
Naserve natin, di ba?
What we received, Your Honor, was a manifestation containing the list of the witnesses of the prosecution for July 6, 7, and 8, Your Honor. And so it would be impossible for the defense or the respondent to object or to even comment on a request that we were not served with any copy with.
The two witnesses against whom a subpoena has been requested by the prosecution were mentioned in the pre-trial brief of the prosecution and was not commented on by the respondents in their pre-trial brief. But if you do have any objections now, the court would be more than glad, or reservations, the court would be more than glad to hear it before ruling on the motion for the issuance of a subpoena
That's
on these
fine.
two NBI agents.
At this point, Your Honor, that's fine. We'll just place on record our objections as the testimonial evidence is presented.
Duly noted. Chair hereby orders that the subpoena ad testificandum and duces tecum be issued to the aforementioned two NBI agents contained in the motion filed by the counsel for the prosecutors. Although by nature subpoena is ex parte, we would Chair would instruct the clerk of court to kindly upload all of the filings of all of the parties to the website for the information not only of the senator judges, but also of the parties and their counsels. The chair earlier, counsel for respondent, said that witnesses for the succeeding week shall be manifested in open court on the last day of the trial, in this case by Wednesday, insofar as the next week's trial is concerned. So ordered. Now, insofar as the request for subpoena for bank records and AMLC records. Chair recognizes the clerk of court to kindly read and spread into the records the request for the issuance of subpoena, both, I believe, ad testificandum and duces tecum, or just duces tecum, for the aforementioned documents. The clerk of court may proceed.
Request for issuance of subpoena duces tecum. The prosecution respectfully requests the issuance of a subpoena duces tecum to the branch manager of the following banks: BPI Julia Vargas Branch, BPI Green Hills EDSA Branch, Philippine Savings Bank Wilson Branch, BDO Unibank Inc. Davao CM Rector Branch, Metrobank Davao Ecoland Branch, BDO Unibank Davao Rizal Branch, Security Bank Bikutan Branch, Land Bank San Pedro Branch, Philippine Savings Bank Davao MADR Branch, requiring him or her or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. the certified true copies of all records, documents, books, papers, electronic data, communications, and information in the possession, custody, or control of the bank relating to any account, deposit, investment, trust, loan, safety deposit, or other financial transactions maintained, opened, closed, controlled, beneficially owned, or jointly held by Sara Z. Duterte and or Manasseh R. Carpio, whether individually, jointly with each other, jointly with any other person, or through any authorized representative, nominee, attorney-in-fact, or signatory for the period January 1, 2007 to December 31, 2025, including but not limited to: number 1, records identifying account numbers, account types, know your customer documents such as but not limited to customer information forms and signature cards. Number 2, monthly bank statements, average daily balances per calendar year, year-end balances from January 1, 2007 to December 31, 2025. Number 3, all account and transaction records, ledgers, and journals and similar instruments from January 1, 2007 to December 31, 2025. And number 4, all other relevant bank documents. Request for subpoena duces tecum to the Anti-Money Laundering Council, to Honorable Eli M. Remolona Jr., Chairman, AMLC, to Attorney Ronel U. Benaventura, Executive Director, AMLC, requiring him or her or his or her authorized representative to submit to the clerk of the impeachment court on or before 24 June 2026 at 9 a.m. original or certified true copies of the following: number 1, all reports of covert transactions and suspicious transactions filed by banks and all other financial institutions and covered persons required to submit covert transaction reports and suspicious transaction reports to the AMLC involving Sara Duterte Carpio and or Manasseh R. Carpio covering the period of 2006 to 2025. Number 2, any and all investigation reports or related reports or documents prepared by the AMLC involving the reported covert transactions or suspicious transactions. And number 3, electronic copies including Microsoft Excel files, database extracts, or machine-readable formats of AMLC, CTRs, and STRs for the period 2007 to 2025 involving Sara Duterte Carpio and or Manasseh R. Carpio. Respectfully submitted, Quezon City for Pasay City, June 18, 2026.
Your Honor, may I comment?
If Your Honor, please, before the defense makes a comment, just to obviate the proceedings and to facilitate the hearing today, if I may.
The chair has not recognized anyone yet.
May I be recognized, Your Honor?
Yes, the counsel for prosecutor.
If Your Honor, please. The subpoena request that was just read by the clerk of court pertains to a request that the prosecution file be brought to the Honorable Court on June 24. Since that date has passed and no subpoena has been issued, we had refiled just this afternoon a subpoena reiterating the same requests And in the interest of justice and to allow the defense to comment or if they want object to the request that we filed this afternoon, perhaps if I may suggest, if Your Honor, please, that we provide the copy to the defense, give them a period of time to submit their opposition or objection, and as well the same period of time to the prosecution to reply before the Honorable Court rules on this
Counsel,
request.
is the motion for subpoena ducis tecum and/or ad testificandum that you filed today exactly the same as what you filed before?
No, Your Honor. It contains the same documents that we had requested earlier, but there were some additional documents that were also mentioned in the request we filed this afternoon.
So you asked for additional documents and
Yes, Your
information?
Honor.
What does counsel for respondent say?
Your Honor, before I give my comment on the request for subpoena, I thank the good counsel for offering to provide us a copy of the request for subpoena, but we would also ask that we be provided with the June 2026 copies of the request for subpoena, as well as the new one that the counsel mentioned today. But just for the record, it would seem to me that the request for subpoena covers documents involving years from 2006 up to 2025. And again, just for the record, this would seem to violate the Duterte versus HOR ruling, which very clearly states that the impeachment must be only for those acts or omissions within the impeachable years and terms and office of the official. But nonetheless, Your Honor, just so we're able to fully ventilate whatever objections or comments that we may have on this request, and considering that for today and in the disclosure made by the prosecution, they will begin with Article 4, and all these documents seem to pertain to Article 2, then we will ask for 10 days to file our comment on this request for subpoena, Your Honor. From today, Your
Chair
Honor.
hereby directs that all motions for the issuance of subpoena ad testificandum, subpoena ducis tecum filed by either parties be furnished to opposing party and/or counsel before filing it before this court in order to provide full disclosure and fairness. But instead of 5 days, counsel, chair is giving both parties 5 days to submit their respective memoranda and/or position insofar as it is concerned. We will afford the parties time to argue their position before the court so that the senator judges can hear your position in addition to your extended written memoranda insofar as this crucial issue of issuance of a subpoena ducis tecum ad testificandum on certain bank records and AMLC records, which the chair will schedule, giving ample notice to the parties in due time. Is that okay with both sides?
Just for clarity,
Yeah.
Your Honor.
Yes, counsel for respondent.
May I ask that the period, if the period for the parties to submit or the respondent to submit its comment, her comment on the request for subpoena would be 5 days from today, Your Honor?
From today, but you can submit it on Monday since it lands on a Saturday.
Second, Your Honor, the presiding officer mentioned that we also must submit a memorandum or position paper on this, Your Honor.
If you so desire, or you simply can argue it in open court,
Okay,
but you may want to submit an extended written memorandum on the matter for the easy reading of the senator judges pertaining to this issue.
Last, Your Honor, will the court also schedule an oral argument on the respective positions of the parties?
Yes, chair will do that.
Thank you, Your Honor. And this would not be on Monday, Your Honor.
No, that will not be on Monday.
Thank you, Your Honor.
If Your Honor,
Counsel
please.
for prosecutor?
Yes. May I be allowed to make a counter manifestation, just a brief one with respect to the statement of the defense counsel regarding the application of the case of Duterte versus House of Representatives.
The gentleman may proceed briefly.
Your Honor, the decision and the resolution of the Supreme Court in that case did not say that any preterm evidence is inadmissible. There is no statement like that at all in the entire decision and the resolution. What the Supreme Court said, and I quote, was very simple. The basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. All of the articles in this particular case pertain to impeachable acts committed by the Vice President during her term as an impeachable officer, including unexplained wealth. If I may just be allowed 1 minute, Your Honor, to explain that. The
1 minute.
Unexplained wealth, Your Honor, that is amassed prior to the term of a Vice President is relevant and material to her being an impeachable officer, because wealth of the magnitude of millions or billions ay meron pa rin pong pakinabang po yan ang Vice President kahit hanggang ngayon. It's very clear that when a local government official, for example, who later becomes a national official, amasses hundreds of millions, if not billions of pesos, then that benefit continues today. Second, if Your Honor, please, integrity, hindi po pwedeng biyakin po yan na kesa dati ay hindi po ganon at ngayon may integridad. It's very clear that integrity is a continuing requirement of fitness for office. Thank you, Your Honor.
Duly noted and entered into the records.
May I respond? Just very briefly, Your Honor.
Counsel
I won't take
correspondent.
much time of the impeachment court.
As a rejoinder to the statement and manifestation of Representative Jogna, briefly.
Thank you, Your
Madam,
Honor.
You may proceed.
I think the good counsel has already stated precisely the reason for our position. We maintain our belief that the Duterte versus HOR ruling precludes any of these trawling incursion, again, on private records of so many individuals and so many entities when nothing in the articles of impeachment point to any specific allegations as to the relevancy of all these documents, Your Honor. But nonetheless, we will include all our position and as well as our objections on the request made today with respect to these documents. And what it would seem to the defense would be another 2.0 version of a fishing expedition. May I also, Your Honor, just to clarify also the period given to us to comment on the request for subpoena, may we ask that the 5-day period run from our receipt of the copies of the documents, Your Honor.
We will make sure that the counsel for respondent will get that today.
Thank you, Your Honor.
The comments of both counsels of the parties are duly noted and entered into records. Chair would like to apologize to Senator Cayetano, who has been waiting for quite some time. Thank you for your patience and indulgence. Senator Cayetano is recognized. What is your pleasure, sir?
Presiding Senator Judge. Since we already stated as a court that we will take literally Section 3, subparagraph 6 of Article 11 of the 1987 Constitution, that no person shall be convicted without the concurrence of 2/3 of all members of the Senate. May I ask the members of this court, through the presiding justice, to consider, not today, I have a proposal, but not today, but to consider communication with the Sandigan Bayan for the attendance of Senator Dante Marcoleta and Senator Jinggoy Estrada, considering that the presiding officer may correct me if I'm wrong, but if we get to Section 21, as discussed a while ago by the defense, the prosecution and defense, and we do not know what will happen. Their case may be dismissed. They can be out on bail. So we want them to be able to participate and observe the witnesses as senator judges here. I do know that Senator Jinggoy is under suspension, but there's an argument to be made that the impeachment court is sui generis. In ordinary committee hearings, we do coordinate with courts to ask that persons under their custody be delivered to the Senate under, or the House of Representatives under certain conditions. So I'd like to formally ask, Mr. President, that this court consider that. I will submit whether you'd rather have a caucus or a in-camera discussion, or if you want us all to submit our legal opinion. I wouldn't also mind the prosecution and defense weighing in, but considering that if they do not attend and they are here, sorry, Mr. President, considering that if they do not attend at all and cannot vote, their vote will be equal to a acquittal. And as we said from the start, we want a fair and we want justice, we want a fair impeachment trial. Sinabi ng prosecution na sana tignan yung ebidensya, pakinggan mga witnesses. So kahit gawin to ni Senator Marcoleta at kahit gawin to ni Senator Jinggoy, and of course this is my personal opinion that may politika sa pagpapakulong sa kanila. That's my personal view. Allowing them to attend here might add to the integrity of the proceeding and actually make things easier when the time comes to render a verdict. So may I submit that to the court and to our colleagues for discussion at the proper time, Mr. President.
The chair notes the comments and requests of Senator Judge Cayetano and will consult the senator judges regarding this matter and shall coordinate with his office with respect to his requests pertaining to Senators Jinggoy Estrada and Senator Marcoleta, including whether or not we will enlist the comment on and position of the parties to this case. So ordered. Senator Tulfo? What is the pleasure of Senator Judge Tulfo? Rafi?
Mr. Presiding Officer, as far as I'm concerned, I would allow siguro mag-monitor yung mga si Senator Jinggoy, Senator Marcoleta. They will be allowed na kahit man lang yung sa TV monitor. Para sa akin, I do agree with what Senator Alan Peter Cayetano was suggesting. Thank you, Mr. Presiding Officer.
The point of Senator Judge Rafi Tulfo is well taken by the chair. Any others? If there are none, Presiding Officer would now like to deal with an administrative matter before we adjourn for this afternoon. On the matter of providing public access to case records, yes, Senator Judge Marcos, what is your pleasure, ma'am?
Yes, Presiding Officer, may I request an update? As I recall, during the pretrial conference, there was disagreement on how to go about the markings on the various documents, and among the thousands of pages that we have received in evidence for the trial, it apparently was resolved that the counsels would place their initials on the evidence. Is that correct? Is that still what stands today? And each party would take their respective evidence or files and present the same during the trial to guarantee that the same evidence would be presented. Is that correct?
That is correct, with the exception of some, I think, documents that where the original was not presented, which is being corrected, I think, by the parties as we speak.
Are we in fact in receipt as judges of all these thousands of pages? Dahil ako, simple lang hinahanap ko yung affidavit of investigation, yung dalawang NBI na unang testigo na sana haharap ngayon, nakita ko sa libu-libong pahina na sinubmit, mali-mali ang pagka-annex ng AOI, hindi ko talaga mahanap. Tapos, ang sabi doon, Annex G. Pero nung kinalkal ko yung Annex G, hindi naman affidavit yun, kundi disbursement voucher or something like that. Kaya, hindi ko alam kung nag-provide ba talaga ang clerk ng Senate ng records as marked during pre-trial at kung pinal na talaga ito at pag-aaralan natin.
At this point in time, Your Honor, documentary evidence as of yet has not been formally offered and therefore has not been turned over to the court. Neither has it as of yet been identified by a witness to authenticate the same. Once the prosecution presents their witness and identifies the piece of evidence, that will be the proper time, perhaps, that the good Senator Judge can ask for a copy because the lady might want to ask questions of the witness should that time come for the witness to testify as to the document marked previously erroneously or rightfully by either party.
Yes, precisely. Thank you very much, Presiding Officer. We wish to prepare for the three first witnesses, and we're unable to access any of their affidavits or other documents. Thank you.
Duly noted and entered the records. What is the pleasure of Senator Judge Padilla?
Ginoong tagapamahalang hukom, gusto ko lamang pong sundan yung sinabi ni Senator Judge Alan Peter Cayetano at magpasalamat po kay Senator Judge Raffy Tulfo. Gusto ko lamang pong linawin na ang hinihingi po namin kung hindi man makapag-participate dahil sinasabi nga po ay ipinagbabawal silang makapag-participate at bumoto si Senator Jinggoy Estrada at Senator Judge Marcoleta. Ang hinihingi po namin ay makapunta po sila dito bilang observer. Hindi lang po basta monitor. Yun lamang po. Maraming salamat.
Noted, at the proper time we shall discuss this matter and settle it as a court or in caucus. There being no other Senator Judge who wishes to make a manifestation, comment, and or motion, Chair would now like to dispose of an administrative matter. Consistent with Article 2, Section 28 of the Constitution on the policy of public disclosure in matters involving public interest and to give life to the directive under the rules to open the impeachment proceedings to the public, the court hereby directs the clerk of court to create the necessary internet web pages to allow the electronic records of impeachment to be made accessible to the public through the Senate website, whereby all pleadings, memoranda, motions filed by the party shall be uploaded, including the journal of the proceedings after it shall have been approved by the impeachment court. Yun lang po siguro yung madedelay ng konti dahil kailangan aprubahan muna ng impeachment court yung journal bago po namin ma-upload sa website. Yes, what is the pleasure of Senator Judge Bam Aquino?
Yes, Mr. President. On this note, firstly, we'd like to second and congratulate this move of the impeachment court to make all of the evidence available to the public. May we know in how many days will the clerk of court make this evidence available to the public, Mr. President?
They've started, but they have not completed it yet. As Senator Judge Marcos said, the documents are voluminous. I think it covers until 9Q, if I'm not mistaken, initially, when it was marked. About more than 10,000 documents.
Mr. President, of course, in the same way, if this is made available to the public 6 months from now or 1 year from now, that defeats the purpose of having this made public.
No, that will not happen.
Yes, may we get a commitment from the clerk of court as to the delay by which presented evidence is made public, Mr. President?
No. Let me clarify, Your Honor. I believe the articles of impeachment as well as its annexes have been uploaded. The answer as well as its annexes have been uploaded. And most of the exhibits that were marked, not all, are annexes of either the impeachment complaint and or the answer. Can the chair give you an update before the week is over as to a realistic timetable to upload in real time already? Again, except for the journal, which we need to approve. So we cannot upload the Wednesday transcript or journal until we meet again on Monday and approve the journal of Wednesday. So that would be the only delay, if at all, in uploading it. That should be the only delay.
So if I take it correctly, Mr. President, the clerk of court will endeavor to upload all of the presented evidence in real time at the soonest possible time, except for the journal, which needs approval of the body.
That is correct, Your Honor.
Thank you, Mr. President.
Senator Judge Cayetano Alan.
Presiding Senator Judge, just a clarification. No? So no problem with complete transparency with any public records. But when we talk about evidence, diba, precisely that's why we want a fair trial, due process. There's a process wherein the prosecution shall present evidence, then they will offer it. And then if there's a question as to the relevance or if it is prohibited, for example, if a evidence presented is a fruit of the poisonous tree, will we upload that? We haven't decided yet here whether we will accept it as evidence or not. So let me tell you first which ones personally I don't have a problem with. Don't have completely transparent. I have no problem with senator judges given time to review everything, and I assume we're all trained to consider only the evidence that is later on admitted, offered and admitted. So my problem is that, for example, no, if someone offers now, between now and the trial, wiretapped recordings, do we upload that when we have not made a ruling yet on that? So I just want to be clarified on that.
The chair will clarify. As the chair said earlier, only the pleadings, motions, and memoranda filed by the parties, and insofar as the exhibits marked are concerned, only those attached as annexes to either the articles of impeachment and or the answer to the impeachment complaint. Insofar as documentary evidence is concerned, it will only be admitted, and if at all admitted by the court, and published once formal offer has been made. Until such time, we will not publish any documentary evidence even after being identified by a witness, because it is the formal offer that will determine its admission by the court after the
Same
party
thing,
rests.
just to clarify, same with if we do issue a subpoena, duces tecum.
The subject matter of the subpoena will not be published, but the motion for the issuance of a subpoena
Thank you.
will.
Thank you for that clarification.
Thank you, Your Honor. Senator Judge Erwin Tulfo is recognized. What is your pleasure, sir?
Thank you, Mr. President. Thank you, Mr. Presiding Officer. Just want to be clarified. I need a clarification, Mr. Presiding Officer, with regards to this anti-money laundering council documents or pieces of evidence that will be submitted here. Will it be okay if we tackle this in public, or shall we tackle evidence from the AMLAC during an executive session? I believe this is under the bank secrecy law, or we can tackle it because this is an impeachment court, Mr. Presiding Officer.
What we will debate upon, if at all, on the scheduled date to be set by the chair is a debate on whether or not to issue the subpoena duces tecum ad testificandum in relation to AMLC records, not the actual records yet. Once it is granted by the court and is issued, it will have to be presented by the parties. We cannot tackle and discuss it in executive session, because anything and everything discussed in executive session cannot be revealed into the public and used by this court. Secondly, it can only be, if at all, revealed by a unanimous vote or consent by all the senator judges, which effectively hog-ties that piece of evidence if we discuss and talk about it only in executive session. Whether or not it is to be made public, whether or not it can be legally obtained, will be decided by this court after hearing the oral arguments of the parties.
Thank you for that clarification, Mr. Presiding Officer.
What is the pleasure of Senator Judge Villanueva?
Yes, Mr. President. Considering that we have been tackling and asking of pieces of evidence, I think there's a lot of questions with regard to the mahiwagang BIR box, Mr. President. Yung clarification lang po, where is it now, and when are we going to transfer it to the Bureau of Internal Revenue?
It is with the Clerk of Court in the Office of the Secretary General, as instructed by the Chair. It should be sent back to the BIR by tomorrow morning. in the condition that it was received, meaning sealed.
The same. Thank you, Mr. President.
Any other manifestations or motions on the part of the senator judges? Senator Judge Ontiveros is recognized. What is your pleasure, ma'am?
Salamat po, Mr. Presiding Officer. Just to make a brief statement in support of the ruling recently proclaimed by the Presiding Officer on executive sessions. Thank you, if I may,
Noted,
Mr.
and
Presiding
entered into the
Officer.
records.
And just to add a little bit of that,
Lady may
Mr.
proceed.
Presiding Officer, thank you. The executive session is only for Congress acting in its usual legislative functions, and impeachment trials do not contemplate executive session. So I join with the Presiding Officer in the call that he made, which I believe is the default also of this impeachment trial court for transparency as a general rule and as a default. Salamat po, Mr. Presiding Officer.
Thank you, Senator Judge Ontiveros. Before the court adjourns, Chair directs the Clerk of Court to kindly make sure that the subpoena for the two NBI agents will be issued this afternoon and duly received, and entrusts it to the Counsel for Prosecutors to make sure of the attendance of their two witnesses tomorrow. Likewise, the Chair reminds the Clerk of Court to furnish, right after we adjourn, Counsel for Respondents with a copy of the requests for the issuance of subpoena thus far submitted and filed with the Office of the Clerk of Court. So ordered.
The impeachment trial of Vice President Sara Zimmerman Duterte is hereby called to order. We shall be led in prayer by Senator Alan Cayetano.
Holy Father, we come to you today, different ages, galing po sa Luzon, Visayas, Mindanao. Iba-iba po ang paniniwala sa politika, sa religion, pero lahat po ay Pilipino at lahat po ay ginagalang ang pangalan mo. Sinabi niyo po sa propetang Jeremiah, sa Jeremiah 29:11, "For I know the plans I have for you, plans to prosper you and not to harm you, plans to give you hope and a future. You love us so much that you made us in your nature and likeness, giving us free will. Thus, to receive the fruits of your plans, plans to prosper us and not to harm us, plans to give us hope and a future, we must first seek your kingdom and righteousness. You call us to be faithful, Lord God. For us to be faithful both in small things and in big things. Same with the rules, Mr. President. Help us to be faithful with the Constitution, the Senate rules, the rules of impeachment. Help us to be faithful to the rules of fairness. As the prosecution stated yesterday, to hold everyone accountable from the barangay captain to the highest official of the land. Lord God, Holy Spirit, do not allow us to obstruct justice, yet always give us the strength to obstruct injustice, regardless of the cost and the consequences. Magalit na po kung sino magagalit, gamitin niyo kami bilang instrumento ng hustisya. Lead each one of us to pursue the impeachment trial with fairness, political neutrality, and due process. To pursue the flood control scandal with the same zeal, effort, fairness, and political neutrality. To pursue corruption in all forms. Help us build a justice system that is ideal rather than one that is weaponized and is actually an instrument of oppression and tyranny. We may disagree on many things, but let us agree in asking for your love, grace, and mercy upon the nation. We may have different visions of a prosperous Philippines, of accountability, fairness, yet may we agree in the words you put in the framers of the Philippine Constitution, which is found in the preamble. We, the sovereign Filipino people, imploring the aid of Almighty God in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and to our posterity the blessings of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, peace, do ordain and promulgate this Constitution.
Thank you for this privilege to serve you and our people, Lord God. We ask for all of this in Jesus' mighty name. Amen.
Amen. The clerk of court will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino. Senator Judge Cayetano Alan. Senator Judge Cayetano Pia. Senator Judge De La Rosa. Senator Judge Ejercito. Senator Judge Estrada. Senator Judge Go. Senator Judge Ontiveros. Senator Judge Lacson. Senator Judge Lapid. Senator Judge Legarda. Senator Judge Marcoleta. Senator Judge Marcos. Senator Judge Padilla. Senator Judge Pangilinan. Senator Judge Soto III. Senator Judge Tulfo Erwin. Senator Judge Tulfo Rafi. Senator Judge Villanueva. Senator Judge Villar Camille. Senator Judge Villar Mark. Senator Judge Zubiri. The presiding officer, Senator Judge Escudero. The Senate President.
With 20 senators present, the chair declares the presence of a quorum. We now recognize the presiding officer, Senator Chis Escudero.
Thank you, Mr. Senate President. The reading of the Journal of July 6, 2026 of the Senate sitting as an impeachment court is hereby dispensed with, and unless there are any objections, the same is hereby approved and adopted. The clerk of court will now please read and call the case before this impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Zimmerman Duterte.
Appearances.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Noted. Appearances for the respondent.
Good morning, Your Honor. Same appearances for the defense.
Is the prosecution ready to call its first witness?
Yes, Your Honor. However, the prosecution have few concerns which it wanted to raise before the Honorable Impeachment Court. So may I request, Your Honor, that the Honorable Counsel for the prosecutor, Lorna P. Kapunan, be recognized, Your Honor.
Before recognizing the counsel for the prosecutor, ma'am, upo muna kayo. Chair would like to recognize first Senator Judge Lacson. What is the pleasure of the Honorable Lacson?
It's a point of inquiry, Mr.
You may proceed, sir.
Yes, Mr. Senate President, Mr. Presiding Officer, Your Honors. Just so it will be clear to our fellow Senator judges, as well as the panel of prosecutors, the defense team, and the public in general, yesterday after your election as presiding officer, you delivered your opening statement, portions of which I will either quote or paraphrase as follows. You stated, the Constitution states that conviction can only happen with the concurrence of 2/3 of all members of the Senate. And then you continued, with 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. However, you also made it clear that, and I quote, those who disagree have the right to go about it through a legal challenge and sue the Supreme Court by virtue of its power of judicial review, render a different ruling on this question. The impeachment court shall faithfully abide by that ruling, unquote. My point of inquiry, Mr. President, Mr. Presiding Officer, is this portion of your opening statement a matter of legal opinion on your part as presiding officer, or does it constitute a ruling by the impeachment court? If the response is, it is the latter, does this mean that this court, through the presiding officer, has raised the level of discourse to a justiciable issue or a dispute that the Supreme Court may have legal authority to settle and resolve? In case either one or both panels in front of us decide to exercise their right to challenge the said ruling, should they deem it as a grave abuse of discretion by this court? I submit, Your Honor.
The response of the presiding officer is in the affirmative. In fact, the journal that we just approved contains a similar inquiry by Senator Judge Cayetano yesterday when he inquired if it was the position and ruling of the presiding officer, and the presiding officer answered in the affirmative. So to clarify, yes, I believe it may be considered already as a justiciable controversy, although it is not for us to dictate that but the courts, given that it is a ruling of the chair not objected to nor appealed by any member of this court and therefore stands.
Thank you for the clarification, Mr. Presiding Officer.
Thank you, Senator Judge Lacson. Senator Judge Cayetano, what is your pleasure, sir?
Sir President, Presiding Officer, may I just further clarify this
You may
statement?
proceed, sir.
Yes. I confirm that yesterday we heard the same thing, and when the transcripts come out, of course, then it will be available to everyone. Basically, yesterday I clarified whether that was the opinion of the elected presiding officer, and of course, without any offense to my brother and friend, Senator Escudero, we have a continuing objection. I asked him whether this was already a ruling of the court, because if it's the ruling of the court, then as a threshold issue, we will have no further questions. Section 22, Article 22 of our rule says that all orders, decisions may be acted upon without objection, or if objection is heard, the orders and decisions shall be voted on without debate by ayes and nays, which shall be entered in the record, subject, however, to operation of Rule 6, and Rule 6 speaks of whether the presiding officer will rule on relevance, admissibility, and giving any movant 2 minutes. So I may also correct that yesterday I was not allowed to, when I objected to Senator Lacson, I should have been given 10 minutes in accordance with Section 22. But I do admit that before that, in the point of order, Senate President Gatchalian was liberal in allowing us to explain. Anyway, everything has been explained yesterday as the constitutional issue of the presiding officer, and since you allowed us to submit in writing, we will do so. But just on this point of the threshold issue of 2/3 of all members, there is actually a pending case in the Supreme Court entitled Cayetano versus Aquino. That is myself and my seatmate, Senator Aquino. We talked, but we're not talking about the case. So actually, you're correct, Senator Lacson, that anyone can go on this issue itself. And I just like to make sure today and further clarify that there's no objections, that as of today, the stand of the impeachment court is that of all members means that as long as you're still a member, so meaning when are you not a member anymore? When you die, when you are removed by finality, and when you resign. No? Otherwise, you are still a member, so you are still counted. And it is in that spirit that we ask, and we're preparing maybe a memoranda for all members to allow Senator Marcoleta and Senator Jinggoy, since they are going to have a vote. And if they are not allowed to vote, then that will be counted as a vote for acquittal. And that might be favorable to the defense rather than a part of giving a fair trial. So all I wanted to clarify today, Mr. President, is that we will continue to thresh out if there are any constitutional issues. But as of today, it is very clear that as a court, we have decided that 2/3 of 24, there are 24 members of the Senate today, 20 are present here today, but there are still 24 members, and 16 ang number of senators needed to convict on any of the articles, Mr. President. Mr. Presiding Officer, thank you.
What is the pleasure of Senator Judge Pangilinan?
21 na pala.
Thank you, Mr. Presiding Officer, Mr. Senate President. Just to place on record that I would like to clarify that the ruling of the chair of 16 is as to the issue of whether the threshold number of conviction. The matter of whether or not Senators Marcoleta and Senator Estrada should be participating in the process of the trial is another matter that we will have to discuss perhaps in camera or on the floor at a later date, Mr. President.
Noted. If there are no other senator judge who wishes to make a manifestation, the lead prosecutor, Representative Luistro, is once again recognized. What was your earlier manifestation and motion, ma'am?
Your Honor, we respectfully reiterate our request that counsel for the panel of prosecutors, Attorney Lorna Kapunan, be recognized.
Counsel for the panel of prosecutors, Attorney Lorna Kapunan, is recognized. Will you be the one to present the your first witness, ma'am?
Good afternoon, Your Honors, Senate President, Presiding Justice. I do have manifestation. Well, in direct answer to the query of the presiding Senator Judge, I am not presenting the witness today. But I would like, with your permission, Your Honors, to manifest a query that we request be addressed by this Honorable Court, Presiding Judge, to the defense.
The lady may proceed.
We are informed, and in fact, we have seen an interview conducted in the Senate premises on the Vice President herself. And she had been quoted as saying that she is expecting a bloodbath and a bludgeoning, but she will not, her head may be blooded but unbowed. My respectful query, Your Honors, please, which could be directed to the defense counsels, is if the Vice President is in the premises, does she intend to appear personally before this impeachment court? And that is preliminary to another manifestation that I would like to make. Your
Kindly
Honors,
proceed
please.
with your next one, counsel. Because the chair is not yet sure if it will even address this to the counsel for respondents or will simply answer the query of the counsel for respondents.
This is relevant to the presentation that we will be making this afternoon, Your Honors. This court will recall your own statements, Mr. Presiding Judge, that on Tuesdays, every Tuesday of every week, that the prosecution must indicate who the witnesses they intend to present before this court will be. This is to enable the impeachment court to issue, when appropriate, and if deemed necessary, a subpoena for such witness. And that is my query this afternoon, because an presentation of witness on the first article that we will be presenting, which is grave threats and acts of sedition, Your Honor. One of the key witnesses, hostile, albeit hostile, would be the Vice President. And therefore, if we can inquire if it is her intention to again appear in the premises of the Senate, because we are already respectfully informing this honorable court that we will manifest, that we will have a written request for her presence in connection with this article on grave threats, Your Honor. That is the relevancy of my manifestation.
The chair would like to rule on the manifestation and request of the counsel for prosecutors instead of throwing the question to the counsel for respondents, for the simple reason that I do not want to the parties to engage in a debate before this court. You can very well do that with the presentation of your witness through direct and cross-examination, redirect and recross. To answer, the impeachment rules do not mandate nor require the respondent to attend any hearing or trial of the impeachment court. Whether she was in the building earlier or arrived after, it is totally up to the respondent, because from the point of view of the court, she is represented in this court through her counsel already. Should the counsel for the prosecutors desire to call the respondent herself, The court will act on that motion and request once it is made and or filed, and need not make a ruling at this point in time. Because of course, when that motion is made, we will ask the counsel for respondent to make a comment and or reply.
Thank you, Sir Presiding Judge, Justice, Senator Judge. We yield to the wisdom of your decision.
Thank you, ma'am.
With that, we will reserve the right. We are not waiving the right to do call her at the appropriate time and to do file the appropriate request for subpoena ducis tecum and subpoena testificandum. On that matter, Your Honor, I have no further questions and would like to turn over the floor to our lead public prosecutor.
Thank you, Counsel
Your
for
Honor.
Prosecutors, Attorney Lorna Kapunan, for your remarks, which are duly noted. Yes, the lead prosecutor is recognized.
Your Honor, as manifested yesterday, the articles of impeachment is divided into 4 teams, and I would like to turn over to the head prosecutor of Article 4, that is threat, the Honorable Lawrence Defensor. May I request that he be recognized, Your Honor?
The member of the panel of prosecutors, Congressman the Honorable Lawrence Defensor, is recognized for his introduction of Article 4, I presume?
Thank you so much, Mr. Presiding Officer. May I be allowed to make a manifestation to introduce Article 4?
Before you proceed, Senator Judge Cayetano is recognized.
Before that, I ask for your indulgence from the prosecution and the defense. There are certain issues that we are more than willing to listen to the debate here. I'm speaking for myself, but I think for also other senator judges, and of course will give us much leeway. But there are certain issues that we also need time to study. So if we look at our rules of impeachment, suppletory kasi yung rules ng rules of court. And the difference between asking the accused to take the stand and asking someone who's not the accused, but we may say something that is incriminatory. There's a wide difference. So the accused, under the rules of court, hindi mo pwedeng i-force to take the stand. Pero yung hindi accused, they have to take the stand and wait for the question, and then they can claim the right against self-incrimination. But it could be argued that this isn't exactly a criminal court and a criminal offense. It's an impeachment court. So if it pleases the court, or if the prosecution is sure to ask for the subpoena, may I propose, Sir Presiding Officer, that both sides give us a memoranda in advance so that we can also do our part and study rather than spend much more time during the debates, because I'd really like to study that issue also. Thank you, and sorry for the interruption, Congressman.
Noted, Senator Cayetano. However, it is premature at this time. We will do what we did with respect to the motion for the issuance of subpoena ad testificandum and ducis tecum in regard to the bank accounts of the spouses Duterte and Carpio, as well as the AMLC records. We require the parties to submit a memoranda, and we will be scheduling it for oral arguments by the parties. If that is the desire of the Honorable Senator Judge Cayetano, we will do the same with respect to this once the motion has been filed formally by the panel of prosecutors. The Honorable Defensor is recognized. You may proceed, sir.
Thank you so much, Your Honor. Honorable Senator Judges, noong 22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan.
Sorry, excuse me.
Your Honor, may I be allowed to finish my manifestation? I will not disrespect and interrupt the defense counsel
Yes, but before
once he has started.
this is no disrespect, sir.
Counsel for respondent is recognized.
Thank you, Your Honor. Your Honor, this is improper. The improper for trial. Manifestation, this is not a manifestation proper for court procedure. This is instead them telling a story. This is a narration by the prosecution, which is not allowed. This is not allowed by any rule in any court. So what,
May I be allowed
what is
to reply?
proper is that they present their first witness, and
We
we
will
are
be
ready.
presenting our witness, Your Honor. However, please allow us to freely advocate our position.
That's why, Your Honor,
including
we are
the defense
objecting.
when it's their turn. We will not
Counsel, the
object to the
respondent,
same.
kindly let him finish.
Thank you, Your Honor.
Thank
to
you so
respond
much,
to
Your
you.
Honor.
To respond to you. Yes, you were saying.
Thank you, Honorable
Defensor.
Senator Judges. Noong ikadalawampung-dalawa
Honorable
ng
Defensor, kindly finish your reply to the
Thank you, Your
objection
Honor.
of
I will
counsel
proceed.
for respondent.
allow us to freely advocate our positions through the proper and respectful discourse. This is not prohibited under the rules. In fact, the court has declared that yesterday, the rules will not comply with the strict procedures of a judicial proceeding. Each article is a separate complaint, and it would be the proper guidance for the senator judges, lalo na po sa ating mga kapwa Pilipino na nanonood, para mas lalo nilang maunawaan ang ipipresenta naming ebidensya. The impeachment is a sui generis. Sui generis dahil kakaiba ito, hindi ito judicial, administrative, o civil o criminal proceeding. Hayaan niyo po kaming magbigyan ng 5 minuto para mailatag namin kung paano namin maipresenta at ang basihan namin sa pagpresenta ng aming ebidensya.
Your Honor, may I respond?
The presiding officer's rule. Although indeed we will interpret the rules liberally, and although indeed this is a sui generis proceeding, neither will we allow any dilatory moves and/or tactics, and I will bind and hold you to your 5 minutes, Honorable Defensor.
Absolutely,
and we
Your
will
Honor.
clock it.
Your Honor,
we will
may-
afford the same opportunity to the counsel for respondents when their turn arrives.
Thank you, Your Honor. May I proceed, Your Honor?
You may proceed.
Honorable Senator Judges, noong ika-22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan sa Tacloban City na ikinasawi ng 3 batang mag-aaral at ikinasugat ng marami pang iba. Ang mga salarin, mga minor de edad, sa kabila ng kanilang murang edad, agad na kumilos ang mga otoridad upang ipatubad ang mga umiiral na batas. Ang mensahe ay malinaw. Ang pagpigiging bata ay hindi nangangahulugang walang pananagutan. Ang pananagutan ay umiiral, pagamat iba ang paraan ng pagpapatupad nito sa ilalim ng batas. Kamakailan, isang pasahero ang inaresto sa airport at kinasuhan matapos itong magbiro na may bomba sa kanyang bagahe dahil mahigpit na ipinapatupad ng mga otoridad ang patakarang zero tolerance policy sa anumang pagbabanggit ng bomba o anumang pampasabog. Sa isang hiwalay na pangyayari noong Mayo 2020, isang public school teacher ang inaresto, pinusasan at kinasuhan ng NBI sa Zambales matapos magbiro na magbibigay ng pabuya sa sinumang papatay sa presidente ng Republika. Ano ang prinsipyo dito? Ang pananagutan ay pinapairal sa lahat, bata man o matanda, nasa laylayan man o nasa katungkulan. The prosecution comes before you today to present evidence for Article 4, establishing that Vice President Sara Zimmerman Duterte committed acts that betrayed the public trust, committed culpable violation of the Constitution, committed high crimes in publicly admitting through a live broadcast that she contracted someone to assassinate the President, the First Lady, and the former House Speaker. We acknowledge the burden of this trial on the senator judges as well as the Filipino people. But it is a duty that we must discharge together, lest the public come to believe that threatening public officials and fostering a culture of impunity are conduct that may be tolerated or condoned, especially coming from the second highest official of the land. Ang mga kilos at salita ng Vice Presidente ay hindi dapat ituring na simpleng krimen sa ilalim ng batas, kundi tuwirang paglabag sa saligang batas. Kaya ang paglilitis na ito ay mahalagang mekanismong itinakda upang tiyakin na ang kapangyarihan ay laging may kaakibat na pananagutan. Accountability must apply to all or none at all. At the heart of this impeachment proceeding lies a fundamental question para sa ating lahat. Can we continue to entrust one of the highest constitutional offices to a public official who, on multiple occasions, purposely and willfully and repeatedly resorted to threats of violence against the very institutions that she swore to uphold and protect? The evidence presented in this article are not just derived from testimonies and authenticated documents, but from the Vice President's own words, own conduct, her very own public admissions. Her words were neither accidental nor taken out of context. They were uttered publicly with the intention to be taken seriously. Huwag kang mag-alala, ma'am, sa security ko kasi may kinausap na ako na tao. At sinabi ko sa kanya na kapag pinatay ako, patayin mo si BBM,
Your Honor.
si Lisa Marcos, si Martin Romualdez. No joke. No joke. What makes these threats especially sinister is that they do not come from an ordinary citizen, but from the Vice President herself, an official who under the Constitution stands to succeed the President of the Republic. Such statements carry a gravity far from the exercise of one's freedom of expression. They strike at the very heart of government. This is especially significant given that she has publicly declared her intention to run for president in the next election. What values do we expect from those who occupy the highest office in the land? Delicadeza, palabra de honor, integrity, and loyalty to your oath of office. These are not outdated ideals. They are the foundations of honorable public office. Maraming salamat po, Your Honors.
The remarks of the gentleman are duly noted. However, Chair would like to inform and instruct the Senator judges that the statement and manifestation made by the Honorable Defensor should not in any way be taken as evidentiary because it was merely a manifestation cum introduction of the fourth article of impeachment. Any evidence to be presented proving the fourth article of impeachment should be done through a witness under oath, duly subscribed, and subjected to direct and cross-examination. Call your first witness, sir.
Your Honor, may I be allowed also to... Your Honor, we move to strike that opening statement. It's improper for trial. It is not evidentiary in nature. And it only provides conclusions of fact and law. Most of it is irrelevant. And fact of the matter is the prosecution should present evidence and not manifest in this improper manner.
May I be recognized, Your Honor?
No need. Motion is denied. Let it remain in the records and as instructed by the chair for the senator judges not to deem whatever statements were given by the Honorable Defensor as evidentiary in any way, shape, size, or form. Again, counsel, call your first witness.
Your Honor, may I request permission to recognize counsel for the panel of prosecutors, Attorney Virgil Ligutan, to conduct the examination of our first witness.
Your Honor,
he will
may
be
I-
under the direct suspension
Counsel
and
for
control
respondent, what is your pleasure?
of
Your
the
Honor,
panel
may
of
I
prosecutors.
register my continuing objection to the opening statement by the prosecution.
Well, I don't think he'll do it again, but nevertheless, so noted.
Thank you, Your
Thank
Honor.
you. Your Honor, may I request that Attorney Virgil Ligutan be recognized to conduct the examination of our first witness.
Counsel for prosecutors, Attorney Virgil Likutan, so that we can have the records clear. Did I pronounce your name correctly, sir?
Your Honors, magandang hapon. My full name is Attorney Armando Virgil Discartin Ligutan, Your Honor, please.
And you've entered your appearance yesterday,
Yes,
counsel?
Your Honor. Duly entered my appearance as one of the counsel for the prosecution.
You may proceed, sir. Call your
Thank
first
you
witness.
Thank you so much. Mga kababayan, we call to the witness stand the first witness for the prosecution in the person of NBI Senior Agents Jean-Marc Santa Ana Calilo.
Kindly bring the witness to the witness stand. Please remain standing. Clerk of Court is instructed to kindly administer the oath to the witness.
Please raise your right hand. You, John Mark Calilong,
I, John Mark Calilong,
do swear
who swear
that the evidence you shall give
that evidence that I give
in the case now pending
is in the case now pending
between the Philippines
in the Philippines
and Vice President Sara Zimmerman Duterte
and Vice President Sara Zimmerman Duterte
shall be the truth,
the truth,
the whole truth, and nothing but the truth.
and nothing but the
So
truth.
help me God.
So help me God.
Your witness, counsel.
Thank you so much, Your Honors. Your Honors, mga kababayan, the testimony of the first witness for the prosecution, NBI Senior Agent Jean-Marc Santa Ana Calilo, is offered to prove the following. Number one, si Agent Jean-Marc Calilong ay isang senior agent of the National Bureau of Investigation. Number two, he is well-trained and experienced in the field of digital forensic examination, having undergone extensive training in the field, making him competent in identifying, preserving, collecting, and authenticating digital evidence. Pangatlo, si Agent Calilong ay bahagi ng NBI Cybercrime Division Team na inatasang mag-imbestiga sa mga pahayag at pagbabanta ng Vice Presidente laban sa Pangulo ng Pilipinas, Unang Ginang, at dating Speaker ng House of Representatives sa isang online media briefing noong Nobyembre 23, taong 2024, pang-apat. Partikular na sinabi sa publiko ng Vice Presidente na may kinontrata na siyang tao na papatay sa Pangulo, Unang Ginang at former Speaker ng House of Representatives. At ito ay nakatatak na sa kasaysayan ng ating bansa bilang unang pagkakataon na ang isang Vice Presidente ay nakipagkontrata sa isang mamamatay tao upang patayin no less than the President of the Republic of the Philippines. Panglima.
Your Honor, may I object. Is this a speech or an offer?
Your Honor, please, with all due respect to counsel,
For the prosecutor may proceed.
it should not be a
May I register my continuing
There's
objection?
no proper ground. This is offer of testimony. Please hold your horses. Number 5, the public statements and threats of the Vice President were publicly live streamed and captured on video. Number 6, Agent Calilong is a designated agent on case for the investigation. Number 7, as agents on case, Agent Calilong personally conducted and participated in the cybercrime and open source investigation relating to the subject video and related digital recordings. Pangwalo, sa takbo ng open source investigation na pag-alaman ng NBI na ang Vice Presidente ay nagpahayag din ng iba pang kahawig na pananakot sa buhay ng Pangulo. Kasama na ang sinabi niya sa publiko na minsan naisip niyang pugutan ng ulo ang Pangulo ng Republika ng Pilipinas. Number 9, in the course of the investigation, Agent Calilong duly identified, preserved, collected, and authenticated the subject video and other related digital recordings. At number 10, the last offer of testimony, Your Honors, Agent Calilong will testify on such other matters as may be relevant, material, incidental to the issues involved in this impeachment proceeding, and will identify relevant and material, documentary, and object pieces of evidence. That is the offer of testimony of our first witness, Your Honor, please.
Presiding officer will now hear the objection and or comments, if any, of the counsel for respondent to the offer made by counsel for the prosecution.
Your Honor, may we move for the exclusion of Agent Calilong for being not previously attached to the Saballa and Cabrera complaints, as well as exclusion on the ground that he was not included in the articles of impeachment transmitted to the Senate Impeachment Court.
Can I respond to that, Your Honor, please?
Counsel for prosecutor may do so.
Mga kababayan, in this stage of the proceedings, the prosecution is about to present a witness, and the defense is invoking the fact that this witness is not listed as one of the witnesses in the Saballa complaint. The Saballa complaint already lived its natural life. Your Honor, this is the impeachment proceeding of the articles of impeachment filed by the House of Representatives. Saballa et al. Is done. That should not be a proper objection, Your Honor, please. As to the number 2, I think the good counsel mentioned that it is not part, this witness is not part of the articles of impeachment. Your Honor, please, I have been practicing for quite some time. I don't see that.
Your Honor, may I allow to reply also?
Can I finish? It's not a ground. And in fact, Your Honor, please, to settle the matter, this witness is listed in the pretrial order. The issue is settled. The issue is passé. No ground for objection. Let me proceed, Your Honor.
Of course not, Your Honor. There were no rulings.
Counsel for respondent is recognized
Thank you,
for
Your
a
Honor.
final rebuttal on this issue before the chair will issue a ruling.
Your Honor, there were no rulings on the pretrial order on exclusion of witnesses. We have a current petition with the Supreme Court questioning the very actions of the prosecution to allow the presentation of evidence that were not attached to the Saballa or Cabrera impeachment complaints would allow the House of Representatives and the prosecution to circumvent the very procedural abuse condemned in Stonehill versus Jokno and allow the violation of the respondent's constitutional rights as held in Duterte in the House of, versus the House of Representatives. Your Honor, the prosecution says the Saballa complaints have lived their and they died their natural deaths. However, Your Honor, this precisely does not cure what the prosecution did. This does not cure the violation of the rights of my client.
If I may, Your Honor, please.
The chair will make its ruling. The motion to exclude by the counsel for respondent is hereby denied. Chair cites Enrile versus Sandigan Bayan, which states that the prosecutors may add or rely on evidence during pretrial, even if the evidence is not stated in the complaint or articles, because only a summary is required to be stated in the articles of impeachment, in this case, and or complaint, and not a complete list of the prosecution's evidence and or witnesses. The court in general will not shackle the prosecution by limiting it to the evidence mentioned in the information and or the articles, especially when it is mentioned in the pretrial brief, not only order but brief, of the Counsel for Prosecutors. But in relation to this witness, even if you will do cross, you can register your continuing objection, Counsel for Respondent.
We are registering it, Your Honor, please.
So noted. Counsel for the prosecution may proceed.
Thank you so much, Your Honor. John Mark Calilong.
Your Honor, may I register my objections to the purposes?
Your Honor, please, I think the purposes must be specified. What are your objections?
Exactly,
On what
Your Honor.
grounds?
May I be
You
allowed?
may comment on the offer of the testimony of this witness for the record.
Your Honor, for the purpose number 3, this is a conclusion of fact and law. For the fourth purpose, it is also a conclusion of fact and law. And the 8th purpose, it is a conclusion of fact and law.
Mr. President.
Counsel for
President.
Respondent. Before we, yes,
No,
Senator Judge Cayetano.
Yeah.
Pia.
I would just like the defense, when you say item number 3, can you repeat what it is? Because I'm trying to follow exactly what your objection is. So either you say it or he repeats it so we can follow.
I was about to do that actually.
Thank you.
Item number 3 in the offer of this witness is that the NBI agent being presented is part of its cybercrime unit that investigated this matter. That's what you're referring to as a conclusion of law, Counsel?
Sorry,
Perhaps number 4.
Number 4, Your Honor.
Yes, not number 3. So number 4 and what else?
Number 8, Your Honor.
Number 8 on other threats other than the video mentioned in the press briefing. Yes.
Yes, Your Honor. Correct, Your Honor.
Would that be all?
Yes, Your Honor.
We will not
Duly
reply.
noted.
We will not reply to that, Your Honor, please.
Yes, please.
May I continue, Your Honor, please?
You may continue to
John
present
Mark.
your first witness, Counsel.
Thank you so much, Mr. Calilong. Reminder, nakikinig yung taong bayan, pakilakasan ng boses. Okay?
Apo.
Okay. Mr. Witness, maaari bang sabihin mo ano yung pangalan, edad, at other personal circumstances?
I am Senior Agent John Mark Calilong, a Filipino citizen, 31 years old, with office address at NBI Philinvest Cyber Zone Bay City, Macapagal Boulevard, Pasay City, sir.
And Mr. Witness, reminder, you may answer in Filipino or Tagalog or Filipino or English, okay?
Yes.
Mr. Witness, what is your occupation, if any?
Currently, nasa National Bureau of Investigation po ako. I'm an agent since 2021 and was recently assigned at Cyber Investigation and Assessment Center in April 2026.
Okay, you said that you have been an agent of the NBI since 2021, pero you were recently assigned to the Cybercrime Investigation and Assessment Center of the NBI. Now, ano ba yung position mo before you were assigned to the Cybercrime Investigation and Assessment Center, kung meron man?
In 2022, I was assigned at Digital Forensic Laboratory Division and in 2024 in Cybercrime Division, sir.
Okay, now, you said that you were assigned to the Digital Forensics Laboratory Division in 2022. Now, yung tanong, ano ba yung mga naging primary duties and functions mo bilang ahente ng division na yan?
In digital forensic, my primary duties is to identify, preserve, collect, analyze, and present digital evidence in court, sir.
Now, preliminary question, have you undergone any training as an agent of that Digital Forensics Laboratory Division?
Yes, sir.
Now, kung alam mo, ano ba yung naging trainings in that division?
I have undergone computer hacking forensic investigation training, mobile forensics, computer forensics, and photo and video authentication training, sir.
Okay, so the last part of your answer, Mr. Witness, you mentioned that you were trained, na sinasabi mo, into photo and video authentication. Now, specifically now, ano ba yung naging trainings in that regard? Photo and video authentication, kung meron man.
I was trained for 2 weeks intensive training in July 2022 by MaxCore Intervention, sir, in digital forensic.
Now, sabi mo, ano nga ba yun? 2 weeks of intensive training. Yung tanong, Mr. Witness, specifically, what happened in that you said 2 weeks of intensive training?
I was trained to perform digital forensics examination, sir.
Now, Mr. Witness, you tell the public, what is the objective, if any? What is the objective, if any, if you know, of that digital forensic examination that you said you were trained to do?
To present digital evidence, sir, admissible in court na ginawa ko na po multiple times.
Multiple times. You appeared in court multiple times. Specifically, how many times?
At least 30 times, sir.
And for how long have you been practicing digital forensic examination?
2 years, sir.
For 2 years. Now, let's go back, Mr. Witness. You mentioned that you were an agent of the NBI Cybercrime Division in 2024. Now, what were your primary duties and functions as an agent of that Cybercrime Division?
To investigate cases in violation to the cybercrime law, sir.
Cybercrime law. Now, Mr. Witness, you are testifying in this impeachment case proceeding trial against the Vice President, the respondent in this case. Do you know the respondent in this case?
Yes, sir.
And why do you know the respondent in this case?
Because she is the Vice President and my team conducted an investigation involving her, sir.
So aside from being the Vice President, your team, you said, investigated the Vice President. The question now is, what was this investigation, if you know?
It's an investigation on the statement uttered by the Vice President during an online press conference briefing dated November 23, 2024.
So statements uttered by the Vice Presidents in an online live stream press conference held on November 23, 2024. Now, yung tanong, ano ba yung naging participation mo, Mr. Witness, kung meron man?
I am the agent on case of the investigation, sir.
Now, sinabi mo ikaw yung agent on case. Now, you tell the court, you tell the public, ano ba yung pagiging ahente on the case? Ano bang ibig sabihin yan kung alam mo?
It means that I gathered evidence necessary for the investigation, sir.
Okay. You mentioned you gathered evidence. Now, you tell us, what do you mean kung meron man, tsaka kung alam mo, ano bang ibig sabihin when you quote, gathered evidence, unquote?
It means that I viewed, identified, preserved, collected, and authenticated digital evidence in the course of the investigation, sir.
Okay, now, you mentioned na you viewed, identified, preserved, collected, authenticated, sinasabi mo mga pieces of evidence that you found in the course of your investigation. Tama ba?
Yes, sir.
Now, Mr. Witness, yung tanong is, ano ba yung mga ebidensya na nakalap ng inyong team?
One of the pieces of evidence that we gathered during our investigation is the video of the November 23, 2024 online press conference held by the Office of the Vice President, which was posted on the Facebook page of Harry Roque, sir.
Facebook page of whom?
Harry Roque, sir.
Harry Roque. Okay.
Yes, sir.
Mr. Witness, sinabi mo, you gathered. When then sinabi mo kanina, pag sinabing gathered evidence, sinabi mo, you viewed, identified, preserved, collected, and authenticated. Preserved, collected, and authenticated. You mentioned the term preserved, correct? Mr. Witness, yung tanong now is, ano ba ang ibig sabihin when you quote, preserved, unquote the evidence?
It means that I ensured that the evidence will be accessible at any time, sir.
Okay, now, let's go to this video you mentioned. The video of sinasabi mo yung isang online media briefing ng Vice President noong November 23, 2024. Ano ba yung mga hakbang, kung meron man, na ginawa nyo to preserve that video?
The NBI Cybercrime Division, through me, initiated a preservation request po kay Meta.
Okay, you initiated a preservation request to Meta. Now, sinabi mo kanina na live stream yung subject video sa isang Facebook page ng isang Harry Roque, di ba? Now, yung tanong, why is it that your request was made to Meta?
Si Meta po kasi yung parent company po ng Facebook. At under po ng Meta si Facebook, si Instagram, tsaka si WhatsApp. All requests on that platform will go to Meta po.
Alright, now, Mr. Witness, what proof, if any, do you have that you initiated a preservation request to Meta in order to preserve the subject video?
I have a screenshot of the preservation request, a screenshot of the web page wherein I made the preservation request, sir.
Who took the screenshot?
I did, sir, and I used my laptop.
Anong ginawa mo sa screenshot kung meron man pagkatapos dyan?
I first saved po yung electronic copy sa laptop ko, then printed it.
Where is this print out of the screenshot now?
Sinubmit ko po sa Committee on Justice of House of Representatives.
Your Honor, with the court's indulgence, may I move that this representation be assisted by a co-counsel for the sole reason of facilitating the presentation of the documents to the witness, Your Honor, please. For that reason alone.
Sa Tagalog siya mag-aabot.
Yes, Your Honor. Siya po yung mag-aabot ng mga dokumento na amin pong ipapakita for the witness to identify po.
Counsel may proceed.
Thank you so much. Assisted by Attorney Stephen Magallon. Now, if this printout is shown to you, will you be able to identify the same?
Yes, sir.
Now, we invite the defense to also peruse the document.
Your Honor, may I request that one of our counsels be allowed to peruse the document?
Yes, one of the
Thank you.
counsels for respondent may look at the document being presented to the witness.
May I continue, Your Honor, please? Thank you. Now I'm showing you. Defense, can we give the document to the witness, please? Your Honor, the document must be presented to the witness.
Your Honor,
Give them some time to look at it. But is this one of the documents pre-marked?
Yes, Your Honor, please.
For the record, can you state the pre-marking of this document just so that we can catch up?
Much obliged, Your Honor, please. That would be P dash Roman numeral 4 dash 7 for the prosecution, Your Honor, please.
Noted.
Your Honor, may I manifest for the record that this is not a certified true copy?
Oh.
Noted.
Your Honor, can I respond to that, Your Honor, please? This is an electronic copy. The rules on electronic evidence says a printed version of an electronic copy is an original. Your Honor, please.
Counsel for the prosecutor, counsel for respondent did not object. He just simply made an observation regarding the document. So you may proceed as soon as the document is returned to the witness.
Thank you so much, Your Honor, please. What relation? Mr. Witness, are we ready? What relation, if any, does this document have with the printout of the screenshot that you mentioned?
This is the copy of the printout that was submitted to the Committee on Justice, sir.
Okay, Your Honor, please, may I proceed with the next question, please? Question, Mr. Witness, how faithful, if at all, is this printout from the actual screenshots?
The printout accurately reflects the screenshot, sir.
And how do you know now that this printout accurately reflects the screenshot?
I compared the printout with the screenshot and with the web page of my preservation and found that the contents are identical, sir.
Thank you so much. Now, Mr. Witness, ano ba ang nangyari kung meron man? At kung alam mo, after you made excuse me. After you made the preservation to request to Meta in relation to the investigation you did on the Vice President?
Meta acknowledge our preservation request, sir.
Okay. Your Honor, please, the exhibits as they come, as they are identified by the witness, are also simultaneously being presented on the screen, Your Honor, please. Okay. You said that Meta acknowledged the preservation request, correct?
Yes, sir.
Now, yung tanong ay ano bang pruweba mo? Kung meron man, that's in fact, Meta acknowledged the request.
I have a screenshot of the acknowledgement of Meta email acknowledgement.
Now, who took the screenshot?
I did, sir, and I used my laptop.
What did you do with the screenshot kung meron man?
Sinave ko muna po yung electronic copy ng screenshot sa laptop ko and printed it.
Where is the printout of the screenshot?
Sinubmit ko po sa Committee on Justice of House of Representatives.
Now, kung yung printout ng screenshot ipapakita sa'yo, will you be able to identify the same?
Yes, sir.
Now, we are now in the process of showing you yung isang printout ng isang screenshot ng isang tugon o reply ng Meta, Your Honor, that is previously marked as Exhibit P-Roman numeral 4-8 for the prosecution.
Your Honor, may I have time to peruse?
Kindly show the document to one of the counsels for the respondent.
Your Honor, we note that the Exhibit P-I-IU-8 is not an original or certified true copy, and we object to the introduction of this and the identification of this.
What does counsel for the prosecution say?
Again, I reiterate, if it is a printout of an electronic document, the rules are clear, that is an original, Your Honor.
Your Honor, if you look at it, there's on the bottom left-hand portion, there is a mark, certified true copy. This certified true copy would not have appeared in any correspondence with no reply at records.facebook.com. So it is not a printout. It's not an original. Would not reflect what accurately was printed out or appeared on the screen.
2
What
points.
does counsel for the prosecutor say?
2 points, Your Honor, please. Settled now, 2019, assuming that the counsel is correct. Photocopy now is considered as an original, Your Honor, please. And number 2, Your Honor, please. With all due respect, presentation of evidence, objection to the admissibility of object and documentary evidence happens when the documents are formally offered in evidence. We are just in the process, Your Honor, please, of presenting this evidence. So therefore, the defense may object thereto when we formally offer the exhibits, Your Honor, please, and that's not happening yet.
Your Honor,
As a last point, counsel for respondent,
Thank you, Your
before the
Honor.
chair makes a ruling.
Your Honor, true that photocopies are now considered originals. However, the photocopy must be an accurate and exact reproduction of that original or that printout. This, Your Honor, may I read it for the record? In the bottom left-hand copy, it says certified true copy, NBI-cybercrime, signed Safira T, date 4/10/26. Is counsel for the prosecution telling us now that this marking came from Meta, the email of Meta, of Facebook?
Again,
Kindly respond, counsel, before the chair makes a ruling. I'm interested to hear your response as well.
I'm so sorry. Could you repeat the question, please?
It was rhetorical, Your Honor. He need not answer.
He was basically questioning the fact that if it indeed came from Meta and is a computer printout, why the need for someone to certify it as a true copy?
I do recall, Your Honor, please, that was submitted to the Committee on Justice. Along the way, there was a need to certify that, Your Honor, please. But be that as it may, certification of a printout of an electronic document is not even necessary, Your Honor, please.
The objection of the counsel for respondent is overruled. With the counsel may proceed.
Thank you so much,
He
Your Honor.
may
Please.
raise his objection at the proper time when formal offer is made of documentary evidence, and any correction may be made thereafter, or rather before that, by the counsel for the prosecutors.
All right.
Please proceed.
Thank you so much. Mr. Witness, you mentioned that Meta, you said, acknowledged the preservation requests. Sorry, Your Honor, please. I recall the last question. I have to proceed to presentation of the documents. Now, Mr. Witness, if this printout of the screenshot of Meta's reply is shown to you, will you be able to identify the same?
Yes, sir.
Now, what relation, if any, does that document have with the printout that you mentioned earlier?
This is the printout that I submitted, sir.
Now, Mr. Witness, Your Honor, please, again, as previously manifested, the documents identified by the witness has been previously marked as Exhibit P-4-8 for the prosecution. Okay, how faithful, if at all, is this printout from the actual screenshot?
The printout accurately reflects the screenshot, sir.
And how do you know that this printout accurately reflects the screenshot?
I compared the screenshot with the printout and the email confirmation of Meta and found that the contents are identical, sir.
Okay. Now, Mr. Witness, you mentioned that Meta quotes acknowledged, unquote, the preservation requests. Now, based on your experience, and if you know, ano ba ang ibig sabihin kung yung Meta nag-a-acknowledge ng isang preservation requests?
Objection, Your Honor. He would be incompetent to say that.
Your Honor, please.
Counsel for the prosecution, what do you say?
Your Honor, please. This is an NBI agent that has been practicing digital forensics for 2 years, appearing in court for 30 times, and underwent training for 2 weeks. No other person in this room is more competent to answer the question than this witness. Let the witness answer.
Nevertheless, Your Honor, he's incompetent. He is not from Meta. He doesn't know Meta procedures. The mere fact that he's an NBA agent doesn't make him competent.
Can I reply to that, Your Honor, please?
Overruled. Chair will allow it. If the witness knows, he may reply. If he does not know, he should so admit also. Witness may answer.
It means that Meta have taken necessary action to preserve the evidence, sir, and assign a case number on it.
So took reasonable steps to preserve and assigned a case number. Now, yung question now is, after receiving this acknowledgement from Meta, ano ba yung ginawa mo kung meron man, in relation to the investigation you conducted on the statements of the Vice President?
I further preserve the video and authenticate the same, sir.
All right, so you said you...
With the permission of the counsel for the prosecutors, Mr. Witness, what do you mean by Meta assigned a case number to it? What does that exactly mean?
It means that yun po, they have taken reasonable action. Yung case number po is for monitoring namin kasi multiple multiple requests po from different investigation. Yung case number na yun for specific request po.
So pag may request kayo sa Metang i-preserve ang isang digital footprint o data, lalagyan nila ng case number?
Yes po.
Lahat ngayon na magre-request na i-preserve yon, ilalagay sa ilalim ng case number na yan yung mga request?
Hindi po. Per request po yung case number.
So each request will have a separate case number from Meta?
Yes, Your Honor.
And the case number for this one would be what?
9116154, Your Honor.
Saan po nakasulat yon?
Your case number is 91, nasa upper part po, Your Honor.
9111654?
Yes, Your Honor.
You may proceed, counsel. Thank you.
Thank you so much. Mr. Witness, you said that you proceeded to further preserve and authenticate the subject video. Now, let's go to that proceeded to further evidence. What does it entail, if any, and if you know?
It means that I further preserve it using a screen recording, open source broadcast software studio, OBS. I screen record what appears on my screen, the video, the online live stream November 23, 2024, from beginning to end, including its URL.
Okay, now, what about authenticating the video? Ano bang ibig sabihin yan kung alam mo?
After screen recording, there's an output video. I compared the output video with the November 23, 2024 video and ensured that the contents are identical. After ensuring that the contents are identical, I now generated a hash value calculation on the video to ensure that the video won't be tampered until presented in court, sir.
Mr. Witness, ano ba yung pruweba mo kung meron man that you authenticated the subject video?
I have executed an affidavit of authentication of digital evidence dated January 30, 2025, sir.
Okay now, kung yung affidavit of authentication of digital evidence dated January 30, 2025, ipapakita sa iyo, will you be able to identify the same?
Yes, sir.
Now, in the process, or the prosecution is in the process of confronting the witness with a document that is previously marked as Exhibit P-Roman numeral 4-9 and series, constituting of 29 pages, including the attachments. Your Honor, please, the defense is invited to peruse the documents. Okay.
Firma. Hindi yan naka.
Your Honor, we object to the introduction of this affidavit of authentication. This is not an original copy of his affidavit. This is not electronic evidence. And if you look at the affidavit, even the appendages, which supposedly consist of USBs and CD, there's no USB, there's no CD, and even the signatures are not wet signatures, Your Honor.
What does counsel for the
Your Honor,
prosecution
please,
say?
we will not comment to that, subject to the proper response to that when the time comes in the formal offer of exhibit, Your Honor, please.
Your Honor,
The objection of the counsel for respondent is noted as to the admissibility of the offered document. However, as correctly pointed out by counsel for the prosecution, the proper time to object to the same and for the court to rule on it would be during formal offer, once the prosecution has already rested its case. So ordered.
Thank you so much, Your Honor, please. Mr. Witness, what relation, if any, does that document have with the affidavit that you mentioned?
Your Honor, may I just make a quick manifestation?
Counsel for the respondent. Yes, you may, sir. Please
Your
proceed.
Honor, during pretrial, the parties got together and agreed that originals of the documents that were to be marked will be presented during trial. We agreed to expedite the proceedings. And now, what is happening is photocopies of documents that we want to peruse and see are being presented. So we object to this, Your Honor.
If I may, can I reply? Sorry, I'm so sorry.
The
Your Honor, please.
manifestation of the counsel for respondent is duly noted.
Thank you so much, Your Honor.
Please proceed, counsel for the prosecution.
On page 3 of the affidavit of authentication of digital evidence, may makikita dyan yung isang pirma sa ibabaw ng pangalang John Mark Calilong. Do you see it?
Yes, sir.
Yung tanong now is, whose signature is that if you know?
This is my signature, sir.
Your Honor, at this juncture, Your Honor, please, despite the prosecution's understanding that a photocopy is now the original, is now considered as an original, but to address the concerns of the defense, Your Honor, please, I move that we be allowed to present the original of the documents that was confronted, that the witness was confronted with. Sorry, it's a certified true copy of the affidavit of authentication, Your Honor, please.
Counsel may proceed.
Okay, now, you mentioned, so I will go back. Now, Mr.
Without prejudice to the counsel for respondent viewing the same
Yes.
with respect to its certification.
Affidavit of authentication of digital evidence dated January 30, 2025. Now, so that it's a certified true copy, correct? Now, we are confronting you now with a certified true copy of the same document. After perusing the same, you have to tell us what relation, if any, do the documents before you have with the documents, affidavit of authentication of digital evidence that you mentioned.
Your Honor.
Yes, counsel for respondent.
We'll finish perusing, Your Honor. $91 na yun.
Let's confront them with the secret. Let's confront the secret. Let's confront them with the original.
Sorry, not found.
Yeah, I will. That's it. Yes. Yeah. Huh? Yeah, I know. Stephen, can I ask somebody else? Shane, can you also help? Huh? Yeah.
Your Honor, for
Yes, counsel for the respondent.
thank you, Your Honor.
You may proceed, sir, for your comments.
Sir, for Your Honor, for P-I, P-4-9H. Your Honor, there is a CD in the original. Oh. 9-4, Ben. 9-4.
Careful.
9-4. Just look at the original.
Counsel, what are you referring to again? P dash.
P dash.
P dash 4 dash 9 what?
Ano siya?
Ito. Before that. Before that. Yeah.
P
Before
dash.
That. No, before that. Attorney, may natanggal lang yung ano nyo. Is this the same ano? Sequence. Sige, punta ka sa C muna. Hanapin mo yung C. C. Dito. Hindi, ito bro. Okay, next page.
Iyan.
Hindi. Okay, next page. Next page. Okay, next page. Okay, next. Yeah, so spot the difference.
Your Honor, for P-4-9H, in the original, there's a marking, November 23. And in the photocopy, it is only a photocopy of the CD, Your Honor. So there's a difference.
Noted.
You can reply to that, Your Honor, please.
Counsel, for let's get all of his comments first.
The page after is already a USB.
Your Honor, the page after in the original is a USB, which is Annex E-1
However,
with markings October 18, 2024 video CL PPS 182. However, in the photocopy, there is no such photocopy, the marked photocopy, there's no such thing.
so the order is no longer the same moving forward.
So the order is no longer the same moving forward, Your Honor.
Yeah, that's it.
Even in that very same one, which I assume is P-4-9K, does not have any date marking, Your Honor.
It's not the same
So
document, the conclusion.
it is not the same document. It's not faithful reproduction of anything, Your Honor.
The photocopy is not a faithful reproduction of the certified true copy. That's what you're stating.
Yes, Your Honor.
What does the counsel for the prosecution say?
Your Honor, counter manifestation that the documents that the defense are perusing have been identified by the very person who authenticated and who executed that exhibit. So, Your Honor, please, we move that the comments of the defense be noted, Your Honor, please.
Your Honor, that's irrelevant. What we're saying is that this is not the copy mark. It is not the same as the original, which he says it's the same thing which is identified. What he's saying is off tangent. What he identified earlier, which is the marked copy, which is the copy marked during pretrial, is not the same document as they are passing on as an original. Your Honor, this is the
Counsel
issue
for
here.
respondent. That is a proper subject matter too for your cross to point, if at all, the distinction and difference between the two copies, which counsel for the prosecution can use as a subject matter for his redirect.
Thank you, Your Honor.
Because you can confront the witness with respect to the certified true copy that is different from what he identified earlier, impugning, if at all, his credibility as a witness in this case.
Thank you so much. Your
So
Honor, please.
we note the comments and observations of the counsel for the respondent. I got lost. So it's being reviewed and has not yet been given to the witness, right?
Your Honor, may I just register our continuing objection?
So noted and so registered.
Thank you so much. Can we proceed?
Before we proceed, the presiding officer was not there during pretrial. As manifested by the counsel for respondent, was there indeed such an agreement that the originals will be presented during the trial
Yes, Your Honor.
by both parties? Can the counsel for the prosecutors also confirm that?
Your Honor, please, we do not confirm. I conferred with my team, the team who actually participated in the marking for Article 4. Your Honor, please. Be that as it may, Your Honor, please, we would like to put into record certain realities of the law. A photocopy is now considered as an original. 2019 amendments in the Rules and Evidence. Number 2, Your Honor, please. This is the person who authenticated the documents. So there's no other person who is competent to testify as to the veracity of those documents other than the witness.
Your Honor,
please.
that's only a
So you do not
conclusion, Your Honor.
confirm?
No,
You
Your
do
Honor,
not
please.
confirm such an agreement during pretrial?
We do not confirm that, Your Honor, please.
So, Chair would like to advise the parties. The court understands the exceptions to the original document rule and will so implement the rules in that regard. However, if it does not fall under the original document rule exceptions, then to save on the court's time, the party presenting the document should present the original during trial to avoid what we are seeing now. Perhaps in the next time you present a witness, counsel
Yes,
for the
Your Honor, please.
prosecutors and counsel for respondents.
We will, Your Honor.
We appreciate that, Your Honor, please. We understand that would be for the next presentation.
For the next one. Please
Thank
proceed.
you so much. Are we done now? We move, Your Honor, please, that
Your
the...
Honor, may
sorry.
may I request that he not also address me directly?
So ordered, so instructed. Kindly address all of your queries and statements to the presiding officer and use the third person when referring to your fellow counsel for the other party.
Much obliged, Your Honor, please. We move, Your Honor, please, that the marking in the affidavit of authentication of digital evidence that was previously identified by the witness, a photocopy, the markings of the same be transposed, Your Honor, please, to the documents that this witness is being confronted with at present, Your Honor, please.
We object to this, Your Honor. This is precisely our earlier objection. They're marking a new document. That's why they're asking that it be marked again, which defeats the very purpose of our pretrial.
If I may
the
reply, Your Honor, please. So
Your Honor,
can I continue?
Kindly
I wasn't
allow
done.
the counsel for the prosecution to speak.
So the hearing will proceed, Your Honor, please. I will withdraw that motion. We will stand by the presentation, the photocopy allowed by the rules and identified by the witness who actually executed the affidavit. May proceed, Your Honor, please.
I hope this satisfies counsel for respondent. You may proceed, sir.
Thank you so much, Your Honor. Now, Mr. Witness, on page 3, sa pahinang number 3 of the affidavit of authentication of digital evidence, may makikitang isang pirma sa ibabaw ng pangalang Agent John Mark Calilong. Now, yung tanong, kaninong pirma ba ito kung alam mo?
Pirma ko po, sir.
Now, sa page 4 ng nasabing affidavit of authentication of digital evidence, may makikita din na isang pirma, okay, sa ibabaw ng pangalang Attorney Jeremy C. Lotok. Now, kaninong pirma ito kung alam mo?
Pirma po ni Attorney Lotok.
Now, how do you know that it is the signature of Attorney Lotok?
Nakita ko pong pinirmahan niya yung document. At may mga document po ako na nakita at enacted upon na bearing his signature, kaya familiar po ako.
Thank you so much. Your Honor, please, we proceed. Mr. Witness, now, what action did you perform, if any, after you authenticated the subject video in relation to the investigation you conducted on the statements of the Vice Presidents?
I first saved the video on my laptop and save a copy of the video on a DVD and a flash drive.
Okay, now you mentioned that you saved a copy in a flash drive. Mr. Witness, kung yung flash drive ipapakita sa iyo, will you be able to identify the same?
Objection,
Yes,
Your
sir.
Honor. We object.
What is the objection of the counsel for
The
respondent?
document identified by the by the witness was the photocopy, and the appended there's no flash drive, CD, or anything appended upon that. So there's nothing, no foundation for this question.
I have to reply to that, Your Honor, please. This is a
By counsel for the prosecution.
This is a non-issue. I asked the witness, what did he do after saving the video? And he said he saved it in a flash drive without referring to any document attached to the affidavit of authentication. Basis is laid, Your Honor, please. This is a non-issue. We may proceed, Your Honor, please.
Your
Besides
Honor,
counsel,
may I
counsel
respond?
for the respondent. This is not a surprise. This was flash drives. Several flash drives were pre-marked during the pre-trial.
Your Honor, may I reply first before?
I believe 7 on the part of the prosecution and several on the part of the respondent too. But you may proceed, sir.
Your Honor, that is not my objection. My objection is the very basis upon which the witness introduced this flash drive was the affidavit. The affidavit. And there was no affidavit upon the there was no attachment upon the affidavit which they introduced. So the very questions that he has do not have any foundation.
No.
Counsel for the prosecution,
Your Honor,
before the court,
please.
the presiding officer makes a ruling.
Ako yung magiging parang sirang Your Honor, I just said that this witness said that he saved a copy of that video in a flash drive. So the logical question now is to ask him if this flash drive is presented to him, is he able to explain and or identify the same? I don't see any proper basis for an objection to that, Your Honor, please.
Presiding officer will make a ruling. Objection is overruled. The prosecution, counsel for the prosecution, is trying to comply with the requirements enunciated by the Supreme Court insofar as such pieces of evidence is concerned. Number 1, establishing its origin. Number 2, to trace the chain of custody insofar as the transfer to a storage device is concerned. And finally, how it reached this court. So the objection is overruled.
On the witness with the flash drive. Mr. Witness, I'm now showing a flash drive that is previously marked as Exhibit P-Roman numeral 4-10A, containing the subject video that is previously marked as Exhibit P-4-10 for the prosecution. Question: what relation, if any, does this flash drive have with the one you mentioned?
P-1, no? May I know if this was appended upon any
Counsel
document?
for respondent is recognized.
Thank you, Your Honor. Your Honor, may I know if this was appended upon any document?
Your Honor, please.
Counsel for the prosecution will please reply.
Your Honor, please.
The answer is no, I presume.
No.
The basis, if at all, counsel for the respondent is the testimony of the witness. When asked, again, to establish not only the origin, but also how he transferred it to a storage device, and if at all, how it reached this court. So, chair replies, and if that is an objection, overrules the same. Witness may answer.
Permission to unseal the flash drive.
You may do so, sir.
Thank you, Your Honor.
Your Honor, the witness manifestation is now in the process of unsealing the object evidence
Witness will please answer.
This is the flash drive where I saved the recording, sir.
Now, Your Honor, please, at this juncture, we are about to confront the witness with the video contained in the flash drive.
Your Honor.
And,
Kindly let the counsel for the prosecution finish.
Yes, Your Honor.
thank you so much. And in the interest of time, Your Honor, please, we move that we allow Attorney Magallon to transport himself to the technical booth to facilitate, Your Honor, please, the playing of the video when the time comes.
Counsel for respondent.
Your Honor, may we know how long the video is?
We will arrive to that, Your Honor, please.
No, I'm also curious. How long
All right,
is
now.
this for us to know? How long is this particular video? Namely, Exhibit P, Roman numeral number 4, 10A.
Your
How
Honor,
many
please.
minutes or seconds would this be?
Exactly, the video is 2 hours and 26 minutes and 10 seconds. But wait, Your Honor, please. We will aid the court in this regard. We will not be showing the entire 2-hour video, Your Honor, please. We will be presenting the relevant portions of the video, Your Honor, please, sanctioned by the rules and subject to the defense doing whatever they want with the remainder of the video, Your Honor, please.
Your Honor.
So what will you play exactly, counsel?
Your
How
Honor,
many
please.
minutes or seconds?
We counted, it's 2 minutes and exactly 18 seconds, Your Honor, please. 2 minutes and 18 seconds of a 2-hour, 26-minute and 10-second video, Your Honor, please.
Your
What does
Honor,
counsel for respondent say?
we object. Based on Your Honor, based on the rules, part of a video documentary must be presented, Your Honor.
Come again?
I'm sorry, counsel?
Yeah, hold on, Your Honor.
I'm sorry, counsel? I did not get what you
Hold
said.
on, Your Honor. Your Honor, under Rule 132, when part of a transaction, writing, or record given in evidence, the remainder must be shown. When part of an act, declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into. And when a detached act, declaration, conversation, writing, or record is given in evidence, any other act, declaration, conversation, or record necessary to its understanding must be given into evidence. Your Honor, we request that the entire video be played.
Your Honor, can I respond to that, Your Honor, please? Can I respond to that?
What does the counsel for the prosecution say before the chair makes a ruling?
Your Honor, please, we don't want to put the defense on the spot, but that is a misreading of the rules. Your Honor, please, counsel cited Rule 132, Section 17. With all respect to the defense, that doesn't serve your interest. It serves the interest of the prosecution. May I explain? Reason. If we read Section 17 of Rule 132, it says, when part of transaction, writing, or record given in evidence, the remainder is admissible. When parts of an act, declaration, conversation, writing, or record, when part is given by one party, and in this case, that is the prosecution, the whole of the same may be inquired into by the other side. Meaning, it's simple. This rule, Section 17, Rule 132, allows exactly the prosecution to present a 2-minute portion of a 2-hour video, subject clear. Number 2, we invoke, Your Honor, please, the ruling that it is for the prosecution to decide what to present, when to present, how to present, and whether to present at all. Be that as it may, Your Honor, please, the defense will not be prejudiced exactly because when the time comes for the defense to present their evidence, they can present the remainder of that 2-hour video. What we are saying, Your Honor, please, for the interest of time, for the prosecution's presentation of evidence, we deem that's only a 2-minute portion of that 2-hour video is relevant at this point in time, Your Honor, please. We move for a ruling.
Your Honor, if I may respond.
As the last response,
Your Honor,
counsel for the respondent.
The prosecution cannot be allowed to present a truncated part of a whole 2-hour, 26-minute video. That will not provide the context necessary for the understanding of what occurred during that night on November 23, and also not allow the proper identification by this witness.
Your Honor, sorry, I will not even reply to that, Your Honor, please.
Chair would like to ask, who did the edit? From the, how many hours? 2 hours?
No. Your Honor, please, if I make
From
an
the
reply to that.
total, who did the edit? Was the witness the one who did the edit, or was it already the prosecution?
Your Honor, there's no editing done. There's
meaning
no editing
who,
done.
Who got that shorter portion?
No, Your Honor, please. What we are presenting are portions of the entire 2-hour video. And this witness, I think, will be able to identify the specific timestamps of that preserved, not edited portion. If I may repeat, Your Honor, please, we are not presenting any edited portions, but only snippets, portions of that 2-hour video. And this witness, I suppose, will be able to identify which specific portions that he would like the court to view at this point.
So when it is shown, the witness will testify and attest to the portion of the entire video that it was found insofar as the timestamp is concerned.
Yes, Your Honor, please.
But as evidence at the proper time, you will be offering this entire
Yes.
2-hour or so video.
Yes, Your Honor, please.
And simply highlighting
Yes.
the 2 or so minutes. Would that be correct?
That's a very keen observation. Agree 100%, Your Honor, please.
Your Honor, the prosecution cannot be allowed to do this because the entire video will show the context on which the utterances were made.
That is a matter for the counsel for respondent to do and present during their time, because I believe the counsel for respondent also identified and marked, if I'm not mistaken, the same video for over 2.5 hours. It can do so during its time to present its evidence in chief.
Thank you so much.
The objection is overruled. Counsel is instructed to go to the booth accompanied by a counsel from the respondent in order to make sure that indeed the USB identified by the witness is the same USB that will be played in the tech booth of the Senate.
Okay. While they're doing that, may I propound the next question, Your Honor, please?
Yes, counsel,
Now,
you may proceed.
Mr. Witness, John Mark, listen. Now, you mentioned kanina that you authenticated the subject video by recording the same through sinasabi mong open broadcaster software OBS, and then you compared the contents of the recording and the subject video. That's one. And you also said that you investigated certain statements made by the Vice President on November 23, 2024. Yung tanong, no? What particular statements of the Vice President did the NBI deem proper to investigate?
The statement of the Vice President where she uttered that she already talked to someone to kill the President, the First Lady, and the former Speaker of the House if something's happened to her.
Okay, now, the next question now, Mr. Witness, is in what particular portion of the subject video, did the respondent utter that she already contracted a person to kill?
Objection, Your Honor.
Oh, wait.
Allow the counsel to finish his
I'm not
question.
yet done. Relax. To kill the President, the First Lady, and the former Speaker of the House.
Objection, Your Honor.
What?
What is the objection of counsel for respondent?
Your Honor, no basis for the question, Your Honor.
Wow.
Overruled. Witness may answer.
May I refer, sir, to my notes to identify the specific timestamp, sir?
Okay, so
The witness may do so if it is available to him. You may refer to your notes. While he's doing that, while the witness
Honor,
is
may
doing that, Senator Judge Alan Cayetano is recognized. You may proceed, sir.
Your Honor,
Presiding
may I question what notes he is referring to?
Counsel for respondent,
Apologies,
the
Your Honor.
presiding officer recognized Senator Judge Alan Cayetano. You may proceed, sir.
Just some thoughts, Presiding Officer. This is not yet an appeal from your ruling and maybe a question to the counsel of the defense. Just to refresh our memory, Rule 132, Section 17, when part of a transaction, writing, or record given in evidence, the remainder admissible. when part of our act declaration, conversation, writing, or record is given in evidence by one party, the whole of the same subject may be inquired into by the other. And when a detached act, declaration, conversation, writing, or record is given in evidence, any act, declaration, conversation, writing, or record necessary to its understanding may also be given in evidence. So I'm not appealing yet. I see the logic of the ruling of the presiding officer. Ito lang po ang tanong ko, is the defense going to ask later on for the showing of the whole video? Because if they are, why don't we just watch the whole of it? Because we're going to have to assess the context. If it was really a threat, what did she say before or after? And I don't really want to go home today believing one thing based on a 2-minute clip and then come back next week to watch the 2-hour clip. I think most of us saw parts of the clip. Of course, I don't also feel like watching the 2-hour, I don't even watch 2.5-hour movies, much less this. But I'm just putting this at the feet of the presiding officer and my colleagues na kung gagawin din naman natin eventually yung 2.5 hours, mas gusto ba natin putulin muna ngayon at may iniisip tayo and then later on the 2 hours? Or can the two parties agree of the 2.5 hours, which one yung may context? So I'm not criticizing the prosecution's motion. I see what you mean. May I ask that one question to the defense, if they're going to ask, presiding officer?
Precisely.
For the presiding officer, we cannot dictate nor predict what either counsel for the prosecution or respondent will do during the presentation of their evidence in chief. Even if they say yes to us now,
yes,
actually they have every right to change their mind and
yes, I agree, Your Honor,
not do so anymore.
But if they do answer now that they want it shown, may we consider, I mean, if I'm the only one who wants to see it as a whole, then I will submit to everyone else. But if everyone else is saying we will eventually watch the whole of it, we might as well get it over and see the context of the whole video. Unless the two parties can agree that they only want to look at 30 minutes or 1 hour. I don't know what context they're talking about. I'm just trying to expedite
Both
presiding
parties,
officer.
Senator Judge Alan Cayetano, marked the same video.
Yes. May I ask
which is over 2 hours. Now
May I
it is-
just ask the defense, do they plan to ask us to watch the whole?
Counsel for Defense will please reply to the question of
Yes, Your
Senator Judge Cayetano.
First, Your Honor, precisely why we're asking to watch the video is because we don't know what the contents of that video is. We don't know if it's any different or the same with our video. And to answer the question of the Honorable Senator, yes, we will be asking the entire 2-hour, 26-minute video to be presented and watched later on during our cross.
So on that point, Mr. President and presiding officer, hindi naman nakalagay sa Section 17 when. And usually, at least for myself, if I have to watch 30 minutes and then may emphasize na 30 seconds, 2 minutes, 1 minute, pinapanood mo na yung buo and then saka papanoorin yung maikli na ine-emphasize para walang prejudgment. Kasi pag nauna yung portions na maliliit and then saka mo lang sasabihin later on, eto pala context nito. Medyo umiiba. But again, no, I'm only one of the 24, so I leave it to my colleagues. If we're going to have to watch it anyway, may I ask the presiding officer what the pleasure is? But since the rule doesn't say, personally, I'd rather watch the whole thing and get it over with, then allow the prosecution to pick out the portions that quickly say, that goes into the center of the controversy or what they want to prove.
Without disagreeing with Senator Judge Cayetano, for the presiding officer, it's just that I don't think the court should impose or dictate upon either party how they will present their evidence in chief. Although it would save the court some time if they... But we can also waste a lot of time arguing about this instead of watching the 2-minute video.
Mr. Presiding Officer, I'm not saying we dictate because there was an objection. You ruled You can change your ruling or we can appeal. But I'm saying I'm just one. So if everyone agrees na portion muna, I will submit to that. But if everyone else thinks na panoorin na yung buo, then baka I can appeal your ruling without voting. So I'm just bringing up this issue for expediency, but I leave it up to what everyone else thinks about it.
You know, Your Honor, if I may, we also move for the reconsideration of the earlier ruling of the Honorable Court.
Counsel cannot move for reconsideration of the ruling of the chair. Only a senator judge
Your Honor,
can do
may
so.
we
Counsel.
manifest that we intend to present the whole during cross-examination, Your Honor.
Presiding officer declares a brief recess.
Thank you so much, Your Honor. So, can I go?
During the break, the presiding officer had a discussion with the senator judges, including Senator Cayetano. The presiding officer would therefore like to make of record the following. Number one, should the counsel for the respondent rather decide, as it has manifested, to present the entire video, this court shall allow it during the time for the respondent to present its evidence in chief. We will not interfere with how each party or either party presents their case, with a caveat that a portion of an entire video being presented is not only to save on time, but also to be able to support the allegations from the point of view of the prosecution insofar as their articles of impeachment is concerned. No need to say that the counsel for the respondent will also present the evidence that they deem best that will prove the innocence of the respondent in this case. Senator Judge Cayetano? The mic, please, of Senator Judge Cayetano.
Mr. Presiding Officer, I submit and I think there's a consensus. May I ask just one question about authentication? I
You may
just want to
proceed,
be
sir.
clarified with my indulgence to the prosecution and defense. Just to the witness, please correct me kasi hindi ako techie talaga dyan. So sabi mo, pag ino-authenticate mo, you get the video tapos may hash.
Yes, Your Honor.
So you get the hash tapos you download the video. Tama po ba?
No, Your Honor. The video was screen recorded, Your Honor.
Okay, so screen recorded, then yung hash na nakuha mo.
Yung hash value po is kinalculate from the recorded po.
Okay, then you have to compare that with the original one, right?
Yes, Your Honor.
So the original one, yung hash niyan, nasa Facebook. Tama ba?
Yung hash po, hindi po kinalculate yung hash from the Facebook. Kasi ang purpose po ng hash value is to calculate po yung value ng mismong video na ni-record ko. Dahil hindi po siya yung for authentication purpose, but for the integrity of the video that I screen recorded na if matampered siya during the time na sinubmit siya until presented in court, makikita po na iba po yung hash value.
So is there a possibility na iba yung hash ng Facebook for the same video sa hash nung sayo?
Magkaiba po talaga yun.
Magkaiba. But how do you know it's, when you authenticated, how do you know it's the same video?
I manually compared, Your Honor.
Manually compared?
Yes, Your Honor.
But we don't know that unless we also manually compare.
Yes, Your Honor.
Yeah. Thank you. I just want to clarify that and think about it more.
Noted and entered into the records. What is the pleasure of Senator Judge Villanueva?
Mr. Presiding Officer, in relation to what Senator Judge Alan Cayetano mentioned, may I just be allowed to ask a clarificatory question in relation to that particular matter?
Senator Judge Villanueva may do so. Yes,
Thank you.
2 minutes.
Thank you. Mr. Witness, I was listening attentively earlier and you made mention that the live stream video was recorded using Open Broadcaster Software or OBS. Just for the benefit of the court, could you briefly explain what OBS is and how it was used in the course of your investigation?
It's open source na software na pwede pong i-access ng kahit sino.
So it's generally available to the
yes
public?
Po. And ang purpose po niya is may two functions siya, is live stream and screen recording po.
And stream recording?
Screen recording, Your Honor.
Could you explain the capabilities nitong OBS as well as any considerations that investigators take into account pag ginagamit po itong recordings generated through this particular software? as part of your investigation?
Yung OBS po, capable po siya i-screen record kung ano po yung nakikita sa screen. After po nun, makakapag-generate po siya ng output. Yung output po na yun, yung minamanually compared ko with the live stream video, Your Honor.
To authenticate?
Yes po.
Thank you. Thank you, Mr. Presiding Officer. Thank you, Sir Witness.
Thank you, Your Honor.
Noted and entered into the records. What is the pleasure of Senator Judge Raffy Tulfo?
Thank you.
Mr. Presiding Judge, just a statement.
The gentleman may proceed.
In Rule 132, Section 17, it is not mandated that the whole record be shown to the court. The video being shown in open court and it being in evidence is completely different. That's all, Mr. Presiding Officer.
Noted and entered into the records. What is the pleasure of Senator Judge Pangilinan?
Yes, Mr. President, just one or two quick questions to the...
The gentleman may
witness.
proceed. Witness
Yes.
will please answer the questions of Senator Judge Pangilinan. He has 2 minutes.
Yes, Mr. Kalilong, ikaw nabanggit mo kanina na nag-training ka, no?
Yes, Your Honor.
Hindi lang dalawang linggong training lamang ang nakuha mo, tama ba 'yon?
2 linggo on the start, pero during the tinetrain po ako ng chief ko. During the process.
So continuing training.
Yes po, kasi nagpe-present po ako sa
At saan yung training? Na sinabi mong 2 linggo, nabanggit mo ba?
sa office namin siya ginawa, pero ang nag-handle is MaxCore po.
Ano yung Max for?
MaxCore Interventures.
Ano nga yun?
Provider po namin ng forensic softwares.
At kumpanya siya?
Yes po.
Ng computer...
Ng mga pang-forensic po.
Forensic. Okay.
Yes, Your Honor.
Thank you.
Counsel for prosecutor will please proceed.
Your Honor, may I be allowed to speak in Cebuano a bit? Mahimo ba kita magpadayon? In Tagalog it means, in English, can we proceed?
Counsel may proceed.
Thank you so much, Mr. Witness. Now, in what particular portion of the subject video did the respondent utter that she already contracted a person to kill the president, the first lady, and the former Speaker of the House of Representatives?
Are you done?
Objection?
Objection, Your Honor.
Wow.
Kindly state objection, counsel for response.
Your Honor, the question is misleading. There was no mention anywhere before that the video mentioned that the killing of the president.
To kill.
Yeah, there's no mention in any testimony earlier. There's no mention that video.
Your Honor, again, with all respect, the records will bear me out. Bases have been more than complied with. This witness mentioned many times over that the subject of the investigation is the statement of the Vice President that she already contracted a person to kill the President, the First Lady, and the former Speaker. There's no basis for the objection, Your Honor, please.
Your Honor, may I ask for a readback? He was the only party who said that, Your Honor, not
Kindly
the...
use the third party in referring to opposing counsel.
Yes, Your Honor.
If I may, Your Honor.
May I ask, Your Honor, for a...
Let the counsel for defense finish his statement.
May I ask, Your Honor, for a reading of the transcript, as the witness, to my recollection, never mentioned that the Vice President did those things.
All right. If I may, Your Honor, please.
Counsel, kindly lay the basis.
Yes, Your Honor, please. Now, Mr. Witness, you said that your office, the NBI, conducted an investigation for a statement made by the Vice President noong Nobyembre 23, taong 2024. Naalala mo yun?
Objection, Your Honor.
Oh. Your Honor, please.
What is the basis of the objection?
Your Honor, it's leading.
Your Honor, please. If I may, Your Honor, please.
Do you remember? leading, Your Honor.
If I may, Your Honor, please, I'm just giving in to what the defense wants. The record will bear me out. This witness mentioned so many times over that he investigated the statement of the Vice President uttering that she already contracted a person. The whole nation is listening.
The chair will
Your
make
Honor,
a ruling.
so many words leading.
The chair will make a ruling. The objection is overruled. Earlier, chair noted, I have it in my notes, that the question was propounded by counsel with respect to the 11/23/24 incident that was the subject matter of a digital forensic examination by the witness pertaining to the former Vice President. That was the instance, if the counsel will recall, that counsel for the prosecutors asked the witness if he knew who the Vice President was. So the objection is overruled. Witness may answer.
Your Honor, may I state for the record, my objection is on the part of the question where he said that the Vice President hired someone to kill the President, the First Lady, and the Speaker of the House, not on the identification of the Vice President.
Noted. Court already made a ruling. Witness will answer.
Mr. Witness, naalala mo ba yung tanong?
Can you repeat the question,
Okay,
sir?
now.
Kindly repeat the question, counsel.
In what particular portion of the subject video in that online media conference of the Vice President did she utter that she already contracted a person to kill the President, the First Lady, the former Speaker? In what portion?
Objection, Your Honor.
What is the objection?
Your Honor, this honorable court already ruled on this question. The discussion later on was on the leading question made by the prosecutor. If you recall, Your Honor, this honorable court said, prosecutor, please lay the foundation, the basis for your question.
Your Honor, please, if I may, can respond.
The presiding officer will ask the witness. Mr. Witness, out of the 2 or more so hours of video that you downloaded, do you know, if at all, the timestamp that pertains to any statements made by the Vice President pertaining to any of the allegations in the articles of impeachment, particularly Article 4, the subject matter of this case, in relation to alleged threats made by her in that video?
Yes, Your Honor, but may I refer to my investigator's note, Your Honor?
You may do so. Senator Cayetano is recognized.
Mr. Presiding Officer,
Alan Cayetano. Sorry.
may I know from the records, is this the first time that the witness mentioned that the Vice President uttered threats against the President, the former Speaker, and the First Lady?
Your Honor, if I may, there was
because if
no
it's the-
mention at all.
No, yes.
Sorry, apologies.
No, because if it's the first time, precisely the rule says that you cannot allow leading questions. Whether it's from the judges, whether it's from the presiding officer, or from the defense, or the... So meaning, you lay the basis. Simply, you ask him, ano yung laman ng video? Pag binanggit na niya, na may ganito sa laman ng video, then you can ask him na directly what part. So, all of us want to expedite it, but let's follow the rules. So that's why I'm asking, has this witness this afternoon, I missed a portion because I have a headache and I had to eat before I drink medicine, but I was watching sa TV. But hindi ko pa narinig na sinabi niya to. Kasi kung hindi pa niya sinabi, Mr. Presiding Officer, can we just follow the rules and just lay the basis, ask him kung ano laman ng video, let him testify, tapos pag binanggit niya, then you can ask him, hindi na siya leading. But we shouldn't really ask leading questions because we'll violate the rules. So excuse me, but I'll just be very particular when it comes to the rules, and it's not against any group.
Senator Judge Cayetano, it will take some time before we can quote-unquote appeal to the records. I'm trying to have them get it. But in lieu of that, that's why the chair tried to intervene. Can counsel kindly lay the basis for the witness to be able to identify the timestamp portions of the 2-hour video?
All right, Your Honor.
Counsel for the prosecutors may proceed.
This will be quick. Mr. Witness, you said that your office conducted an investigation on the statement made by the Vice President dated November 23, 2024, correct?
Objection, Your Honor. Leading.
Your Honor.
Your Honor, he's not on direct. He's
Overruled. Witness may answer.
Yes, sir.
Now, tanong, ano ba exactly yung sinabi ng Vice President nung araw na yan, November 23, 2024?
Objection, Your Honor.
Well,
Vague.
I'm not yet done.
Well, Your Honor, the pauses of the prosecution are very
Kindly
confusing.
let the counsel for the prosecutors finish his question
Precisely,
before
Your
you
Honor.
object.
May I
Counsel
ask
for the prosecutor
also
may proceed.
may I ask, instead of this, Your Honor, may I ask that the Honorable Court direct the witness to allow me to object before answering? Because
No.
precisely the questioning of the prosecutor
Okay, what?
is there are many pauses, which it's confusing if he's done or not.
Counsel, witness even on occasion forgot what the question was because he did not respond to the question of the prosecutor.
Yes, Your Honor. So I just
Court will make sure of that.
Thank you, Your Honor.
So kindly finish your question if
Yes,
you want
so-
to state it again, counsel for the prosecutors.
Maybe it's the tone. No? I'll be quick. What particular statements of the Vice President on that day did you investigate?
Objection, Your Honor. Vague.
Please.
Take it, counsel for respondent. A bit of patience. Let the counsel
Yes.
finish. I don't think he's finished.
The question is done. What particular statement on that day did you investigate? How is that leading?
Objection, Your Honor. Vague.
Okay, Your
Not
Honor.
leading.
Your Honor, please. Can I
I didn't
address
say
to that,
leading.
Your Honor, please? Can I?
What was
Whether-
counsel? What's the basis of the objection?
Vague.
All right. I will
It's a
indulge.
2 hour
Your Honor, please.
36
I will
26
indulge,
minute
Your Honor,
video, Your
please.
Honor.
I will indulge. I will add these two phrases. It will never be. That. Now, Mr. Witness, what statements did the Vice President utter on that day, if any?
Your Honor,
Whoa.
same objection. There's a
Honor, please.
2 hour 26 minute. What?
Let the
does he
witness
mean?
answer.
Counsel, this 2 hour and so minute video was done on the same day.
Yes.
Correct, Your Honor, but the question must be given with particularity.
If the witness knows, witness may answer.
Answer.
Witness will please answer.
Can I refer for my notes to identify the exact statement because I might said a statement that's not part of the actual statement.
Presiding officer will allow the witness to refer to his notes to refresh his memory. Go ahead, Mr. Witness.
The specific statement, quote and quote, yes, huwag kang mag-alala ma'am sa security ko kasi may kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta at si Martin Romualdez. No joke, no joke. Nagbilin na ako ma'am. Pag namatay ako, sabi ko, huwag kang tumigil hanggat di mo sila mapatay. Hanggat di mo sila mapatay sila. And then he said yes.
Please proceed, counsel.
Thank you. Now, in what particular portion of that video recording that you authenticated of that online media briefing on November 23, 2024, did the Vice President utter those words?
If I may, sir, I think we should include the question to 1 hour, 17 minutes, and 18 seconds, sir.
Your Honor, so the witness manifested as an answer to the question in what portion he said, timestamps 1 hour, 15 minutes, 0 second to 1 hour, 17 minutes, 18 seconds. And we computed, Your Honor, please, it's a 2-minute, 18-second portion of that video. At this juncture, Your Honor, please, bases have been laid. The nation can finally see it. The court will do. We move that's 2-minute and 18-second portion of that video be presented at this juncture, Your Honor, please.
The Secretariat is instructed to play the USB given to the tech behind that was observed and witnessed by both counsels for the parties. Sorted. Kindly play the video.
Vice President. Thank you so much nga po pala sa dala niyong hopya nung hearing na pumunta kayo for PRRD. Kami yung nasa likod niyo po, yung tinawag nilang bastos kasi po malaki. Congresswoman.
Kindly pause it. Ganyan ba talaga?
Your Honor, please, Your Honor, please, the witness said that he would like to include the question propounded to the Vice
okay lang.
President.
So ganyan nga, hindi nalalakihan yan? Ganyan na talaga yan? Or it will get bigger?
It will get bigger, Your Honor, please.
Okay, please proceed.
Yan. Thank you, ma'am. Nakakain kami. Ako po ay natatakot kumain ng pagkain doon baka mamaya. Ma'am, mag-iingat po kayo. Nasa teritoryo kayo ng kalaban.
Okay lang
nag-aalala po kami para-
ma'am, kasi sila naman ako na eh. Sila talaga yung bastos eh. You reap
Opo,
what you sow.
Yeah. Mag-iingat po kayo kasi sa dinami-rami po ng inyong mga pasabog ngayong gabi, it seems like marami po talaga kayong alam about them, no? Dahil sa pagkakasama niyo sa kanila during the campaign and during the 2022 elections. Baka po mamaya kasi totoo yung mga naririnig namin or yung, I don't know if it's true, na meron daw silang Operation Romanovs and baka bala kayong ubusin ang inyong pamilya dahil hadlang kayo sa kanilang mga balaki in the future. So mag-iingat po kayo. Kami po kasi kami ng EDSA Friday crew, kami yung bumababa every Friday dyan sa EDSA because we believe yan yung tamang venue sa dinami-rami na ng problema natin. Ang kaya lang naman po namin gawin ay manawagan na bumaba na yan. Eh ano po kaya ang remedy naman ninyong mga nasa posisyon or ng mga kayang labanan itong napakarami na pong ginagawang korupsyon at krimen laban sa taong bayan? Ano po ang pwede nyo maging remedy para matapos na ito? Lalo't nagsisigaw na po ang taong bayan na mag-people power na.
Yes. Huwag kang mag-alala, ma'am, sa security ko. Kasi may kinausap na ako na tao. Sinabi ko sa kanya, kapag pinatay ako, patayin mo si BBM, si Lisa Araneta, at si Martin Romales. No joke. No joke. Nagbilin na ako, ma'am. Pag namatay ako, sabi ko, huwag ka tumigil hanggang hindi mo mapatay sila. And then he said yes.
That's the end of that 2-minute and 18-second portion of the video, Your Honor, please. Pwede ba kita magpadayon? Can we continue?
Counsel may continue, may proceed.
Now, Mr. Witness, what relation, if any, does that video that you viewed with the video you mentioned earlier of the Vice President uttering that statement?
It is the portion of the video that I authenticated, sir.
Okay. Let's continue. What happened next, Mr. Witness, kung meron man, after mong ma-authenticate yung subject video na yan?
Our team conducted an open source investigation to identify previous statement of the Vice President that had similarities to the November 23, 2024 video, sir.
Okay. Now, sinabi mo that your team conducted yung tinatawag mong open source investigation for any prior statements made by the Vice President against President Marcos Jr. and his family members. Yung tanong nga, ba't kailangan pa mag-conduct ng open source investigation for any prior statements na ginawa, kung meron man, ng Vice President against laban kay President Marcos Jr. at saka yung pamilya niya?
As part of our standard procedure, sir, kailangan namin makita yung full context kung bakit ito nagsimula. Kaya nagtingin kami ng mga prior statement made the Vice President against the President and the family.
Alright. Now, ano ba yung naging resulta, kung meron man, sa naging open source investigation nyo, Mr. Witness?
We identified a video, October 18, 2024, an online press conference held by the Office of the Vice President, sir.
Now, ano ba yung nakita nyo, kung meron man, sa naging press conference ng Vice President on October 18, 2024?
There were similar statements uttered by the Vice President against the President, sir.
So sinasabi mo na on that October 18, 2024 press conference, may mga nasabi din na mga statements yung Vice Presidente laban sa President. Yung ba sinasabi mo, di ba?
Yes, sir.
Now yung tanong is, ano ba yung naging mga parehong statements ng Vice President sa araw na yan, October 18, 2024?
To said the exact statement, may I refer to my investigator's notes, sir?
Move, Your Honor, that this witness be allowed to peruse his notes to answer the question as to ano ba yung naging exact statement ng Vice President on October 18, 2024, Your Honor, please.
Witness may confer with his notes.
Quote and quote, gusto ko tanggalin yung ulo niya ba? I just imagine myself cutting his head.
Wait, so sinabi ng Vice President, gusto kong tanggalin ng ulo niya, I imagine myself cutting his head. Now, ano pa yung naging statement kung meron pa?
So doon, na-realize ko, toxic na, di ba? Ganyan na yung imagination mo. Sinasakal mo na yung tao. And then, I said this is over.
Alright, kung meron pa, ano pa yung naging statement ng Vice President sa araw na yan?
Hindi marunong maging presidente ang nakaupo. Kasalanan ko ba yun?
Kung meron pa, ano pa yung naging statement ng Vice Presidente sa araw na yan?
Hindi ko alam, pero isang beses sinabihan ko talaga si Senator Amy. Sabi ko sa kanya, kung hindi kayo tumigil, huhukayin ko yung tatay nyo, itatapon ko siya sa West Philippine Sea.
Your Honor, please. There's a manifestation of the good Senator Tito Soto. He did not hear the last statement.
No such manifestation was heard by the presiding officer. Okay. Counsel may continue. Please proceed.
Thank you so much.
Kindly stated for the record, Senator Judge Soto. Apologies from the presiding
Thank
officer.
you. I did not get the exact words that were uttered during the last statement.
Will the witness kindly repeat his answer to the last question propounded by counsel for the prosecutors?
Yes, Your Honor. Hindi ko alam, pero isang beses sinabihan ko talaga si Senator Amy. Sabi ko sa kanya, kung hindi kayo tumigil, huhukayin ko yung tatay nyo, itatapon ko siya sa West Philippine Sea.
Huhukayin. May proceed, Your Honor, please.
Counsel may proceed.
Ano pa yung naging mga statements, kung meron pa, ng Vice Presidente sa araw na yan?
Last statement, kung presidente nyo siya, okay lang. Ako hanggang Vice President lang ako. Hanggang number 2 lang itong bansa na ito. Wala itong number 1 para sa akin.
Are these all the statements, Mr. Witness?
Yes, sir.
Now, proceed. Now, ano ba yung nangyari kung meron man pagkatapos madiskubre ng NBI yung mga naging statements ng Vice President nung araw na yan, October 18, 2024?
Like what we did to the main video, the November 23, I proceed to preserve and authenticate the October 18, 2024 video, sir.
Again, for ano ba yung ibig sabihin when you preserve the video?
It means that I make the necessary action to ensure that the evidence will be accessible at any time, sir.
All right, now. Ano ba yung ibig sabihin? After mo ma-authenticate yung video, ano bang ginawa mo kung meron pa?
I saved the video on my laptop and on a flash drive, sir.
Now, sinabi mo yung flash drive kung saan sinave mo yung mga video recording mo sa mga naging statements ng Vice Presidente sa araw na iyan. Now, kung yung flash drive na yan ipapakita sa iyo, ma-identify mo ba yan?
Yes, sir.
Your Honor, please, we are now in the process of confronting this witness with a flash drive that is previously marked as Exhibit P14-11, small letter A for the prosecution, containing the recording of the October 18, 2024 press conference of the Vice President identified by the witness that is previously marked as Exhibit P-4-11 for the prosecution.
Permission to unseal the flash drive.
You may do so.
Thank you, Your Honor.
Manifestation, Your Honor, that the witness is in the process of checking the flash drive. Question, Mr. Witness, what relation, if any, does that flash drive have with the flash drive you mentioned?
This is the flash drive where I saved the recording, sir.
All right. Now, okay. Now, Mr. Witness, you mentioned earlier that you authenticated the subject video by recording the same through open broadcaster software, and then you compared the contents of the recording and subject video. And you also said that you found out that the respondent said, etong sinabi niya, gusto ko tanggalin yung ulo niya. At saka, I imagine myself cutting his head. Do you follow?
Yes.
Now, Mr. Witness, in what particular portion of that subject video did the Vice President utter, gusto kong tanggalin yung ulo niya, I imagine myself cutting his head?
Permission to refer back to my investigator's notes, sir.
Witness may do so.
Your Honor, may I approach the witness? Your Honor, may I approach the witness?
Counsel may do so.
Thank you,
Stephen?
For the first statement, timestamp 1 hour, 35 minutes, 57 seconds to 1 hour, 36 minutes, and 10 seconds. And on the part na I just imagine myself, 1 hour, 36 minutes, and 52 seconds to 1 hour, 36 minutes, and 58 seconds, sir.
Okay now, what about the statement that sinabi niya, so doon na-realize ko toxic na, di ba? Ganyan na yung imagination mo. Sinasakal mo na yung tao. And then I said, this is over. In what particular portion of the video did the Vice President utter that statement?
From the authenticated video, timestamp 1 hour, 38 minutes, and 32 seconds to 1 hour, 38 minutes, and 48 seconds, sir.
Okay, now, what about the statement, hindi marunong maging presidente ang nakaupo? Kasalanan ko ba yun? In what particular portion of the subject video did the Vice President utter that?
Timestamp 55 minutes, 26 seconds to timestamp 55 minutes and 37 seconds, sir.
Okay. Now, what about the statement that I quote, hindi ko alam. Isang beses, sinabihan ko talaga si Senator Amy, pag di tumigil, huhukayin ko ang tatay nyo at itatapon ko siya sa West Philippine Sea. In what particular portion of the video did the Vice President utter those words?
Timestamp 1 hour, 11 minutes, and 28 seconds to 1 hour, 11 minutes, and 42 seconds, sir.
And finally, as to the statements, I quote, kung presidente nyo siya, okay lang. Ako hanggang Vice President lang. Hanggang Vice President lang ako. Hanggang number 2 lang itong bansang ito. Wala itong number 1 para sa akin. In what particular portion of that video did the Vice President utter those words?
On timestamp 1 hour, 4 minutes, and 2 seconds to 1 hour, 4 minutes, and 16 seconds.
Your Honor, this representation took notes of the timestamps. Your Honor, please. We now move we go to the next question. Now, Mr. Witness, I'm about to show you the specific portions of the recording of the October 18, 2024 press conference. Now, you tell us, after viewing these portions, what relations do they have with the subject video of that October 18, 2024 video that you identified, if any, okay? Now, Your Honor, we move that Attorney Stephen Magallaon be allowed to proceed to the technical booth to bring the flash drive and for the Secretariat to play specific portions of the video identified by the witness.
Conditioned upon counsel being accompanied by a representative of the counsel for the respondent so that the exact same USB flash drive will be the one that will be played.
To guide the Secretariat, Your Honor, please, these are the timestamps that the prosecution would like to present. First, from 1 hour, 35 minutes to 57 seconds to 1 hour, 36 minutes and 10 seconds. That's the first video. And the second video is from 1 hour, 36 minutes, 52 seconds to 1 hour, 36 minutes and 58 seconds. So move, Your Honor, please.
The Secretariat is instructed to kindly play the video in the presence of both counsels for the parties.
Gusto ko, ang galing yung ulo niya ba? I realized
And the second video, please. Timestamps 1 hour 36 seconds to 36 minutes to 52 seconds to 1 hour 36 minutes and 58 seconds, please. Oh, it's done. Is that it?
cutting his head. Gusto ko, ganun din ang gusto ko.
Mr. Witness, you heard the Mr. Witness, you heard the Vice President mentioning cutting somebody else's head. Based on your investigation, kaninong ulo ba yung nire-refer ng Vice President na gusto niyang tanggalin?
The President, sir.
Ulo ng Presidente.
Yes, sir.
Mr. President, you also mentioned timestamps 1 hour 38 minutes to 32 seconds and 1 hour 38 minutes to 48 seconds. May we have that specific portion be played?
So noon, na-realize ko, toxic na, di ba? Ganyan na yung imagination mo. Ang imagination mo, sinasakal mo na yung tao. And then I said, this is over.
Okay. Then what about from timestamps 55 minutes, 26 seconds to 55 minutes, 37 seconds, please?
To elaborate po.
Hindi marunong maging presidente ang nakaupo. Kasalanan ko ba yun? Hindi. Ba't sinasabi ng mga tao, kasalanan mo kasi hindi ka tumakbo, ikaw sana yung presidente, hindi siya. But then I said, maaga ako nagsabi na hindi ako tatakbo for president. May madaming mga...
Okay. Now, what about from timestamps 1 hour 11 seconds? 1 hour 11 minutes 28 seconds to 1 hour 11 minutes 42 seconds.
Hindi ko alam. Pero isang beses sinabihan ko talaga si Senator Amy. Sabi ko sa kanya, kung hindi kayo tumigil, huhukayin ko yung tatay ninyo. Itatapon ko siya sa West Philippine Sea. Sinabihan ko si Senator Amy.
Thank you. What about from timestamps 1 hour 4 minutes to 02 seconds to 1 hour 04 minutes 16 seconds?
Ay hindi. Hindi ko na gusto. Kung presidente niyo siya, okay lang. Ako, hanggang vice president lang ako. Hanggang number 2 lang itong bansa na ito. Wala itong number 1 para sa akin. Yet,
Okay. May proceed, Your Honor. Mr. Witness, what relation, if any, do these portions of that specific video have with the video you authenticated as to the press conference of the Vice President on October 18, 2023?
Those video presented were portions of the video that I recorded and authenticated, sir.
Thank you so much. Mr. Witness, ano ba yung nangyari kung meron pa? After you identified and authenticated the video ng Vice President on October 18, 2024.
We perform open source investigation to identify naman po yung mga naging responses ng iba't ibang tao in response to the statement of the Vice President po.
Ano ba yung naging resulta kung meron man sa naging open source investigation nyo?
We found that the President himself, the former Speaker of the House, and different governmental agencies made their statement po in response to the statement of the Vice President.
So yung Presidente, yung Speaker, former Speaker of the House, saka yung mga sinasabi mo mga governmental agencies, nagbigay ng kanilang mga tugon sa mga nasabi ng Vice President. Now, ano ba yung mga governmental agencies na ito that you are referring to, aside from the President and the former Speaker of the House of Representatives?
The Armed Forces of the Philippines, the Philippine National Police, the National Security Council, and the Presidential Communication Officer.
Okay, now, nasabi mo na yung Presidente ay nag-issue ng kanyang statement in relation sa naging mga pahayag ng Vice President. Ano ba yung naging pruweba mo sa naging statement ng Presidente?
I have taken a screenshot of the statement of the President on the official webpage of the Presidential Communication Office. And I also have a video recording which I authenticated wherein the President made such a statement, sir.
Okay, so nasabi mo, isang screenshot saka isang authenticated recording ng Presidente. Now, let's go to that screenshot. Sino yung kumuha ng screenshot kung alam mo?
I did, sir, and I used my laptop.
Ginamit mo yung laptop mo. Ano ba yung ginawa mo kung meron man sa naging screenshot mo sa laptop mo?
I first saved an electronic copy po nung screenshot.
Now,
sa laptop.
saan na tong screenshot ng...
Pinrint ko po.
Ha?
Pinrint ko po.
Print mo. Now, saan na yung printout ng screenshot na ito?
Sinabit ko po sa Committee on Justice of House of Representatives.
Now, kung yung printout ng naging statement ng Presidente, sinabi mo, titled, Message by President Ferdinand R. Marcos Jr. is shown to you, will you be able to identify the same?
Yes po.
I'm showing you now a printout of a screenshot of the statement from the President titled, quotes, Message from President Ferdinand R. Marcos Jr., and quotes, Your Honor, that is previously marked as Exhibit P-Roman numeral 4-12 for the prosecution through the website of the Presidential Communications Office. Now, question, what relation, if any, does this document have with the printout that you mentioned?
Your Honor, same objections to this printout. Yes.
May I know the specific
Your Honor, same
objection?
objections. There is on the right bottom portion of the Annex P-U-12, 12A, and until 12B. There are marked certified true copies from the NBI signed Safira T dated 4/10/26, Your Honor.
Court made a previous ruling about this matter already, but the objection is duly noted.
Submit, Your Honor.
Thank you. Mr. Witness, how faithful, please? How faithful, if at all, is this printout from the actual screenshots?
The printouts accurately reflects the screenshot, sir.
And how do you know that this printout accurately reflects the screenshot?
I compared the printouts with the screenshot and the web page wherein the message can be seen and found that the contents are identical, sir.
Now, you mentioned that an authenticated recording of the President making the statement. You mentioned that. Now, yung question now is, sino ba yung gumawa ng authentication na ito?
I did, sir.
Ano ba yung pruweba mo na ikaw talaga yung nag-authenticate ng video na ito?
It's part of the January 30 Affidavit of Authentication of Digital Evidence na in-identify ko po kanina.
Okay, Mr. Witness, ano bang ginawa mo kung meron man? Pagkatapos mo sinabi mong ni-record mo, saka in-authenticate mo yung video ng Presidente na nagbibigay ng statement niya.
Sinave ko po yung video sa laptop ko and sa flash drive.
Oh, na-mention mo yung flash drive. Now, kung yung flash drive ipapakita sa'yo, ma-identify mo ba yan?
Yes po.
Now, Your Honor, please, we are in the process of confronting this witness ng isang flash drive that is previously marked for the prosecution as Exhibit P-Roman numeral 4-13, small letter A.
Permission to unseal the flash drive, sir.
Witness may do so.
Thank
Please
you, Your
proceed.
Honor.
Continuing manifestation that the flash drive contains the recording of the President making the statement that is previously marked as Exhibit P-Roman numeral 4-13 for the prosecution.
This is the flash drive where I saved the recording, sir.
Okay, now, move that we allow Attorney Stephen Magallon to proceed to the technical booth to have the recording played on, please. To be accompanied by the defense, if they want to.
So ordered.
Mura. Nakakabahala ang mga pahayag na narinig natin itong mga nakarang araw. Nandyan ang walang pakundangang pagmumura at ang pagbabanta ng planong ipapatay ang ilan sa atin. Kung ganun na lang kadali ang pagplano sa pagpatay ng isang presidente, paano pa kaya ang mga pagkaraniwan na mamamayan? Yung ganyang kriminal na pagtatangka ay hindi dapat pinapalampas. Yan ay aking papalagan. As a democratic country, we need to uphold the rule of law. Ako bilang pinuno ng Executive Department at lahat ng mga nanunungkulan sa pamahalaan ay may sinumpaang tungkulin na tutup din at pangangalagaan ang konstitusyon at ang ating mga batas. Kaya hindi tama ang pagpigil sa mga halal ng bayan sa paghahanap ng katotohanan. Hindi na sana hahantong sa ganitong drama kundo at sa House of Representatives. Ang katotohanan ay hindi dapat itokhang. Tapos na sana ang usapang ito kung tutok yan ay magsabi ng totoo at hindi hahadlangan. Imbis na diretsahang sagot, nililihis pa sa kwentong chicheria. Hangad ko na matuldukan na itong mga pangyayaring ito sa parang matiwasay at magdadala sa atin sa katotohanan. 12 taon din ako nanungkulan sa magkaparehong kamara ng Kongreso. Batid ko ang kapangyarihan iginawad sa kanila ng taong bayan at ng ating konstitusyon. Dahil dito, iginagalang ko ang kanilang gawa at ang buong executive branch. Lahat ng mga ahensya ay hindi nakakaligtas at parating sumasailalim sa kanilang masusing pagsusuri. Bilang isang bansa, marami tayong mga paghamon na dapat harapin at mga suliraning dapat bigyan ng lunas. Sa kabila ng mga pambabatikos, natin ikokompromiso ang rule of law. Kailangan manaig ang batas sa anumang sitwasyon, sino man ang tamaan. Kaya hindi ko hahayaan magtagumpay ang hangarin ng iba na hatakin ang buong bansa sa burak ng politika. Igalang natin ang proseso. Ito pa rin ang katiwala sa atin ng milyon-milyon na Pilipino. Magtrabaho po tayo sa ikauunlad ng Republika ng Pilipinas at para matamo ang bagong Pilipinas.
Your Honor, the defense puts on record that the video was skipping and then portions where the president or who seemed to be the president was paused while audio was continuing playing.
So it's delayed.
Yes, Your Honor.
Noted.
Thank you. Mr. Witness, what relation, if any, does that video have of the president making the statement, if any, to the video of the president making the statement?
That is the video that I recorded and authenticated, sir.
All right, now proceed. You mentioned that the Presidential Communications Office or PCO also issued a statement. Ano yung pruweba mo na yung PCO nag-issue ng statement na iyan?
I have a screenshot of the webpage of the Presidential Communication Office wherein they considered the statement of the Vice President as an active threat.
As an active threat. Okay, now, sino yung kumuha ng screenshot na iyan?
I did, sir, and I used my laptop.
Now, saan yung printout ng screenshot na iyan?
Sinubmit ko po sa Committee on Justice of House of Representatives.
Now, aming ipinapakita yung isang printout ng isang screenshot galing sa website ng PCO kung saan yung statement, makikita yung statements ng Vice President, sinasabi ng PCO, that's an active threat. Now, previously marked in Exhibit P, Roman numeral 414. May you peruse the same. And after perusing the same, the question, Mr. Kalilong, is what relation, if any, does this document have with the printout you mentioned? But you have to peruse the document first.
For the record again, Your Honor, the
Counsel may proceed.
Exhibit P-4-14 is a photocopy, and on the right bottom part, there is a stamp marked certified true copy NBI signed Sapphira T dated 4/10/26.
The observations and comments of the Respondents' Counsel are duly noted. Witness may answer.
Please peruse the document and answer the question, please.
This is the copy of the printouts that was submitted to the Committee on Justice, sir.
Thank you so much. How faithful, if at all, is this printout from the actual screenshot you mentioned?
The printout accurately reflects the screenshot, sir.
And how do you know that the printout accurately reflects the screenshots?
I have compared the screenshot with the printouts and the web page and found that the contents are identical.
Now, let's proceed. Mr. Witness, sinabi mo rin na yung former Speaker ng House of Representatives nagbigay rin ng statement sa mga pagbabanta ni VP Duterte sa isang video. Ano ba yung maging pruweba mo sa naging pahayag ng former Speaker ng House of Representatives?
I have a video of the statement of the former Speaker of the House of Representatives during the plenary session on November 25, 2024, which was published by ANC Digital, sir.
At sinabi mo na authenticate mo yung video na yun. Ano ba yung naging pruweba mo na ikaw ay nag-authenticate sa video na iyan?
It's part of the affidavit of authentication of digital evidence dated January 30, 2025, which I identified earlier, sir.
Now, ano ba yung ginawa mo kung meron man after you authenticated yung video ng former Speaker of the House of Representatives?
I save a copy of the video on my laptop and a copy of the video on a DVD and a flash drive.
Now, sinabi mo, sinave mo sa isang flash drive. Kung yung flash drive na iyan ipapakita sa iyo, ma-identify ba mo ba yung flash drive na yan?
Yes, sir.
Your Honor, we're in the process of presenting to the witness yung isang flash drive that has been previously marked as Exhibit P Roman numeral 4-15 subparagraph A, which contains the recording of the former Speaker's speech previously marked as Exhibit P Roman numeral 4-15.
Permission to unseal the flash drive, sir.
Witness may proceed.
Thank you, Your Honor.
Manifestation, the witness is in the process of checking that flash drive.
This is the flash drive where I saved the recording, sir.
Mr. Witness, question. In what particular portion of that video did the former Speaker of the House give his response to the threats of the Vice President?
May I refer back to my notes?
Your Honor? Your Honor, please. There is a request by the witness that he be allowed to refer to his notes.
Yes, the witness may refer to his notes to refresh his memory. What is the pleasure of Senator Judge Erwin Tulfo?
Mr. Presiding Officer, just a clarificatory question. The witness, the witness here, for the record, mentioned that he was referring to notes. Kanina pa po ito. Could he please clarify what specific notes he was referring to? Who prepared those notes? When were they prepared? And were they made before, during, or after the events he have testified about? And also, these notes, nabigyan po ba ang defense ng copy to? Was this submitted as part of the evidence also, Mr. Presiding Officer? Additionally, the question is, was he relying on these notes to refresh his recollection while giving his testimony today? So,
Witness will please answer the question of Senator Judge Erwin Tulfo.
This is my investigator's notes, which I made during the time of investigation, sir.
my next question would be, was this also presented? Since notes niyo po ito, pinagbabasihan niyo po yung mga testimonya niyo rito, sinabit niyo rin po ba ito as an evidence so that mare-refer din po ang defense, Mr. Witness?
Yung content po ng affidavit, nung notes ko is nandun na po sa affidavit of investigation, sir.
Yung copy exactly ng notes?
Ng notes po. No, sir.
Hindi nyo naibigay. That's all, Your Honor.
Thank you, Senator Judge Erwin Tulfo.
And can I
Counsel for the prosecution.
Can I make a manifestation, Your Honor, please, that the witness referred to his notes when answering specific questions as to actual statements made by the Vice President and the others, number one. And number two, in referring to the actual timestamps of the video. For these specific reasons, the witness was referring to his notes. As to his answers for the other substantial questions, he was not referring to his notes, Your Honor, please.
Your Honor, we move to strike the manifestation. He's already testifying on behalf of the witness.
Your Honor, we cannot move to strike a manifestation of counsel. The good counsel could do his own manifestation. That's not in the rules.
I would like the Honorable Court to rule, Your Honor.
Motion is denied. Let it stay and remain in the records in response to the query of Senator Judge Erwin Tulfo. Senator Judge Risa Ontiveros is recognized. I believe she was raising her hand earlier. What is your pleasure, ma'am?
Salamat po, Mr. Presiding Officer. Tig isang tanong lamang po para sa witness at para sa prosecution.
The lady may proceed. She has 2 minutes.
Salamat, Mr. Presiding Officer. Mr. Kalilong, nung sinabi nyo na nag-conduct kayo ng open source intelligence, pagkatapos nyo ma-authenticate yung November 23, 2024 video, at nahanap nyo yung video naman ng press conference dated October 18, 2024, anong basis nyo para sabihin na yung mga statements sa October 18 press conference ay halintulad sa November 23 video na may assassination threat? In other words po, ano pong napansin yung magkakapareho dun sa statements nung October 18 at nung November 23? O what do they have in common?
Both were... Ang tinutukoy po, ang pinupunto po is yung president. And makikita po doon na hindi na sila in good terms no October 18 pa lang po.
Okay, so sa parehong video ng press conference at saka yung November video naman, yung dalawang elementong yon na hindi na sila magkakasundo at
hindi na sila magkasundo and ang ina-address po parang pinapatukuyan po ng Vice President doon sa press conference is yung President
si
po.
Presidente. Okay. And then, Mr. Presiding Officer, salamat kay Mr. Kalilong. Sa prosecution naman po, yung isang tanong ko at this point in time, Mr. Presiding Officer. Well, Counsel, none of these statements are proof that the Vice President actually contracted an assassin or hired one. Why are these acts impeachable?
Yes. There is an answer to the question, Your Honor, please. The prosecution is in the process of establishing that the Vice President should be impeached and she is impeached and be removed from office for contracting an assassin to kill the President, Your Honor, please. Inasmuch as we understand that these statements may not actually 100% prove that she in fact contracted an assassin to kill the President, Your Honor, please. We are invoking, Your Honor, please, a rule in the rules on evidence that there could be statements, utterances of a person that may not be directly similar to what he or she did, but it could establish, Your Honor, please, what we call a specific intent, knowledge, identity, plan, system, and the like. Ibig sabihin po, pinapakita ng prosecution na yung mga nasabi ng Vice President sa gabing iyon, November 23, 2024, hindi po yan nag-iisang statement ng Vice President. Kung hindi, yun po yung culmination sa mga series of statements ng Vice President kung saan sinasabi niya talagang gusto niyang patayin yung presidente, yung First Lady, tsaka yung former Speaker of the House. Your Honor, please. We invoke Rule 130, Your Honor, please, Section 35 of the Rules of Court. Etong mga statements na to, they prove one thing. Talagang may plano na, talagang may system na, talagang may knowledge na yung Vice President sa anong gusto niyang gawin sa Pangulo. Gusto niyang pugutan ng ulo, gusto niyang patayin. No less than the President of the Republic of the Philippines. Your Honor, please.
At ang tanong po ba dito ay kung may krimen o kung may kung ang asal ay karapat-dapat
Yes,
sa
Your Honor,
Vice-Presidente?
We are able to answer two questions, Your Honor, please. The charges against the Vice President ay yung pagbibitray ng public trust, Your Honor, please. That is also, Your Honor, please, a culpable violation of the Constitution. Now, yung usaping, was that a criminal act? Yes, Your Honor, please. Kaya nga, yung NBI, through this witness, will prove na nag-file na ng kaso yung NBI against the Vice President exactly sa mga naging pagbabanta niya. But you know, Your Honor, I'm a lawyer, but I'm willing to take off yung robe ko as a lawyer and answer the question directly. Mga kababayan, kailan ba naging normal?
Your Honor, this is no longer answering the
I'm
question.
answering the question.
We
I'm
object,
answering
Your
the
Honor.
question, Senator Judge.
The chair will make an equitable ruling in a while. Kindly let the gentleman finish because it's a senator judge asking a question of a party.
Your Honor.
Thank you, Mr. Presiding Officer.
Kailan ba nangyari sa kasaysayan ng Republika ng Pilipinas na yung pangalawang Pangulo ng ating bansa nagbanta, sinabi sa publiko na nakipagkontrata na siya sa isang mamamatay tao upang patayin ang Pangulo, ang First Lady, yung asawa niya. Your Honor, please, I think Attorney Season is making a scene.
Kindly wind up, Counsel.
Your Honor, please, manifestation, I think Attorney Season gave a statement addressed to this representation and she walked out. She's now coming back.
Mr. Presiding
Counsel,
Officer, I'd like to hear the conclusion
kindly
of the
wind up
answer
and we will
to my
address that
question.
matter in a bit.
Okay. Now, Your Honor, please. Yung pagbabanta ng Vice Presidente sa buhay ng Pangulo ng Republika ng Pilipinas, hindi po yan normal. Iyan po ay unang pagkakataon na nangyari yan, nakipagkontrata sa isang mamamatay tao, Your Honor, please, to do that. Even without going into the question, is that a criminal act, Your Honor, please? That act, 110% sure, betrayed the public trust that the Vice President got in the previous elections.
Thank you.
Your
Thank you,
Honor.
Counsel, for
Salamat,
the
Counsel. Salamat, Mr. Calilong. Salamat, Mr. Presiding
Chair
Officer.
would like to remind my colleagues, the question posed by Senator Judge Risa pertains to the final question of this entire impeachment proceedings already. If that is an impeachable act or not. And since we gave the counsel for the prosecutors, I think about 5 minutes, Chair would now like to be fair and hear the counsel for the respondent to discuss why it is not an impeachable offense.
Your Honor, may be allowed to do so after our cross?
After your?
I would like as I understand it,
Yes.
I would like the Honorable Court to play back what the prosecutor said, because it's very interesting. So may I be indulged to allow to give my answer after my cross-examination?
The chair will allow it.
Thank you, Your Honor.
But you would have the similar and same amount of time given to the counsel for the prosecutors, again, to answer the reverse of the question.
Honor.
Because statements were made by the counsel for the prosecutor, their conclusions of fact and law already, which should be taken upon advisement by the impeachment court, because these were not evidence, but rather conclusions in fact and law by the counsel for prosecutors. Senator Judge Pia Cayetano is recognized. Ma'am, you may proceed. What's your pleasure?
Thank you, Mr. President. No, I would just like to manifest my support for the statement and observation of the presiding officer. That was like a closing statement, Mr. President. So I don't think this is fair because, you know, some parts are exciting, some parts are dragging. We're trying our best to be paying attention and what evidence, you know, we have to ferret the evidence before us, what is admissible, what is not. The official objections will come later. But when we allow this to happen, shortcut na natin yung process. So, if I may, with all due respect, Mr. President, admonish us. Call us out if yung question natin is also not proper at the proper time. We may all make those mistakes. Even I may make that mistake. And I'm telling you, please call me out if I make a mistake and ask the kind of question that should not properly be asked by a judge at that particular time. Because it is not right. We must follow the rules. And I know you are being courteous to all of us, but that was a closing statement. And I also asked the parties involved. You have an oath as lawyers. Don't take advantage of the generosity of this impeachment court. I don't want to see this happen again. Thank you, Mr. President.
Duly noted and well taken. The chair, as I said, or as the presiding officer said earlier, reminded our colleagues with respect to similar questions to be asked in the future.
Your Honor,
Chair would like to make a ruling that the counsel for the respondent will be given, I think that was approximately 8 minutes or 10 minutes, we will get the exact time, to answer after the cross-examination of this witness so that we would be fair in listening and hearing the views of both parties in regard to the query raised earlier. Senator Judge Plea Cayetano?
Yeah, sorry, Mr. President. I don't mean to interrupt now. I want to give the defense their time. I respectfully move that the statements of the prosecution be stricken off the record. It is not proper for those statements to have been made. Thank you.
Can we respond? Your Honor, if I may, Your Honor, please.
With the
Your Honor,
permission of
we-
Senator Judge
we joined the
Plea
motion of
Cayetano,
the Senator Judge.
May we table her motion and act on it at a later time with respect to striking it so that we can discuss the matter.
Your Honor, for the
Thank you for your generosity, Senator.
Your Honor,
Judge
if I may,
Plea
for
Cayetano.
the
Yes, counsel
record,
for the
we
respondent.
joined the motion of the Honorable Senator.
I'm sorry?
We joined the motion of the Honorable Senator.
No need, counsel. That motion will be taken up at the proper time by this court.
For the record lang, Your Honor.
Noted for the record, Senator Judge Erwin Tulfo first, and then Senator Judge Risa Ontiveros once again.
I think to resolve this issue, Mr. Presiding Officer, Mr. President, a quick manifestation. Can we request the council that be directed whenever available to furnish members of this impeachment court with sworn statement, testimony, or affidavit of witnesses or witness they intend to present in the proceedings or succeeding proceedings before such witness is called to testify, and this goes to the defense panel too. While the judicial affidavit rule does not strictly apply to impeachment proceedings, its underlying objectives of promoting orderly and efficient presentation of evidence may be instructive. Advanced access to the witness's sworn statement would assist the senator judges in following the testimony and preparing clarificatory questions. Sa madaling sabi po, hinihiling lang po natin na kung mayroon ng nakahandang sinumpaang salaysay ng susunod na testigo, magbigay na sana ng mga kopya nito sa aming mga senator judges bago pa po ang pagdinig upang magsilbing gabay sa pagtatanong at pagtatalakay. Maiwasan po natin ang mga sitwasyon na ito. Thank you, Mr. Presiding Officer.
To reply, Senator Judge Erwin Tulfo, the court did not adopt the judicial affidavit rule for the simple reason that we wanted all of the testimonies to be made and given in open court. so that it will be heard not only by the senator judges but also by the public as a whole, given that this is an impeachment court and an impeachment trial that seeks to unseat a duly elected official. However, the court shall endeavor through the clerk of court to give the senator judges a copy of the annexes attached, if they have not yet done so, to the pre-trial order and the pre-trial briefs pre-marked by the parties, because it would encompass already approximately 80% of the documents that will be presented by both parties, save of course for documents that they have not yet been able to produce and are yet to produce. But the clerk of court is instructed to endeavor to do so with respect to the senator judges so that they can catch up with what is going on in the proceedings. Yes, counsel for the prosecution, you may proceed.
Thank you so much.
Apologies, Senator Judge Risa Ontiveros is recognized. What is your pleasure, ma'am?
Salamat po, Mr. Presiding Officer. Just a point of clarity, briefly, if I may, Mr. Presiding
You may proceed,
Officer.
ma'am.
Salamat po, Mr. Presiding Officer. And of course, I will submit to any ruling or statement of the presiding officer to this Senator Judge. But for clarity, Mr. Presiding Officer, my question po had to do with how the evidence is material to the allegations in the articles of impeachment. Kasi nga po, hindi naman napapatunayan na the Vice President actually sought an assassin. I wanted to appreciate the evidence before me in light of the articles of impeachment. If you wish to strike out the response of the prosecutor, then so be it, Mr. Presiding Officer. But for clarity again, my intention was not to provoke a closing statement. Salamat po, Mr.
We
Presiding
will
Officer.
review the transcript again. Sorry, we have my apologies on the part of the presiding officer. We have a bit of a problem with respect to getting an updated copy of the TSN. But given the clarification of Senator Judge Risa on the matter, then for the consideration of the body, given that we tabled the motion of Senator Plea, that the response of counsel for the prosecution is not responsive to the question of Senator Judge Ontiveros. Because clearly the question he answered was whether or not it constituted an impeachable offense. But without further debate, we are tabling this and we'll discuss and decide upon this at a later date. So ordered.
Thank you so much. May proceed, Your Honor, please.
Counsel may proceed.
Mr. Witness. Okay. Now, sinabi mo na yung former Speaker of the House ay nagbigay ng kanyang tugon sa managing pagbabanta ng Vice President. Saka sinabi mo rin na may isang video recording na inauthenticate mo. Yung tanong is, Your Honor, please, sorry, I'm reminded he is supposed to answer the specific timestamp of that recording of the former Speaker of the House's speech. Your Honor, please. I move that the witness be allowed to answer the question as to ano yung naging specific timestamp ng recording na yan.
Witness may answer.
May I refer to my investigator's notes?
He
sir?
may do so if he so wishes.
Thank you, Your Honor. Timestamp 1 minute 2 second to 2 minutes and 20 second.
So that would be timestamp 1 minute 2 seconds to 2 minutes.
20 seconds, sir.
20 seconds, Your Honor, please. I move that the portion identified by the witness from timestamps 1 minute 2 seconds to 2 minutes 20 seconds be played. Your Honor, please.
Clerk of Court is directed to coordinate with counsel for the prosecution, accompanied by counsel for the respondent, to make sure that the USB identified by the witness will be the same one that will be played. So ordered. The Senate President.
Mr. Presiding Officer, I just have a few questions while we're waiting for the video to play. This is in line with authentication.
The gentleman may proceed. Yes, 2 minutes.
At sa ating ginong testigo, narinig ko kanina ilang beses yung open source investigation. Anong ibig sabihin ng open source investigation?
Ang ibig sabihin po nun is nag-gathered po ako ng iba't ibang information na available sa internet wherein anyone can access po yung data na yun.
And yung iba't ibang information na yun, how do you prove whether those information are valid, authentic, totoo? In the age of fake news ngayon, ang dami ng mga information na lumalabas.
Yung pinagkuhanan ko, Your Honor, ng mga information na yun is from the official websites and official web pages po.
Okay.
To ensure that the contents is accurate.
Okay. And then my next question, narinig ko rin kanina na minamanual comparison nyo yung mga videos between, let's say, Facebook and let's say, yung video recording. Can you describe to us anong ibig sabihin ng manual comparison?
Ibig sabihin po nun, Your Honor, meron akong dalawang monitor during that time and both videos were being played to ensure that the contents are identical po.
Meron bang, nakaupo ka doon, tinitignan mo yung dalawa?
Yes po.
Wala ka bang, let's say, software na will say, ito ay purely parehas itong dalawang video? Kasi na-imagine ko lang, upo ka doon, papanoodin mo yung dalawang video. How do we know that 1:1 yung video na kino-compare mo?
Based on, nakikita naman po siya and based on the audio, sir, na sabay po sila.
Ikaw lang yon ang tumitingin?
Yes po, and it was checked after po.
Sino nag-check?
Meron po akong nagre-review na executive officer and the chief po.
So kayong dalawa ang nagsasabi na itong Facebook video and also itong video recording talagang parehas na parehas?
The authentication itself na affidavit po, ako lang po.
Okay. Meron ba kayong ginagamit ng standards in terms of comparison? Like for example, ito ay ginagamit ng international investigative body. Ito ay isang standard na acceptable by international judicial process. Meron ba kayong ginagamit na standard acceptable by the judiciary or any courts?
Yung procedure ko po nagawa is based lang po sa digital forensic procedure po. Which
Nino?
is, yun po yung ginagamit sa digital forensic as a whole. Yung process po ng
But in digital
identification.
forensic procedure, ito ba internationally accepted procedure or locally lang?
It's a procedure that is acceptable internationally in court po.
And then meron bang international accreditation stamp yan or organization that approves it?
I have no personal knowledge, Your Honor, but I've been following that procedure.
And accepted by the courts?
Yes po.
All right. Thank you. Thank you, Mr. Presiding Officer.
Thank you, Mr. Senate President. Clerk of Court is directed through the technical staff to kindly play the video.
The Vice President of the Republic of the Philippines, Sara Duterte, admitted to contacting an assassin to kill President Ferdinand R. Marcos Jr., First Lady Luis Araneta Marcos, and myself. Let me be clear. Hindi na to biro. Hindi na to normal na panalita. Isa itong direktang banta sa ating demokrasya, sa ating pamahalaan, at sa seguridad ng bayan. Such statement is not just reckless, it is dangerous. It sends a chilling message to our people. A message that violence can be contemplated by those in positions of power. This is not just an affront to the individuals targeted, it is attack on the very foundation of our government. It is an insult to every Filipino who believes in the rule of law and the sanctity of life. Violence has no place in our society. It is irreconcilable with the values that have taught and guided us for years. Values.
Thank you so much. That's the portion. Your Honor, please. May we proceed?
Counsel, may proceed.
Thank you so much.
Counsel, may proceed.
Thank you so much. Mr. Witness, nasabi mo rin na yung AFP, Armed Forces of the Philippines, nag-issue rin ng kanilang tugon sa mga naging pagbabanta ng Vice President. Ano ba yung pruweba mo sa naging tugon ng Armed Forces of the Philippines?
I have a screenshot of the website of the Armed Forces of the Philippines, titled Statement on Military Professionalism and National Unity by General Romeo Browner, sir.
Sinabi mo screenshot. Now, sino yung kumuha ng screenshot na yan?
I did, sir, and I used my laptop.
Anong ginawa mo sa screenshot na yan kung meron man?
I first saved an electronic copy ng screenshot sa laptop and printed it.
Sana yung print out ng screenshot na yan.
Sinubmit ko po yung copy sa Committee on Justice of House of Representatives.
Now, kung yung print out ng screenshot ipapakita sa'yo, ma-identify mo ba yan?
Yes, sir.
Now, we are now in the process of presenting to you a printout of a screenshot from the AFP website with the title, quotes, Statements on Military Professionalism and National Unity, and quotes, that is previously marked as Exhibit P-Roman numeral 4-16. Okay? May you peruse the same? And the question is, what relation, if any, does that document have with the printouts of the screenshot you mentioned?
This is a copy.
How faithful, if at all, is this printout from the actual screenshots?
The printout accurately reflects the screenshot, sir.
How do you know that the printout accurately reflects the screenshot?
I compared the printouts with the screenshot and the web page of the AFP and found that the contents are identical, sir.
Now, sinabi mo rin,
Your
Mr.
Honor, for the record, we have the
Counsel for respondent.
we have the copy of the document. How can he be identifying the document when he does not have that copy? Are you following a script? Is he following
Oh
a
my
script?
goodness, Your Honor, please. I move that statement by the defense that the witness is following a script be stricken out of record. For the record, Your Honor, the witness was perusing the document before he handed that to the defense. I move that the statements of the defense be stricken out, Your Honor, please.
But he was answering
Comments
the
of both
question.
counsels are simply noted. Kindly, if you're done with the document, counsel, kindly give it to the witness.
Your Honor, for the record, the right-hand portion of both documents contain certified true copies. It's and a mere photocopy, Your Honor.
The manifestation and objection is duly noted. Same ruling by this court. Witness may answer.
You state for the record your answer.
I have compared the screenshot with the printouts and the web page and found that the contents are identical, sir.
Your Honor, may continue. Mr. Witness, sinabi mo rin na yung PNP ay nag-issue rin ng kanilang statement sa mga naging pagbabanta ng Vice Presidente sa subject video. Ano bang pruweba mo kung meron man of that PNP statements?
I have the screenshot of the statement of the PNP on their Facebook official page dated November 23, 2024, sir.
Sino bang kumuha ng screenshot na yan?
I did, sir, and I used my laptop.
Anong ginawa mo sa screenshot na yan kung meron man?
Sinave ko po yung screenshot doon sa laptop ko and printed.
And then print mo. Saan na yung printout ng screenshot na yan?
Sinubmit ko po sa Committee on Justice on House of Representatives.
Now, saan na yung printout ng screenshot na yan?
Sinabit ko po sa Committee on Justice.
Now, kung yung copy ng printout ng screenshot ipapakita sa iyo, will you be able to identify the same?
Yes, sir.
Now, I'm showing you a printout of a screenshot ng Facebook post ng PNP dated November 23, 2024. Title is PNP Statement that is previously marked as Exhibit P14. P-Roman numeral 417. What relation, if any?
Your Honor, may I
Counsel
ask,
for the respondent.
may I ask that we be allowed to peruse before he asks his question to identify the document?
Counsel is directed to kindly give opposing counsel for the respondent a copy of the document being presented to the witness.
Your Honor, both documents appear to be photocopies, Your Honor.
Noted, and I presume the continuing objection and comment of the counsel for respondent will be placed on record as well.
Thank you, Your Honor.
Witness may answer.
It is a copy of the submitted document to the Committee on Justice, sir.
How faithful, if at all, is this printout sa naging actual screenshot?
It accurately reflects the screenshot.
At saka paano mo nasabi na that printout accurately reflects the screenshot?
I compared the screenshot with the printout and the web page where this was posted and found that the contents are identical.
Okay, so let's go to the last agency, Mr. Witness. Nasabi mo rin na yung National Security Council or NSC nag-issue ng statement sa naging mga pagbabanta ng Vice President. Ano bang pruweba mo kung meron man sa naging tugon ng National Security Council or NSC?
I have the screenshot of the statement of National Security Council on the official webpage of the Presidential Communication Officer.
Sino yung kumuha ng screenshot?
I did, sir, and I used my laptop.
Okay, anong ginawa mo kung meron man sa naging screenshot na yan?
Sinip ko muna electronic copy ng screenshot sa laptop ko and
Sana
printed it.
yung screenshot na yan kung alam mo?
Pinrint ko, sir.
Now, kung yung kopya ng screenshot na yan ipapakita sa'yo, ma-identify mo ba?
Yes, sir.
Now, we are in the process of showing you a printout. The defense may produce the document sa screenshot ng National Security Council statement. Okay, previously marked as Exhibit P Roman numeral 4-18.
Your Honor, the Exhibit P-4-18 is a photocopy.
Noted.
Okay. May I ask the question?
Kindly return the document to the witness so that witness may answer.
Mr. Witness, what relation, if any, does that document have with the printout of the screenshot you mentioned?
This is the copy that was submitted to the Committee on Justice, sir.
How faithful, if at all, is that printout from the actual screenshot?
It accurately reflects the screenshot, sir.
And how do you know that that printout accurately reflects the screenshot?
I compared the screenshot with the printouts and the web page and found that the contents are identical, sir.
Okay, done. Now, Mr. Witness, let's proceed. Sinabi mo rin na in the course you conducted yung open source investigation now. What happened, if any, in the course of your investigation in relation to the statements of the Vice President after you collated the videos, the screenshots of the several governmental agencies?
We then proceed to the issuance of subpoena, sir, to the following individuals who were present on November 23, 2024. Bons Magsambol, Red Mendoza, Dempsey Reyes, Ana Malindog Uy, Mikhail Flores, and Jason Rubrico, sir.
Alright, now, yung tanong, Mr. Witness, is, ba't kaya nag-issue, kung alam mo, no? Ba't nag-issue yung NBI ng subpoena sa mga taong ito?
Nandun po kasi sila sa press during the November 23, 2024 online press conference, sir.
Alright, now, ano ba yung nangyari kung meron man after yung NBI nag-issue ng, ano ba yan, subpoenas ba yan or subpoena sa mga taong ito?
Dumating po sa office namin si Dempsey Reyes and Bons Magsambol noong December 4, 2024 and inassign po sa akin na i-interview at ako po yung nag-interview.
So, Your Honor, please, may Dempsey Reyes' soul rest in peace. Now, ano ba yung nangyari kung meron man during your interview with namayapang si Dempsey Reyes?
He confirmed po na he was present during the November 23, 2024 online press conference. And he also confirmed that he heard the Vice President utter the statement, quote and quote. May I refer to the notes for the exact statement?
Your Honor,
The witness may do so.
He confirmed the statement, he heard the statement of the Vice President, quote and quote, yes, huwag kang mag-alala, ma'am, sa security ko kasi may kinausap na ako na tao. Sinabi ko
Your
sa
Honor,
kanya.
May I object? This is hearsay.
oh,
Objection is sustained.
mhm.
Counsel, clearly you're trying to use this witness to present an affidavit of another person who has already passed.
If I may, Your Honor, please.
Counsel may respond.
Your Honor, please, that is not an affidavit of Dempsey Reyes, Your Honor, please. The question was what happened during his interview with that person. And he has just answered the question by saying that Dempsey Reyes confirmed that he was there and that he heard the Vice President uttering the statement, Your Honor, please. Does that hearsay, Your Honor, please? And be that as it may, Your Honor, please, we invoke a doctrine that we call an independently relevant statements. The defense is reacting. I don't know why. Your Honor, please, IRS would allow this witness to testify as to what the other person told him as to that fact, the making of the statements, as to whether or not what the person said is true or not. That is not material at this point, Your Honor, please.
Let the court clarify then. As to tenor, the court will allow it. As to the fact, as to the supposed fact that the witness told this what's his name? Dempsey Reyes made those utterances to the witness, but not as to the truth
Yes.
of what Dempsey Kaiden Reyes said. As to subject to that clarification, court will allow it.
Thank
Counsel,
you so,
proceed.
Thank you so much, Your Honor, please. What about this Bonds Magsambol? Ano ba yung nangyari sa interview with him, kung meron man?
Bonds Magsambol also confirmed that he was present.
Objection, Your Honor. Same objection.
And same ruling, I suppose.
Let the witness first answer and the court will make a ruling because he might have a different answer. Because counsel, note, the affidavit of the witness appended the affidavit of this Bonds guy, but did not do so with the affidavit of Dempsey. So court will listen, presiding officer will listen to the witness before ruling on the matter, and may have the same ruling unless he gives a different answer. Please, witness, Mr. Answer. Please, Mr. Witness, kindly answer.
Thank you, Your Honor. Bonds Magsambol also confirmed that he was present on the November 23, 2024 online press conference held by the Office of the Vice President. And he also confirmed that he heard the utterance of the Vice President making the statement.
Same ruling, only as to tenor. The court will admit it, not as to the truth that indeed what Bonds said is true, but only as to the fact that he told the witness those statements in the Q&A that they had.
If I may.
What is the pleasure of Senator Judge Rafi Tulfo?
Mr. Presiding Officer, I just have some clarificatory questions for
The gentleman
the
may proceed and he has 2 minutes.
expert witness. Sabi mo meron kang 2 weeks lecture experience as a digital evidence expert. Is that right? 2 weeks?
2 weeks training.
Wala ka naman iba pang training?
I have a
Seminars?
training on different digital forensic aspect.
Dito sa abroad meron?
Meron po, pero yung specific sa photo and video authentication, yun po yung 2 weeks.
So all in all total you have 2 years experience plus 2 weeks lecture lang pagdating sa authentication ng forensic evidence?
For the photo and video, sir.
For the photo and video, which ito yung pinag-usapan natin yan.
Yes po.
Now, my question to you, in your testimony, Mr. Witness, you did mention that you personally investigated the alleged inciting to sedition by the BP Sara Duterte video, correct?
Yes, Your Honor.
Now, in doing so, in the course of your investigation, did you look at the comments section? If you did, ano yung mga reactions doon? Ano yung mga statements doon sa comment sections? na mga nag-view ng videos?
There are comments that they agreed to the statement of the Vice President, but it was not documented, sir.
That's all, Mr. Presiding Officer. Thank you.
Thank you, Senator Judge Tulfo. Counsel, you may proceed.
Thank you so much, Your Honor. Mr. Witness, let's proceed. What proof, if any, do you have that Dempsey Reyes confirmed that he heard the Vice President utter those words?
I have the signed minutes of interview with Dempsey Reyes and an affidavit that I executed attesting to the interview, sir.
All right. Now, what about this Bones Magsambol? What proof, if any, do you have that he confirmed that he heard the Vice President utter those words?
I have the minutes of interview with Bones Magsambol, sir, that he was signed. And I also have the affidavit that attesting that I interviewed Bones Magsambol, sir.
So far, Mr. Witness, you mentioned 1 minutes and affidavits. Now, kung yung mga dokumentong ito ipapakita sa'yo, do you think you'll be able to identify the same?
Yes, sir.
Now, I'm now showing you a document entitled Side Minutes that is previously marked as Exhibit P Roman numeral 4-20 and series. Please peruse that document.
May the defense be allowed also to peruse, Your Honor.
The defense may, the counsel for respondent may look at the document.
Your Honor, for the record, the documents marked as Exhibit P-4-20 to P-4-20E are photocopies, and Exhibit P-4-20D is unreadable, as well as P-4-20E, Your Honor.
Which one is unreadable, counsel?
P-4-20D and P-4-20E.
20D?
D for dog, Your Honor. D and E. Delta Echo.
What does P-4-20D seek to show, counsel for the prosecution?
If I may peruse the document, John, please. Stephen, I need to see the document. And let's get the...
Because indeed, the presiding officer confirms that it is, I cannot decipher what it seeks to show. Unless the photocopy of a photocopy is what I have.
John, please, so may we be given 2 minutes to secure the other copies of that document.
Your Honor.
And P-4- Roman numeral number 4-20E?
Yes, Your Honor. Your Honor,
This is the one with the blurred face of the Vice President?
Yes, Your Honor.
Supposedly on a computer?
Your Honor, may we object on the 2 minutes? Because this is the document. They are already having him identify. Do they mean to correct that mistake?
Counsel, do not waste the court's time in regard to this.
Your Honor, if I may.
Yes, counsel for the
We
prosecution.
abide by the copies as they are. We abide by the copies as they are, Your Honor, please.
So let's see, Mr.
Yes.
Witness, what do you see in front of you? Insofar as P-4-20D and E is concerned.
Hindi. Same. Same. Hindi yung blurry.
So pareho malabo yung kopya natin. Yan at yung kopya ko din. Mr. Witness, if you don't see anything, it's okay.
I can only confirm the signed minutes, but the annexes, there are some unreadable, Your Honor.
Yeah. Yeah.
But the signed minutes, I confirm, sir, that this is
The what?
the copy of the minutes.
Your Honor,
This is the copy of
The
the minutes.
minutes, but not the attachment, because clearly the attachment P4-20D and -E are both
Yes, Your Honor.
unclear. Would that be correct?
Yes, Your Honor.
So only as to the supposed affidavit and not to the two attachments. You
Yes, Your
cannot
Honor.
identify them. Noted.
Thank you so much. Now, on page 4 of the signed minutes, Mr. Witness, there appears a signature above the name Dempsey Saiden Reyes. Whose signature is that, if you know?
It is the signature of Dempsey Reyes, sir.
And how do you know that that is his signature?
I saw him sign the document after our interview, sir.
Now, on page 4 of the signed minutes, may pirma din sa ibabaw ng pangalan ng isang Attorney Jetro Lorenza A. Cuon. Kaninong signature ito kung alam mo?
Signature of Attorney Cuon po, who is the counsel of Dempsey Reyes and present during the interview, sir.
And how do you know that that is signature?
I saw him sign the document after the interview, sir.
Now, sa page 4 ng side minutes, let's go to page 4, Mr. Witness. Makikita mo dyan yung signature sa ibabaw ng pangalang Agent John Mark Calidong. Whose signature is that, if you know?
This is my signature, sir.
Okay, now, let's, you also mentioned ng affidavit. No? Kung yung affidavit na ito ay papakita sa'yo, will you be able to identify the same?
Yes, sir.
Now, ipinapakita ko sa inyo now yung affidavit dated February 10, 2025.
Your Honor, may we also be allowed to peruse?
Yes.
Thank you, Your Honor.
Kindly exhibit and show to counsel for the respondent the document you are showing to the witness.
That is previously marked as Exhibit P-14-19 and series. And if the court may inquire as to the remainder of the testimony of this witness, we are about to wind up the testimony of this witness, Your Please.
Your Honor,
Thank you,
for the
counsel.
record, this is a photocopy. This is Exhibit P-4-19.
Noted.
Okay. Mr. Witness, have you perused that document? Have you perused the document? Nabasa mo na ba yung dokumentong iyan?
Yes, sir.
Now, what relation, if any, does that document have with the affidavit you mentioned?
This is the affidavit attesting my interview with Dempsey Reyes, sir. Copy of the affidavit, sir.
Now, on page 2 of the affidavit, may makikitang pirma sa ibabaw ng pangalang Agent John Mark Calidong. Kaninong pirma ba iyan?
It is my signature, sir.
Now, on page 2, may pirma din sa ibabaw ng pangalang Attorney Van Homer ang Luben. Kaninong pirma ba iyan?
Signature po ni Attorney ang Luben, sir.
Ba't mo nalaman na iyan ay isang pirma ni Attorney ang Luben?
I saw him sign the document and I have viewed and acted upon documents bearing his signature. Kaya pamilyar po ako.
Thank you so much. Now, I'm now showing you the other affidavit of even date, February 10, 2025. That is previously marked as Exhibit P-Roman numeral 4-21 and series.
Your
May
Honor.
you peruse the same?
Your Honor, may be allowed. Thank you, Your Honor.
Kindly show counsel for respondent a copy of the document that the witness will testify to.
Thank you so much.
For the record, Your Honor, the Exhibit P-4-21 and Exhibit P-4-21A are photocopies.
Duly noted. Kindly return the document to the witness for his perusal.
We are returning the document to the witness, Your Honor.
Stephen, wait, ano yun? P14, P422C.
Counsel, please proceed.
Thank you so much, Your Honor. Please, on what relation, if any, have you answered the question? Does this document have with the one you mentioned?
This is the copy of the affidavit of interview with Bons Magsambol. Your Honor, yes, please the copy, sir.
Now, on page 2 of the affidavit, may pirma sa ibabaw ng pangalang Agent John Mark Calilong. Kaninong pirma ba yan?
This is my signature, sir.
Sa pahina, page 2, may makikita din isang pirma sa ibabaw ng pangalang Attorney Van Homer ang Luben. Kaninong pirma ba yan?
This is the signature of Attorney Van Ang Ruben, sir.
Ba't mo nalaman na iyan ay isang pirma ni Attorney ang Luben?
Nakita ko po niya, pinirmahan po yung document and may mga documents pa po ako nakita na pirmado niya.
Now, Mr. Witness, thank you so much. Now, we are showing you yung dokumento entitled Signed Minutes. That is previously marked as Exhibit P-Roman numeral 4-22 and series. May you peruse the same. Defense may also peruse that document.
Thank you, Your Honor.
Kindly show a copy to the counsel for respondent.
Your Honor, Exhibits P-4-22 to Exhibits P-4-22G are photocopies, and Exhibit P-4-22F Foxtrot and P-4-22G Golf are unreadable. For the record, we are returning the document to the witness.
For the record as well, Chair confirms the observation of counsel for respondent in regard to P-4-22F and P-4-22G. And the presiding officer would like to once again ask the witness, can he decipher what is in the two exhibits mentioned by counsel for respondent? Again, P-4-22F, P-4-22G.
Your Honor, I can confirm the signed minutes, but the attachment, there are unreadable, Your Honor.
The two exhibits.
Annex A and Annex B with Exhibit 4-22F and P-4-22G.
Duly noted.
Thank you so much. May proceed, Your Honor, please. On page 6 ng side minutes, may makikitang pirma sa ibabaw ng pangalang Bons Magsambol. Kaninong pirma ba yan?
This is the signature of Bons Magsambol, sir.
Then how do you know that pirma yan ni Bons Magsambol?
Nakita ko po ito nung sinign po niya yung document after ng interview.
Now, you go to page 6 ng side minutes na yan. May makikitang pirma sa ibabaw ng pangalang Attorney Michael Christopher De Castro. Kaninong pirma ba yan kung alam mo?
Pirma po ito ni Attorney De Castro. Counsel po ni Bons Magsambol during the time ng interview na present during that time.
Yung tanong is, paano mo nalaman na yan ay pirma ni Attorney De Castro?
Nakita ko pong pinirma niya to after the interview, sir.
Now, let's go to page 6 of that minutes. May makikitang pirma sa ibabaw ng pangalang Agent John Mark Calilong. Kaninong pirma ba yan?
Pirma ko po, sir.
Okay. Now, Mr. Witness. Mr. Witness, you mentioned that the NBI conducted an investigation on the threats uttered by the Vice President against the President, the First Lady, at saka former Speaker of the House of Representatives. Now, ano ba yung nangyari? Ano ba yung nangyari kung meron man pagkatapos ng naging investigasyon ng NBI?
Objection, Your Honor. Misleading. He assumes as fact not testified to by the witness.
Kindly rephrase, Counsel.
Okay, now, what happened next, if any, and if you know, and in relation to the investigation conducted by the NBI, after the NBI's investigation?
Objection, Your Honor.
Your Honor.
Same objection.
Your Honor, please, if I may.
Witness may answer.
After the investigation, we executed an affidavit of investigation and recommended the filing of inciting to sedition and 3 counts of grave threat, both in relation to Cybercrime Prevention Act of 2012, sir.
Now, sinabi mo na yung NBI, you signed, executed yung affidavit of investigation, correct?
Our team, sir.
Now, ano ba yung nangyari kung meron man at saka kung alam mo, okay, pagkatapos may execute ang affidavit of investigation na yan in relation to the investigation you did on the Vice President?
We filed it to the DOJ, the affidavit of investigation, together with its annexes, sir.
Okay, you said you filed the affidavit. Now, question, ano yung mga nangyari kung meron man, kung alam mo, after ma-file yung affidavit of investigation with the DOJ in relation to the investigation you conducted on the Vice President?
We further conduct an investigation wherein we identified different videos, at least 3, that we find relevant to the November 23, sir.
Okay, so you are now mentioning videos. Sinabi mo relevant. Relevant again to what?
To the November 23, 2024 video, sir.
All right. Now, so for the record, this is now the 3rd set of videos you're referring to.
Yes, sir.
Now, ano yung mga videos na ito kung alam mo, Mr. Witness?
The June 19 video wherein the Vice President resigned as the Secretary of the Department of Education. The July 11 video wherein the Vice President state that she would not attend the SONA, but instead declare herself as the designated survivor. And lastly, the November 26 video wherein the Vice President did not deny making statement, but instead confirmed that she already talked to someone to kill the President, the First Lady, and former Speaker of the House if she was killed.
So for the record, you mentioned of 3 videos. One is dated June 19, 2024, June 11, 2024, tsaka November 26 ba yun? 2024. Now, let's go to this video na sinabi mo ng Vice President resigning as the Secretary ng Department of Education on June 19. Ano yung pruweba mo that you have, sinabi mo rin na authenticate mo yung video, correct?
Yes po.
Ano yung pruweba mo that you authenticated this video?
I have executed an affidavit of authentication of digital evidence dated April 30, 2026, sir.
Kung yung kopya ng affidavit of authentication now dated, sinabi mo, April 30, 2026, may papakita sa'yo. Okay? Ma-identify mo ba yan?
Yes, sir.
Now, we are in the process of showing you yung isang affidavit of authentication of digital evidence dated April 30, 2026 that is previously marked as Exhibit P-Roman numeral 4-25 and series. Defense is in the process of other manifestation of perusing that document.
Your Honor, exhibits
Counsel for the respondent.
Thank you, Your Honor. Exhibit P-4-25 to Exhibit P-4-25F, Foxtrot, are photocopies, Your Honor. And Exhibit P-14-25B and P-14-25F, Foxtrot. Let's take it to P-4-25B, Your Honor. P-12-25B is unreadable and it merely shows a black screen. Meanwhile, P-4-25F, it seems to be a photocopy of a USB with no real USB attached. For the record, we are returning the
Duly noted, and the
document.
presiding officer likewise confirms the observation of counsel for the respondent. Kindly return the document to the witness.
Mr. Witness, the question is, what relation, if any, does that document have with the affidavit you mentioned?
This is a copy of the Affidavit of Authentication of Digital Evidence dated April 30, 2026, which I executed. And on the annexes, on Annex B, there is a missing part. It may be due to... I can't read some words on Annex B.
Mr. Witness, when you say Annex B, you're referring to Exhibit P-4-25C.
Yes, Your Honor.
For the record, please proceed.
And also on Annex D, Exhibit P-4-25E, there is some missing. But the only missing is the hash file, maybe due to printing.
For
So
the
it's
record,
not recognizable.
For the record,
Mr.
Your Honor,
Witness.
the hash file is missing. The witness said the hash file is missing.
The command.
The hash file is missing as stated by the witness. Yes. Please proceed, Mr. Witness. How about P-4-25F?
Yes, I confirm, Your Honor, that's a
What
photocopy of
do
the
you
flash
confirm?
drive.
The picture ng USB to?
Yes, Your Honor, a picture of the flash drive.
Your Honor.
Please proceed, counsel, for the prosecution.
But this is the Affidavit of
This is
Authentication
the
of Digital
affidavit.
Evidence.
Again, could you repeat your answer?
This is the Affidavit of Authentication of Digital Evidence that I executed, but there are, on the annexes that I mentioned, there are some that unreadable.
Thank you. May I make a manifestation, Your Honor, please? As to this affidavit, it pertains to a
Counsel may
video,
proceed.
as to the video of the Vice President resigning, Your Honor, please. And we're supposed to present the flash drive that the defense pointed that they only have the photocopy. Be that as it may, Your Honor, please, we are waiving the presentation of the video of the Vice President resigning because, Your Honor, in the pre-trial order, specifically on page 3 thereof, the defense already admitted that the Vice President resigned on June 19, 2024.
The presiding
Your Honor, please.
officer was exactly about to state that. There is no need for the counsel, for the prosecution to present evidence on an admitted fact.
Thank you so much, Your Honor, please. May I proceed, Your Honor, please?
Counsel may proceed.
Now, Mr. Witness, you also mentioned that you authenticated a video where the Vice President said that she would not attend the SONA and instead publicly declared herself as the, quote, designated survivor, unquote. What proof, if any, do you have that you authenticated the video?
It's part of the affidavit of authentication of digital evidence dated April 30, 2026, which I previously identified, sir.
What happened next, if any, after you authenticated the video of the Vice President announcing that she is keeping the SONA and declaring herself as a designated survivor?
I saved the video on my laptop and saved a copy on a flash drive, sir.
You saved a copy in a flash drive. Now, if this flash drive containing the video where the Vice President said she declared herself as the designated survivor after skipping the SONA is shown to you, will you be able to identify the same?
Yes, sir.
Now, we are now in the process of confronting you with a flash drive that is previously marked as Exhibit P Roman numeral 4-24 small letter A for the prosecution, containing the recording of the Vice President where she said that she would not attend the SONA and instead declared herself as the, quote, designated survivor, unquote, previously marked as Exhibit P Roman numeral 4-24 for the prosecution.
Permission to unseal the flash drive, sir.
You may do so, Mr. Witness.
Thank you, Your Honor. This is the flash drive where I saved the recording, sir.
Mm-hmm. Now, you also mentioned that you authenticated a video that on November 26, 2024, the Vice President did not deny and instead confirmed her utterances of contracting an assassin to kill the President and the two others. What proof, if any, do you have that you authenticated the video?
I have executed an affidavit of authentication of digital evidence dated April 27, 2026, sir.
And then, aside from that affidavit, do you have other proof, if any?
For objection, Your Honor, leading.
If any, Your Honor, if any.
It's still answerable by yes or no.
Yes, sir.
Ask an answer, Your Honor, please.
Your
Now,
Honor, please, can the witness be directed to wait until the court rules on an objection before answering?
But the
Witness is so directed.
Okay,
Thank you, Your Honor.
Ask and answer. So what is that, if any?
Yes, sir. I also executed an affidavit of authentication of digital evidence dated June 11, 2026.
So you mentioned two affidavits in result, correct, Mr. Witness?
Yes, sir.
Mr. Witness, I'm showing you a document entitled Affidavit of Authentication of Digital Evidence dated April 27, 2026. That is previously marked as Exhibit P Roman numeral 4-27 and series. May you peruse the same. Defense, Your Honor, manifestation is in the process of perusing the same documents.
It's
not here. Show it.
Your Honor, for the record, the exhibits P-4-27 to exhibit P-4-27D are photocopies, and on exhibit P-4-27D, it would seem to be a mere photocopy of a USB, an image of a USB and no actual USB appended.
Chair confirms the observation of the counsel for responding insofar as P-4-27D is concerned.
May proceed, Your Honor,
Kindly
please.
return the document to the witness so that he may answer.
So what relation, if any, does that document have with the affidavit that you mentioned?
This is a copy of the affidavit of authentication of digital evidence that I executed, sir, dated April 27, 2026, sir.
And on page 2 of that affidavit, may makikitang pirma sa ibabaw ng pangalang John Mark Calilong. Kaninong pirma ba yan?
Signature ko, sir.
Then sa page 2 ng affidavit, may makikitang pirma sa ibabaw ng pangalan ng isang attorney, Ria Vanessa Asuncion. Kaninong pirma ba yan?
Pirma po ni Attorney Asuncion, sir.
At paano mo nalaman na iyan ay isang pirma ni Attorney Asuncion?
Nakita ko po na pinirmahan niya yung document and I have acted upon documents bearing her signature, sir.
Okay. Mr. Witness, you also mentioned of the other affidavit on the collection preservation. No? Sinabi mo dated June 11, 2026. Di po ba?
Yes, sir.
Na yung kung affidavit na iyan, ipapakita sa'yo, ma-identify mo ba yung affidavit na iyan?
Yes, sir.
Now, I'm showing you, the prosecution is showing you a copy of that affidavit that is previously marked, Exhibit P-Roman numeral 4-28 and series for the prosecution. May you peruse the same. And for the record, Your Honor, I'm about to ask a few more questions and the prosecution is finally done with this first witness, Your Honor, please.
Noted.
Your Honor.
Counsel for respondent.
Your Honor, for exhibits P-4-28 to exhibit P-4-28H, these are photocopies. And Your Honor, we note the affidavit on the collection, preservation, and authentication of digital evidence in page 2, which is exhibit P-4-28A, mentions a copy of an affidavit of authentication of digital evidence dated January 30, 2025 is attached herewith as Annex A under footnote 1, but upon perusal, no Annex A is attached to the affidavit. On exhibit P-4-28B, under footnote 2, it says a copy of the preservation request dated 24 November 2024 is attached as Annex B, but we note that there is no preservation request or Annex B appended. As footnote number 3 of the same exhibit, a copy of the email dated November 28, 2024 from Meta is attached herewith as Annex C. However, no Annex C is appended upon the affidavit. As footnote number 4, it says a copy of the authenticated recording of the video of the online live stream press conference of the Vice President held on 23 November 2024. And it says it's attached here as Annex D. However, no Annex D is attached on this affidavit. As footnote number 5, a copy of the printout of the screenshot of hash file VP November 23 press con at the Batasan is attached here with this Annex E. However, no hash value or printout thereof is appended as any Annex E. As footnote 6 of the same exhibit, it says a copy of the VP November 23 press con at Batasan CCD transcript is attached as Annex F, and a copy of the affidavit of transcription dated December 2024 is attached as Annex G. However, no Batasan CCD transcript of the November 23 press con or affidavit of transcription are attached as Annexes F or G respectively. For Exhibit P-4-28C, the footnote 7 says a copy of authenticated 18 October 2024 video is attached as Annex H. However, no Annex H or an authenticated video is attached hereon. As footnote number 8, a copy of the printout of screenshot of hash file is attached as Annex I. However, no printout of such hash file is found on this document.
If I may, are we done?
No.
Okay, proceed.
On Exhibit P-4-28D, footnote 9 says a copy of the VP SD press briefing dated 18 October 2024 CCD transcript is attached as Annex J, and a copy of the affidavit of transcription dated 3 February 2025 is attached as Annex K. However, no press briefing or affidavit of transcription dated February 3, 2025 are appended as an
With the
Annex.
permission of the counsel for respondent to abbreviate the proceedings, counsel for the prosecution, will you stipulate that none of the attachments contained in the footnote until Annex KK
if I may,
is attached to the affidavit that you are presenting the witness?
If with a counter manifestation, Your Honor, please, that this latest affidavit of authentication tries to summarize each and every other affidavit authentication. So as to the concern of the defense, Your Honor, please, this is just a summary of all the other affidavits of authentication.
Subject to that
stipulated.
qualification, but indeed it did not contain and does not contain, or the annexes purported to be part of this affidavit.
Yes, Your
Does
Honor.
counsel or respondent confirm that it is up to Annex KK?
Your Honor, we confirm.
KK, tama ba?
We
Hanggang KK,
confirm
diba?
that is it until KK, Your Honor.
KK. Noted, subject to the brief manifestation of counsel, but indeed the chair presiding officer confirms that none of the annexes contained in all of the footnotes until Annex KK is attached to the affidavit being presented to the witness.
Your Honor, please. Thank you so
Noted.
much. May I proceed? Mr.
Counsel,
Witness.
For the record, we're returning
Yes, counsel for respondent.
the document to the witness.
Mr. Witness, have you perused that document?
Yes, sir. This is a copy of the affidavit of authentication, collection, preservation, authentication of digital evidence, dated June 11, 2026. And it doesn't have annexes here.
Yeah, okay. May I proceed, Your Honor, please? Mr. Witness, what happened next, if any, after you authenticated the video of the Vice President, that on November 26, 2024, you said the Vice President did not deny that she made the threats, and in fact, she confirmed her utterances should something happen to her. What happened next, if any, after that?
Objection, Your
What is the objection of counsel?
Leading.
Misleading, Your Honor. No mention.
Oh.
The witness did not mention this.
Your Honor,
Witness may answer.
I saved the video of the November 26, 2024 online interview on my computer and on a flash drive.
Now,
Your Honor, before we
Counsel for respondent.
proceeds, may I request that the counsel for the prosecution refrain from characterization, testifying on what the document or the video is. So, Your Honor, I request that.
Your Honor, I'm just merely describing an affidavit or a document or an object that this witness already testified to. I'm just repeating what the witness said. I'm not adding any value whatsoever to what the witness already testified to, Your Honor, please.
Precisely, Your Honor.
And there's nothing
my point.
wrong with that. Nothing
Precisely
in
my
the rules
point, Your
would
Honor. It's
disallow me to
improper.
do that, Your Honor, please.
Will counsels kindly wait for the presiding officer to recognize them before they speak? Counsel will instead advise the senator judges to kindly listen, take note of the pieces of evidence presented through a witness under oath and subject to cross-examination, and not statements made by either counsel that are conclusions of fact and or law in arriving at their decision. The chair will be more mindful, counsel for respondent, insofar as that is concerned.
Thank you, Your
Counsel
Honor.
for the prosecution, you may proceed.
Thank you. Mr. Witness, you mentioned a flash drive, correct?
Yes, sir.
Now, kung yung flash drive na iyan, ipapakita sa iyo, ma-identify mo ba yan?
Yes po.
Now, ngayon, ipinapakita ko yung flash drive na previously marked as Exhibit P1426 containing the video recording of the Vice President on November 26, 2024 that is previously marked as Exhibit P-Roman numeral 426. May you peruse the same.
Permission to unseal the flash drive, sir.
Witness may do so.
Thank you, Your Honor.
Oh.
This is the flash drive where I saved the recording, sir.
Now, thank you so much. Now, you mentioned that you authenticated the recording of the video of the Vice President on November 26, 2024. Okay, sinabi mo, the Vice President did not deny that she made the threats. In fact, she made the utterance. Not yet done, Mr. Witness. Now, the question now is, in what particular portion of that video did the Vice President not deny that she made those threats, if you know?
Permission to refer to my investigator's notes, sir.
You may do so.
Thank you, Your Honor. Timestamp 10 minutes and 40 seconds to timestamp 11 minutes and 50 seconds, sir.
So it's from timestamps 10 minutes to 40 seconds to 11 minutes, 50 seconds. A quick calculation, that would be 1 minute and 19 seconds. Mr. Witness?
Yes, sir. 1 minute and 10 seconds.
I'm about to show you now that 1 minute and 18 seconds portion, particularly from timestamps 10 minutes, 40 seconds to 11 minutes, 50 seconds. May we allow Attorney Stephen Magallon?
Will one of the counsels for respondent accompany the counsel for the prosecution to make sure that it is the same USB identified by the witness that will be played by the tech
Thank you, Your Honor.
of the clerk of court?
me, another person warned me, and then I was asked during a press briefing by a media person if I know of these plans, if you can say the word, if that is the correct word to use here, plans. So I answered. I was asked Romanov, and then I answered. I was told by two people, this is the first time I've heard of Romanov, so that is the third already. And I said, don't worry about my security. If they kill me, if I die, kapag pinatay ako, or kapag namatay ako, in the context of don't worry about my security. So this means pinatay ka. Diba? Kasi hindi ka naman mamamatay by heart attack in relation to your security. Diba? So, pag namatay ako, I already asked a person to take revenge against 3 individuals. So, my question now.
So, last question for this prosecution witness. You
Counsel may
confirm.
proceed.
Kinukumpirma mo, Mr. Witness. When confronted with the question whether she uttered those threats against the President, the First Lady, and the former Speaker of the House, the Vice President did not deny, and she confirmed she made those threats.
Objection, Your Honor.
What is the objection?
Leading.
Witness may not answer.
Counsel, kindly rephrase. It's your last question.
I
Let's
will.
kindly rephrase.
Okay, now, Mr. Witness, base sa video na yan, makikita mo ba, base sa video na yan, na yung Vice President, instead of denying, she confirmed that she made those threats.
Objection, leading.
I will withdraw the question. That's all for this witness, Your Honor, please.
Thank you very much. Bugso ng kahilingan ng ilan sa aming mga miyembro dahil sa kapasyahan na rin ng presiding officer, ipagpapaliban natin ang cross-examination ng counsel for respondent para bukas. The witness is under the same obligation to appear tomorrow by virtue of the same subpoena issued to him. The same is true with respect to Attorney Jeremy Lontok, especially given that the subpoena gives 2 dates for the required appearance of the 2 NBI agents. Any other points that any of the parties wish to make before we adjourn?
Your Honor,
Yes.
please, admin matter, Your Honor,
Counsel
please.
for the prosecutor.
For the record, the exhibits, in particular the flash drives, were unsealed. May I move that representatives from both sides be present to seal again those flash drives and for counter signatures from both sides, Your Honor, please.
We were worried about that, but I was waiting for the counsel to actually ask for that. When can we do this? Would some counsels for the parties wish to remain
Yes,
after
Your
we
Honor.
adjourn, just so that we can sign and seal the USBs?
Of course, Your Honor.
For the record, Attorney Legutan will be representing the counsel for prosecutors, and on the part of the respondent, it will be Attorney Narvasa. That will be correct. By the way, while we're
Yes, Your
waiting
Honor.
for the witness, Attorney Narvasa, if you recall yesterday, Attorney Legutan, in response to a question by a senator judge, gave a discussion, a peroration, if you will. But yesterday I said we will be giving counsel the same opportunity. I cleared it earlier with Senator Pia Cayetano, who wanted the statements deleted from the record. However, since this is a televised proceeding, nakita na eh, napakinggan na eh. So, i-erase ko man sa record, bali wala na lang. The fairest thing to do is to give you an opportunity as well. Attorney Ligutan spent 5 minutes and 18 seconds delivering his discussion. The court will give you the same time after your cross-examination with a warning. With a warning and reminder from the presiding officer that the presiding officer will not tolerate such perorations again by either party, even if it is in response to a question of a senator judge, and the presiding officer will try to remind as best we can senator judges to let the witnesses present the evidence of both parties instead of the counsels presenting both facts and law through their statements. Senator Judge Cayetano, Alan.
I'd like to thank the presiding officer for prudence, for wisdom in trying to resolve this issue. And I do understand that we are 24 people, all elected by the people, all wanting justice, all wanting a fair trial. Having said that, prudence dictates that we stop ourselves from asking certain questions that can prejudice the whole trial, whether or not our intention is to do so. So the problem is well stated by the presiding officer that if we simply delete from the record, mapapanood nyo na rin naman sa YouTube yung magandang discussion ng prosecution. So, on one sense, it is fair to give the defense a chance to answer. But on another sense, it's unfair. Why? Because whoever phrases the question, lamang na eh. Kasi yung question nga is, why is this an impeachable offense? So for example, if I was the one who stood up yesterday and I asked the prosecution, why is this a political vendetta? And why is the House not investigating the flood control instead of investigating the Vice President? That would be unfair. That would be unfair to the House. That would be unfair to everyone. So simply giving the prosecution the chance to answer that question I asked would be unfair to everyone. So I do not know the solution. I accept the solution of the presiding officer. Now, let's not tolerate any more questions like that. I agree with Senator P. I don't like being called out. But that's the role of the presiding officer and the Senate President. No? So, sana yun lang, no, na one, when we ask the questions, we'll make sure it doesn't prejudice the whole trial. Whatever we say here, may ma-accuse na lawyering for the prosecution or defense. Okay lang yun. Okay lang yun. Sa prayer nga kahapon, di ba? Basta't justice, bahala na magalit. Okay. But my last point, Mr. President, let's give the defense a little latitude in not only answering that question, but what you want to say. Because nga, the question is unfair. So if you're simply going to answer that question, then it won't solve the problem na nakapagsalita sila 5 minutes, kayo nakapagsalita. So we'll consider, personally, I'll consider the very eloquent answer yesterday as a sort of a closing. So same, personally lang, Mr. Presiding Officer, give the latitude to the defense na parang closing din, whatever. Because they have affirmative defenses. And they did not push us to hear that. They went straight to trial. So dun din sa mga nagsasabi na delay sa dami ng objection, that's unfair. No? Let's give everyone latitude here. The same thing, I think, may konting ano sa internet na photocopies are not original and the counsel was simply citing, tama ba? A Supreme Court decision, no?
And the rules of court.
And the rules of court. So I'm just saying it's an emotional issue. So all of us will be hit, badgered, whatever. I think trabaho naman nung witness natin, bantayan yung internet. So as long as hindi foul, hindi threat. But having said that, Mr. President, let's give each other leeway, but only to the point that the trial will not disintegrate, di ba, into a political fiasco or circus. Thank you, Mr. President.
The remarks of Senator Judge Alan Cayetano are noted. Senator Judge Pia Cayetano.
Thank you, Mr. President. This will be brief. First of all, I'd just like to confirm that I acknowledge what the presiding officer said, that I agreed. Basically, I'm withdrawing my motion in the interest of fairness, because the delivery of justice is about fairness. So kung nakapagsalita nga ang prosecution with their closing statement, di pwede rin dapat mag-closing statement ang defense, no? So I am amenable to that. But very, very, very briefly, Mr. President, I'd like to put on record, why are we being strict about the rules? Why do I have to bother standing up? Well, because nothing in this world will run well without the rules. Now, my colleagues, the Senate is a basketball-loving Senate. Dami dito, hilig mag-basketball. Kung ako volleyball player, colleagues ko, basketball. I'll use basketball as an example. Will you have a decent basketball game if there's no rules? No, there's rules. That's why we stand up. And then sometimes, there are also opportunities to question the rules. That's also fine. But that's why we have to stand up and call the attention of the presiding officer when we feel that the rules are being violated. And we will continue to do so when we believe it is necessary in the interest of justice. Thank you, Mr. President.
The remarks of the lady are noted. Since we are discussing housekeeping chores and matters, let the presiding officer continue with the same. The presiding officer will call for a break midway through in order to afford the parties 15 minutes to relax, go over their notes, and do their thing. In regard to senator judges or counsels for the parties who are not on deck, you're free to answer the call of nature in the least disruptive manner possible and return afterwards outside of the 15 minutes that we will be doing halfway through the proceedings. And finally, a request has been brought to the presiding officer to request as well the senator judges to lower the tone of conversational voices because I think where you're seated is an echo chamber. Naririnig sa iba't ibang sulok ng plenaryong ito yung mga sinasabi din ninyo at hindi rin nakakapag-concentrate yung ilan sa ating mga kasama na nakaupo sa paligiran ninyo. Just a reminder, and one last reminder before I recognize counsel for the respondent, Mr. Calilong, you will be testifying once again and will be undergoing cross-examination under the same oath
Yes, Your
that
Honor.
you took yesterday. Do you understand that?
Yes, Your Honor.
Thank you, counsel for respondent. Attorney Narvasa, if you're ready, you may proceed with your cross-examination.
Your Honor, may I be allowed to approach a witness?
You may do so.
Thank you, Your
counsel.
Honor. Good afternoon, Mr. Calilong.
Good afternoon, sir.
During your direct examination, you testified that you were trained on photo and video authentication.
Yes, sir.
You said that you were trained for 2 weeks?
Specific for photo and video, sir.
Sir, my questions are answerable by yes or a no. Can you
Yes, sir.
please constrain yourself to these questions, unless I tell you, okay?
Objection to that, Your Honor, please.
And you got this training from
Before counsel for respondent proceeds, counsel for the prosecutor to let the presiding officer
Your Honor.
recognize you first. You are so recognized, sir. What is your objection?
Thank you so much. Inasmuch as I would like to accommodate the defense that in asking the question that the witness is to be limited to a yes or no question, Your Honor, please. Unfortunately, Your Honor, please, that's not sanctioned in the rules. There's nothing in our rules that would allow a defense to constrain a witness, even on cross-examination, to answer the questions by a yes or no answer. It's not in the rules. So, Your Honor, please, we cannot constrain a witness to answering either a yes or a no. The witness should be able to qualify. The usual answer by the defense is that it could be handled by the prosecution on redirect. But that is not the case, Your Honor, please. So long as there is nothing in the rules that would allow the defense to constrain the witness to answer yes or no, the prosecution will vehemently object to that, Your Honor, please.
The presiding officer
May I, Your
overrules
Honor?
the presiding officer overrules the objection. The counsel for prosecutors can make a continuing objection regarding this matter, but it is the position of the presiding officer that the witness is seasoned enough. According to his testimony yesterday, he has attended over, if I recall correctly, 30 hearings already. So he would know how to respond and to explain if the need would arise and it's up for counsel for the respondent, if at all, to strike out whatever answers that are not responsive to his question. Counsel for respondent may proceed.
Thank
We
you.
would abide, Your Honor. We would abide.
Thank you, counsel for the prosecutors.
And you testified that you got this training from MaxCore Interventures,
Yes,
correct?
sir.
And you said that the training you got from MaxCore Interventures was in digital forensics.
Yes, sir.
I have with me in Articles of Partnership of MaxCore Interventures Co. You see that it states that it is the Articles of Partnership of MaxCore Interventures Co.
Your Honor, may we allow Attorney Stephen Magallon to also approach the witness stand to peruse the document. And of course, at this juncture, Your Honor, please, I have to object.
I have no question yet, Your Honor.
Yeah, I am objecting to the witness being shown an articles of incorporation, a
Articles of
partnership of a partnership, Your Honor, please. Anyways, since the question has not been asked, I will...
Let us wait for the question, counsel. In the meantime, the presiding officer allows counsel for the prosecutors to examine the document being presented to the witness.
And Your Honor, for the reference of the senators, we are flashing this Articles of Partnership on the screens. Sir, please take a look at page 2 of these articles. Page 2, sir. That's here. Page 1, page 2. Let's read it together, okay? Primary purpose, to engage in the business of trading both import and export of goods on wholesale, retail basis. Do you see that, sir?
Yes, sir.
Now on page, the same very same page 2. The secondary purpose. Let's read it together again. Own, use, improve, develop, subdivide, sell, exchange, lease of all kinds, including buildings, houses, apartments, and other structures. Do you see that, sir?
Yes, sir.
After that, in the same page 2, the secondary purpose is to print, publish, distribute, buy, sell, acquire rights to and generally deal in all kinds of software packages, books, periodicals, newspapers, magazines, journals, and other publications dealing in or having to do with subjects of all kinds, character, and all acts of things as may time to time be deemed needful, necessary, or required. You see that, sir?
Yes, sir.
Thank you, sir. Now I'm showing you a screenshot of the website of this MaxCore Interventures Co. It states under About Us. I am also flashing this on the screen, Your Honors, for the ease of the senator judges.
Your Honor, at this juncture, the prosecution will now manifest that there was no question propounded as to the presentation of the Articles of Partnership. And the counsel is now moving forward to the presentation of an alleged website. Therefore, it seems that the defense counsel is the one presenting the documents without propounding any question to this witness. Highly improper, Your Honor, please. Highly improper. The counsel should be asking question and not presenting document. You will have your turn when the defense team is allowed to present your evidence. 2 documents, no question yet. Highly improper, Your Honor, please. Again, I don't want to put the lawyer on the spot, but that is highly improper. Ask questions.
Your Honor, I did ask questions.
No, there was no question.
Counsel,
can we ask that the transcript be read back?
Counsel, kindly proceed.
Thank you.
Counsel for the prosecutors, with the understanding that Mr. Calilong is not testifying as to the truth of whatever counsel asked him or what he read, because clearly he's not competent to testify as to the truth of what is contained in the Articles of Partnership. However, as to the fact that he read it and saw it, up to that extent, and the senator judges are so advised as well. So ordered. You may proceed, sir.
Thank you, sir. And I am on cross, Your Honor. Thank you. Sir, under the words about us, it says MaxScore Interventures has been established as a one-stop source of different products and services intended for both government and private institutions. Its company tagline, Innovation Without Boundaries, stands true testament to provide customers with quality merchandise, from the simplest to the most sophisticated ones at very affordable prices. The company places a long-term business relationship through customer satisfaction on top of its priority list, with integrity and honesty as the foundation of the company. It envisions to evolve into excellence amidst the competitive pace of information technology. You see that, sir?
Yes, sir.
Sir, now I'm showing you another screenshot of the website of this MaxScore Interventures Co. You confirm that I'm also flashing this for the ease of the court. Sir,
At this point, Your Honor, please, allowed. The prosecution is allowed.
Counsel for the prosecutor is recognized.
Your Honor, not by way of an objection, but a manifestation, Your Honor, please.
Your Honor, this is...
Wait.
Before that, I would like to object to your manifestation. Your Honor, there's no objection. Why is the
Your Honor,
prosecutor allowed to manifest during my cross-examination?
Counsel for respondent, kindly wait for the presiding officer to recognize you.
Thank you, Your Honor.
What is the desire of the counsel for the prosecutors to make
I would like to put into record the simple fact, Your Honor, please, that basis has not yet been laid as to the presentation of these documents. He presented an articles of partnership and screenshots of websites without saying who took these screenshots or who, from where did the defense get the articles of partnership. That is only by way of manifestation. No need for the court to rule on that, Your Honor, please.
Noted. Earlier ruling of the presiding officer stands. Counsel may proceed.
Your Honor, may I respond?
No need, counsel. It was not an objection. Please proceed with your cross.
Thank you, Your Honor. May I also state a manifestation, Your Honor? Your Honor, the basis of the defense was laid...
For the record, the chair will allow it just this once, please.
The basis of the defense was laid when we asked him whether he testified that he got his training as an expert witness from MaxScore Ventures. That's basis,
Counsel, please proceed.
Thank you, Your Honor. Sir, could you take a look at this? Under the words "our products," the products seen there are office supplies and equipment, ICT equipment, software and hardware, investigative equipment, hardware and software, emergency response software, and CCTVs. Do you see that?
Yes.
Thank you. Mr. Calilong, are you a lawyer?
No, sir.
Yesterday, you testified that you signed the affidavit of investigation dated February 10, 2025.
Yes, sir.
Your Honor, may I request a copy from the prosecution? I think it is Exhibit P-4-3 in series.
P-4-3
series.
Your Honor, please, manifestation. The witness, number one, mentioned the affidavit of investigation, but that the witness did not identify the documents. So for the record, Your Honor, please, that document is not yet presented in courts as a documentary evidence, Your Honor, please. So highly improper for the defense to elicit that document through this witness, precisely because this witness did not yet identify the affidavit of investigation, Your Honor, please.
Which exhibit is this? I believe he did, Counsel, but which exhibit is this?
Exhibit P-4-3 to Exhibit P-4-3BB, Your Honor.
Your Honor, please, if I may, it was not yet identified, but it's pre-marked, Your Honor, please, to be presented by our next witness, Attorney Jeremy Lotok. So highly improper, in as much as we want to accommodate the defense.
So who is the signatory in that document? Is it
Your Honor, Mr. Kalilong is a signatory to that document.
is one of the signatories?
Yes.
Is one of the signatories. But the counsel for prosecutor is correct. This document has not yet been identified by any of the witness for the counsel for the prosecutors.
Yes.
You will get your chance, counsel for the respondent, when Attorney Lotok testifies later, which I believe this is the only exhibit that he will be testifying to.
All right, Your Honor.
Kindly proceed, counsel.
You mentioned a affidavit of investigation, correct?
Yes, sir.
And this affidavit of investigation, you sent a copy to the House of Representatives Committee on Justice.
Yes, sir.
You identified it during the House Committee hearings on April 29, 2025.
Yes, sir.
I'm showing you now an affidavit of investigation. This is marked as Exhibit D-4-46 and series, Your Honor.
D-4-46 and series. Is there a counterpart marking from the counsel for prosecutors?
Yes, Your Honor. This is P-4-3 to P-4-3BB.
Thank you. For the record.
This annex of this affidavit of investigation has appendages, correct? Annexes.
Yes, sir.
And it forms a whole, correct?
Yes, sir.
Okay. Sir, do you confirm that you signed this?
I'm one of the signatories, sir.
Do you want me to have him identify a signature? Okay. Your Honor, do you have here, sir? Kaso lang, sir, yung sinumpit mo po, I withdraw, Your Honor. Apart from this affidavit of investigation, dated February 10, are you aware if there is another affidavit of investigation executed by the NBI represented by the Cybercrime Division in relation to this case?
This is the only one that is submitted, sir.
No, executed, signed. My question is
The defense
executed.
cannot argue with the witness, Your Honor, please.
The witness would know how to respond, counsel. If he is not responsive to your question, do not argue with the witness.
Yes, Your
Kindly
Honor.
rephrase.
Apart from this affidavit of investigation, are you aware if there is any other affidavit of investigation signed by the NBI represented by the cybercrime?
Okay, at that juncture, I have to object. Vague, Your Honor, affidavit of investigation signed
Related
by
to
the
this
NBI.
case, Your
There could
Honor.
be thousands.
Related
of
to this
documents.
case.
If the witness knows, witness may answer. Is there any other affidavit of investigation executed by the NBI cybercrime in relation to this case, witness?
As far as I remember, sir, this is the final affidavit of investigation, sir.
Final affidavit. Are you sure, Agent? Let me remind you that you are under oath.
Yes, sir.
I have with me a certification, a DOJ certification, executed by J.V. Lawrence B. Bandung, Senior Assistant State Prosecutor J.V. Bandung. For the record, Your Honor, this is Exhibit D-4-29 for the defense. Do you see this, sir?
Yes, sir.
This certification dated February 5, 2025, states, and I quote, the complaint referral does not contain all the necessary evidence to prove the essential elements of the crime. Therefore, it is recommended that the same be first referred for case buildup. Do you see that?
Yes, sir.
Now below that, in the second page, below that, under the word notes, number 1, therefore, states, and I quote, that there is no... May I have this flashed on the screen, please? For the ease of the court. So the Honorable Court can follow. Under notes again, sir. For the record, Your Honor, we are flashing the certification on the screen. Under notes, sir, number 1 therefore states, and I quote, there is no affidavit of the persons who recorded the video entitled VP November 23 Press Con at Batasan through open broadcast software OBS and in turn stored it in a digital video disc. Do you see that, sir?
Yes, sir.
Let's go to page 2. On paragraph 7, it states, and I quote, one of the elements of the crime of grave threats is that the offender threatens another with infliction upon the latter's person, honor, or property, or upon that of the latter's family of any wrong amounting to any crime. In the instant complaint, only the NBI executed an affidavit and there was no participation on the part of the offended parties, as it appears. NBI is not the offended party for the crime of grave threats. Do you see that?
Yes, sir.
Above this, in paragraph 6, it states that, and I quote, only the minutes of the meeting with several personalities and representatives from various media outfits were submitted. And although the minutes were signed, there was no individual affidavit executed regarding the contents of said minutes. Do you see that, sir?
Yes, sir.
On paragraph 5, it states that, and I quote, the affidavit of one Patria Morales mentioned that she stored these footages in a USB and submitted it to the NBI. However, there was no USB attached to the complaint, only a DVD was attached. There was no detail regarding the contents of this DVD. Do you see that, sir?
Yes.
On paragraph 4, it states, and I quote, Annex L did not indicate who made such TSN. There was also no affidavit of the person who made the TSN. Do you see that?
Yes, sir.
On paragraph 3, it states that, and I quote, Annexes I and K, open parenthesis, DVDs with markings NBI-CNN-C-2412-43-6-2 and NBI-CCN-C-24-12436-2, close parenthesis, were not accompanied by an affidavit of the record and TSN, also affidavit of the one who will execute the TSN.
Yes, sir.
On paragraph 2, it states, and I quote, the press briefing conducted on October 18 was not recorded and or stored in a DVD, no video submitted, and there was no TSN of the said briefing and the necessary affidavit of the person taking the CSN.
Yes, sir.
Now you are aware, sir, so now is your memory refresher? Did the DOJ send back the original affidavit of investigation to the NBI?
Yes, sir. As far as
Thank you. Now, you are aware that on February 11, 2025, the NBI, through its then director, retired Judge Jaime B. Santiago, wrote to the Office of the Prosecutor General submitting a revised affidavit of investigation.
Yes, sir.
This is your affidavit of investigation dated February 10, right? February 10, 2025. Correct?
So, wait. So, objection, Your Honor. The defense said that this is your affidavit, dated February 10. without showing any document to
I'm
the
asking,
witness.
sir,
How could the witness answer to a question that is not accompanied with a document? That should be the basis for the question and the
and
answer,
this
Your
is
Honors.
your affidavit. I will reform, Your Honor.
Kindly reform, Counsel.
Thank you, Your Honor. This is your affidavit dated February 10, 2024, correct? Please check. Sorry, sir.
Your Honor, can I make a manifestation, Your Honor, please?
Your Honor, can we object again to this manifestation?
Manifestation. I will not even object. I'm being generous. Your Honor,
Counsel,
the
let's wait for the witness to review it. It's a voluminous document. And
No,
the signature is on the last page. You can make the corresponding objection to
signature.
the style, manner, or cross-examination of the counsel for responding at the proper time.
And po. Is this the amended affidavit of investigation?
This is a photocopy of the
Yes, sir.
affidavit, sir.
This is the amended one.
Yes,
Yes,
sir. The photocopy, sir.
Thank you.
With the permission of counsel, Mr. Calilong, what was the date of the first affidavit you submitted that was returned by the DOJ to the NBI?
As far as I remember, January 30, and was when the certification was issued, we complied with the requirements and submitted it on February 10. That's
Have
why
you
there's a revision.
identified that affidavit of investigation dated January 30 in yesterday's proceedings? No. Yes or no?
Sir?
Have you identified the January 30?
The one that I identified, Your Honor, is the authentication, Your Honor.
Not the affidavit of investigation. So you have not done so?
Yes, sir.
This one, you have not done so too?
Yes, Your Honor.
For the record, counsel, you may proceed.
I'm showing you now a letter dated January 30 from the former NBI Director Jaime Santiago.
Now, I have to object, Your Honor, please. You know, the defense has been confronting this witness with documents, even without marking and identifying the source of these documents.
Your
It's
Honor,
like
that's
plucking out of thin air a document, presenting them the document to the witness, and withdrawing the document.
Your Honor, that's up
Without
to the
even introducing this piece of evidence, this piece of exhibits into evidence. So my question is, through the presiding officer, is the defense not entering these documents into evidence, Your Honor, please?
They can do so at the proper time, counsel, but insofar as the witness is concerned, I think the basis was laid when he said that he executed only one affidavit of investigation in connection with this case. Now it seems that there are two affidavits,
I would like to make
both of which have not yet been presented. One will be presented, I think, by Attorney Lotok.
Your Honor, for
but
the
the first
record-
one, we're not aware of it. Is that correct, counsel, for the respondent?
Your Honor, he just identified a copy of the affidavit of investigation.
Dated January 30?
April 10,
2025.
April.
February 10. Sorry, Your Honor. February 10.
February 10, Your Honor, please.
What about the first affidavit? The witness said he had a first affidavit.
Yes, Your Honor. Not yet.
Not yet.
Yes.
You only cited a January 30 letter of
Yes,
the
Your Honor.
former NBI
I cited, Your Honor, a
Director.
certification by the DOJ returning an affidavit.
And that is now the problem, Your Honor. In fact, even I am confused because the documents are not introduced into evidence by the defense.
Counsel, please proceed and kindly help the court to be clarified
you.
regarding this matter.
You mentioned that you mentioned that you were aware that the then director, retired Judge B. Santiago, wrote to the office of the Prosecutor General submitting a revised affidavit of investigation on February 11, 2025. I'm showing you now that letter dated February 11, 2025. For the record, this is Exhibit D-4-43 for the defense.
Up for the defense, you mean pre-marked, I suppose. Because when you say marked as evidence for the defense, it's not yet. Your turn has, you have yet to present your exhibit, so it should be pre-marked, Your Honor, please.
No, it's pre-marked, and I believe both the defense and the respondent and the prosecution also have common pieces of evidence which you decided during pre-trial. This is not one of them, which you decided during pre-trial to be marked separately.
It's not one of those few common pieces of evidence.
Yes, there are a few.
Sir?
Please proceed, counsel, for the respondent. Witness may answer.
There is a signature above the name Judge Jaime B. Santiago. Whose signature is that?
Your Honor, now I would like to object to the relevance. A letter is being, the witness is being confronted with a letter coming from the former NBI Director, Judge Jaime B. Santiago, and this witness is now being asked to identify whose signature is that. That's obvious.
I'll allow it conditionally if you can show the relevance insofar as your ability to test the credibility and the accuracy of the witness is concerned. In the meantime, I'll allow it. Kindly show the connection, counsel.
Thank you. Sir, whose signature is this?
As far as I remember, signature of Director Santiago, sir.
Thank you. On the last line of the letter, on the fourth page, sir, please take a look. Last line. It says, and I quote, "To support our recommendations attached herein is the revised affidavit of investigation, including its attachments." Did you see that, Agent?
Yes, sir.
Thank you. And you confirm that the former NBI Director, Jaime Santiago, wrote to the Prosecutor General, Richard Anthony D. Fadulyon, a letter dated January 30, 2025. This is one of the documents that you submitted to the Committee on Justice, correct?
Where's...
Okay, I will show you now. May I have this flashed on the screen? Do you recall this document?
Yes, sir.
Yes. January 30, 2025 is a date earlier than February 10, 2025, correct?
Yes, sir.
Your Honor,
As an
Counsel
answer,
for the
Your Honor.
prosecutor.
Your Honor, the witness being asked which
Your Honor, ask and
came
answer.
first. I mean, relevance, Your Honor. Relevance.
Counsel, if the witness knows and the counsel for respondent will be given the latitude to test the credibility, accuracy, and completeness of the testimony of the witness. But we note your continuing objection, because you already sound frustrated, counsel, in regard to this line of questioning by the
I'm very
counsel for the
patient, Your Honor,
respondent.
please. I'm very patient.
The counsel for respondent may proceed. Witness
Thank
may
you.
answer.
He already answered, Your Honor. Thank you. You earlier confirmed that there was actually a certification dated February 5, 2025. You
Objection, misleading. I don't remember
I have no question,
this
Your Honor.
witness.
Let
stating
the
that there
counsel
was-
finish with this question, counsel.
He even read it, Your Honor. You likewise confirmed that in that said certification, dated February 5, 2025, the earlier affidavit of investigation were subject to 7 recommendations. And you confirmed that you read that.
Objection. Misleading, Your Honor,
objection.
please. Now the counsel mentioned 7 grounds. 7 grounds. And I don't remember this witness uttering the term 7 grounds. What I do remember, Your Honor, please, is that this witness was confronted with a certification, a letter, whatever, but now the counsel is now asking this witness to confirm the contents of those certifications or letters. Misleading.
No,
That's not allowed during cross. The counsel is now assuming facts that have yet to be established. Can I repeat that? This witness was only confronted with certifications, letters, dated this, dated that. And now, the counsel now asking,
Your
do you
Honor, please,
confirm-
he's
do you
now
confirm
testifying.
rights? Wait, let me finish. Now he is asking this witness to confirm that in that letter there are 7 grounds, as if this witness uttered those words. The ground is misleading, definition. This counsel is assuming facts that have yet to be established through this witness, Your Honor, please.
Counsel, again, the witness is not a newbie. I think he can handle himself and would know how to answer if indeed he is familiar or not with what is being presented to him. And thus far, he has responded based on his knowledge of these documents. Chair will allow it. Witness may answer.
Sir?
Can you repeat the question, counsel?
You confirmed that there was a certification dated February 5, 2025. You likewise confirmed that in said certification...
Your Honor, compound question.
There's no question.
Wait.
Kindly wait for the presiding officer to recognize you before answering.
Yes, Your Honor.
Yes.
Much
Please,
obliged, Your Honor,
counsel
please.
for the prosecutors, please finish with your objection.
Thank you so much. Can I?
Yes,
Your
please
Honor,
proceed, counsel.
Compound questions. The witness is now being confronted with 2 successive questions without allowing this witness to answer the first question. What makes a compound question?
No need to lecture, counsel. Counsel for respondent, please reform.
Your Honor, I had no question. I had no question yet.
Kindly proceed with your question.
Thank you, Your Honor. The earlier affidavit of investigation was subject to 7 recommendations from the DOJ
Vague, Your Honor,
for case
please.
build-up.
Objection vague. The earlier investigation, which investigation is the counsel referring to? Objection vague.
We already established, Your Honor, there was an earlier one. This is
Overruled again. The witness is competent enough to testify. Overruled. Witness, kindly proceed with your question, counsel.
Yes. In the revised affidavit of investigation dated February 10, 2025, that you identified, despite DOJ's recommendation number 6 that you earlier read.
Objection, Your Honor. Objection.
Sir, Your Honor, I'm not
If
yet
the
finished.
ground is
Can we
already-
wait for the counsel to finish with this question, counsel, please?
Okay, Your Honor.
Sir, there were still no affidavits of the journalists from the media outlets in your affidavit of investigation dated February 10.
Witness, not answer first. Objection, Your Honor, please. Misleading.
Why is it misleading, counsel?
The counsel said the earlier affidavit of investigation. In fact, Your Honor, please, he referred to the February 10 investigation. That's not the earlier investigation. That is the final affidavit investigation submitted to the DOJ. Misleading, Your Honor.
Your Honor,
The presiding officer will ask the question. Mr. Witness, did you attach the affidavits of the two witnesses that viewed the video of the Vice President in the February 10 affidavit?
Yes, sir. Let me qualify my answer in number 6, sir.
You may do so.
In number 6, sir, the DOJ requested an affidavit to be executed regarding the contents of the minutes. I executed an affidavit attesting to those minutes, sir, which I'm part of the interview, sir.
But was it attached to the February 10 affidavit?
Yes, sir.
Counsel for the respondent, your witness.
thank you. Sir, but there are no affidavits of the journalists from the media outlets, correct? My question is not found there, Your Honor.
Oh, Your Honor, please.
My question is
Your
not
Honor.
found there.
Okay, wait. The counsel is confronting the witness with a document, and he propounded questions, and then he asked another question, and he took the document away. What's
Your
the
Honor,
purpose of that?
I was
Objection,
not-
Your Honor, please.
My question is plain, Your Honor.
Let the
Do you-
witness peruse the document you presented him with. Let him answer that through a document.
My question is plain, Your Honor.
Your Honor, a witness should be allowed to peruse the document
I am
that he
not-
was confronted with.
Counsels, please. Witness, I think the witness understood the question. Mr. Calilong, you may answer if you understand the question.
I will repeat the question. Your
Kindly
Honor.
repeat, Counsel.
Thank you, Your Honor. There is still no affidavits of the journalists from media outlets appended on your revised affidavit of investigation, sir.
May I qualify my answer, sir?
No, sir. Just answer a yes or no.
Kindly look at the document presented to you. On redirect, counsel can make you explain the disparity, if any. The question is simple. Are the affidavits attached to the affidavit of investigation?
May I see the question number 6?
Your Honor, my question does not relate to question number 6.
Kindly show the witness, counsel.
I will.
If it will enable him to give an intelligent answer
Can we
to your
please
question.
flash certification and put it to paragraph number 6?
The paragraph number 6 states that only the minutes of meeting with several personalities and representatives from various media outfits were submitted. Although the minutes were signed, there were no individual affidavit executed regarding to the content of the minutes. On this,
Okay, sir. I have no
So the
question.
answer is the affidavits are not attached.
I have executed an affidavit, sir.
No, the
Sir,
affidavits of the two journalists are not attached. I think that's the only question of
Yes, sir.
counsel for the respondent.
Thank you, Your Honor. Instead, sir, as you confirmed, what you appended to the affidavit of investigation are affidavits of NBI agents, correct?
Yes, sir.
Not the journalists who were present
The one
during the November 23, 2024 press conference.
The one who interviewed, sir.
Yeah, the one in the interview. Not the journalists.
Yes, sir.
Ask and answer, Your Honor.
Move forward.
Sir, in the revised affidavit of investigation dated February 10, 2025 that you identified, despite DOJ's recommendation number 7, can we show again DOJ recommendation number 7? In the certification dated February 5, 2025, it is still the NBI Cybercrime Division that is the complainant.
I believe this is answered on the letter of the director, sir.
Sir, my answer is answerable by yes and no. The complainant is still the NBI Cybercrime Division.
Yes, sir.
Thank you. The supposed offended parties in this case would be President Bongbong Marcos,
Yes, sir.
the First Lady Lisa Marcos,
Yes, sir.
the former Speaker of the House Martin Romualdez.
Yes, sir.
Did President Marcos appear before the NBI during its investigation?
No, sir.
Did the First Lady Lisa Marcos appear before the NBI during its investigation?
No, sir.
Did the former Speaker Martin Romualdez appear before the NBI during its investigation?
No, sir.
Sir, I'm showing you again for the record the affidavit investigation. Sir, did you attach to that affidavit of investigation dated February 10, 2025, an affidavit of the President Marcos?
Only the responses, sir.
Sir, listen to my question.
That's
Did
the
you-
answer.
Your Honor, he did not answer, so I am entitled to
That's
ask
his
again.
answer.
Not responsive. The question was, Mr. Witness, did you attach the affidavit of President Marcos to the February 10 affidavit?
No, sir.
Did you attach an affidavit of the First Lady Lisa Marcos on your affidavit?
No, sir.
Did you attach an affidavit of former Speaker Martin Romualdez on your affidavit of investigation?
No, sir.
To your knowledge, if you know, sir, did President Marcos file any criminal complaint against Vice President Sara Duterte as a result of the November 23, 2024 online press conference?
He made a statement.
No, sir. My question is, if you know, did the President file any criminal complaint against the Vice President?
I have no personal knowledge.
Did the First Lady Lisa Araneta Marcos file any criminal complaint against VP Sara?
I have no personal knowledge.
How about the Speaker Martin Romualdez? Did he file any criminal complaint against VP Sara as a result of the November 23, 2024 online press conference?
I have no personal knowledge.
Did you really investigate this case?
Oh, Your
Withdrawn,
Honor,
Your Honor.
argumentative,
Withdrawn.
Your Honor, please.
Withdrawn.
Did you really investigate
Withdrawn.
this?
How about
Question
the
has been
Speaker
withdrawn.
Martin Romualdez? In other words, sir, the alleged offended parties were not included as complainants in the case you filed with the Department of Justice.
Yes, sir.
Thank you.
Based-
Thank you. And despite the fact that the NBI Cybercrime Division did not comply with recommendations number 6 and number 7 in the certification dated February 5, 2026, it nevertheless filed the revised affidavit of investigation dated February 10, 2025 that you identified today.
Can I qualify my answer, sir?
No, sir. Just answer with a yes or no.
Witness may be allowed to answer according to how he wishes to explain. You may proceed, Mr. Witness, to answer.
Yes, sir. Thank you, Your Honor. For this case po, we complied with the requirements of the DOJ. That's why we secured a second certification wherein our documents is enough for preliminary investigation, sir.
Okay, thank you. And this certification is a certification dated February 5, 2025, correct?
Kindly show the witness the
This
document.
is not the new certification, sir.
Oh, sorry, sir. So, apologies, Your Honor. February 11.
Yes, sir.
This was also executed by Senior Assistant State Prosecutor J.V. Lawrence B. Bandong, correct?
Yes, sir.
Now let's discuss the nature of the investigation you conducted. You claimed in your affidavit, sir, affidavit of investigation, that the NBI began its investigation into the VP's remarks because it was directed by the DOJ to do so.
Motu proprio and directed, sir.
Okay. Do you understand what you just said, sir?
Oh,
yes, sir.
Oh. Can I
I'm
object
asking,
to that,
sir.
Your Honor, please?
I'm asking, sir. It makes sense, Your Honor.
Argumentative, counsel. Move on.
Mutu proprio, sir, means...
Oh, no, objection. You cannot lecture, counsel. This is
Sir, what does
cross-examination.
you mentioned mutu proprio. What does it mean?
Even without a complainant, we started the investigation, sir.
Are you sure, sir?
Oh, argumentative. Are you sure,
get-
sir?
Move on, Counsel.
Are you sure,
move on.
sir?
How? How about direct investigation? What does that mean?
Your Honor. Okay, never mind.
Directed investigation. What does that mean?
There is instruction from above, sir.
From?
Above. From
Above.
upper.
What does above mean?
It may be the DOJ or the higher.
Higher. What's higher than the DOJ?
Based on that, it's only the DOJ, sir.
Based on. You said above the DOJ, sir.
No, sir. Above the
Sir,
NBI,
you said above. May I ask for a reading?
Argumentative, Your Honor,
Counsel,
argumentative.
Counsel, again, I would have to sustain the objection. It is argumentative. I heard
All
the
right, Your
answer, and he meant as a general term above, but referring apparently to only the DOJ in this particular instance.
We submit, Your Honor.
Please proceed.
You confirmed that the NBI Cybercrime Division is the complainant in the case against the Vice President, and that the DOJ filed this with the NBI filed this with the DOJ.
Objection, compound,
No,
Your Honor. That's a
no
compound
question, Your Honor. That was just a statement.
Counsel, kindly wait.
Exactly. Your Honor,
He's laying the basis for a question. Go to your question, Counsel.
Sir, the NBI, of course, you're from the NBI, is under the Department of Justice.
Yes, sir.
Your Honor, we can take judicial notice of that.
Your Honor, if I'm on cross, Your Honor.
I know, but
I'm on cross.
there are things that
No.
need not be discussed.
Your Honor, please.
Counsel-
Can I, Your Honor?
Your Honor, please.
Counsel, let's give him some latitude.
Much obliged, Your Honor, much
Although we
obliged.
can take judicial notice of that, it's part of his cross-examination.
Yes, thank you, Your Honor. The Secretary of Justice is meanwhile the head of the DOJ, correct?
Yes, sir.
It's the Secretary of Justice exercises control and supervision over the NBI.
Yes, but even
No more questions.
The witness is
Yes or no,
answering.
Mr. Witness? If you know.
Can you repeat, sir?
Mr. Witness?
The Secretary of Justice exercises control and supervision over the NBI. Yes or no?
We are under, sir. But we're independent.
So you do not know.
Oh, Your Honor, that's
Sorry.
argumentative. So
Sir,
you
are
do
you-
not know?
All right, Your Honor. Are you aware of Book 4, Chapter 8, Supervision and Control of the Admin Code?
Your
Section
Honor.
39. Your Honor, I have no
Your Honor.
question yet.
Yeah.
Please.
Yeah.
Section
Counsel for the
39.
prosecutor, let the counsel for respondent finish his question.
Yes, Your Honor.
Section 39 thereof, Secretary's authority. The Secretary shall have the supervision and control over the bureaus, offices, and agencies under him. Supervision and control. Sir, my question is this. Is the NBI, the National Bureau of Investigation, under a bureau under the Department of Justice?
Yes, sir.
Thank you. And, sir, the President has control over all executive departments, correct?
I believe so, sir.
The DOJ is one of those executive departments, correct?
Yes, sir.
And the current President is Ferdinand Marcos Jr., correct?
We agree to that. That's judicial notice.
Your Honor, please. Yes
There's
or
no
no?
other
Yes, sir.
president. We
Oh,
only
he
have
answered
one
already, Your
president.
Honor.
Already asked and answered.
The head of the executive branch is President Ferdinand Marcos Jr., correct?
Yes, sir.
The very same Ferdinand Marcos Jr., who you said was an offended party in the case against Vice President Duterte.
Yes, sir.
So, in other words, the NBI investigated and filed the complaint. The DOJ directed the investigation and will determine whether the case should proceed to court. And the alleged offended party, President Marcos, is the constitutional head of the executive branch,
Objection.
exercising control over both the DOJ and the NBI. I withdraw, Your Honor. I withdraw. I withdraw, Your Honor. I withdraw.
Oh, Your Honor. It's even more compound question.
Nothing to
asking
object to.
several
Withdraw,
subject
Your Honor.
matters.
Withdraw.
Counsel, move on.
Sir, you testified earlier that you investigated the Vice President in relation to the press briefing that she conducted on November 23, 2024.
Yes, sir.
This investigation by the NBI Cybercrime Division was started after the conduct of the November 23, 2024 press briefing of the Vice President, correct?
Yes, sir.
So basically, to put it simply, the investigation was done after the supposed incident on November 23, 2024.
The same day, sir.
The same day, but after.
Oy, Your Honor, the same day then after.
Same, not responsive, Your
Counsel,
Honor.
clarify your question.
Same day,
The
same
investigation was done after, later than, the supposed incident on November 23, 2024.
Yes, sir.
Thank you.
You mean to say later that day?
Yes, Your Honor.
Because how can you investigate something that hasn't happened yet?
Correct.
Yes, Your Honor.
Please proceed.
Sir, you're not one of the participants of the press conference on November 23, 2025, correct?
Yes, sir.
So you do not have personal knowledge about what transpired during that press briefing, correct?
It was live streamed, sir.
You did not watch that live stream, correct? In real time.
Yes, sir.
You only acquired knowledge about it when you started investigating later that day.
Yes, sir.
You also do not have personal knowledge of the alleged threats made by the Vice President during that press conference. Press briefing, sorry.
After the press briefing.
After. You only acquired knowledge about it when you started investigating.
Yes, sir.
You also do not have personal knowledge of the alleged assassin that was allegedly hired by the Vice President.
It came to my knowledge upon...
Personal knowledge, sir.
No, sir.
Now, during your testimony yesterday, you mentioned that during your investigation on the November 23, 2024 press briefing conducted by the Vice President, you preserved a copy of said press briefing through open source investigation, correct?
Preserve a copy through open broadcast software studio.
Okay, thank you for the correction. One of the videos that you were able to preserve in relation to your investigation is the screen recording of the November 23, 2024 press briefing conducted by the Vice President, right?
Yes, sir.
Your Honor, may I move that the very same USB be unsealed and shown by the prosecutor's exhibit P-4-10 be unsealed and shown the witness.
Counsel for the prosecutor, so instructed.
Thank you, Your Honor. Okay ka na po? Wait lang.
November 20.
This is exhibit P-4-10, I believe. Your Honor, may I request that he unseal the USB and that it be allowed to be played?
Which part, Counsel?
Your Honor, we will play various parts of the, not the whole, for the, as the...
That's what I was worried about.
Yes, Your Honor. We understood by the faces of the honorable members of the court. So
you will...
we will just...
play parts.
Yes, Your Honor.
Of it. And you identified, I presume, the time stamp.
Yes, we have, Your Honor. I will get to that.
Witness may open the seal.
Thank you, Your Honor.
And counsel for the prosecutors is instructed to accompany counsel, one of the counsels for the respondent, in the tech booth to make sure that it's the same USB being presented.
For the record, Your Honor, the witness is opening the prosecution's exhibit P-4-10, Your Honor. This is the video dated November 23, 2024.
I have unsealed the flash drive, sir.
Counsel this with understanding, okay, very much like yesterday, that this USB will again be sealed and signed by both parties.
Yes, Your Honor. Your Honor, may request that this be played. Here, brother.
Counsel for the prosecutors, kindly accompany a representative from the counsel of the respondent to the tech booth to make sure the same USB to be played. Kindly just guide us through, Counsel Attorney Narvaez, as regards the timestamps.
Thank you, Your Honor. I will.
Please don't forget your promise that it's not going to be the whole 2 hours.
Yes, Your Honor.
Waiting.
Senator Judge Pia Cayetano, what is your pleasure, ma'am?
Yes. If it's possible, Mr. President, if our secretariat can install a monitor here because magkaka-stiff-neck na po ako watching this. And it really doesn't look nice that I'm slouched there looking this way. So, and then this one here is a little bit, not for videos, but for the copies of affidavit, it's quite difficult. So if they can put one here, the others want another, but I can speak for those in the front row we would like to request. Thank you.
The clerk of court, rather, is instructed to kindly install a TV monitor in front of the tables of the counsel for the parties instead of at the witness stand. Both sides. Underneath the table of the counsel for the parties, Senator Judge Pia. Counsel, for the record and for reference, kindly identify the timestamp that you will be playing. I presume in chronological order.
Your Honor, for the record, we are showing the witness a part of the video marked as the prosecution's exhibit P-4-10. First video, the timestamp around 0001:27 to 0002:20 of the November 23, 2023 press briefing as contained in the video that you identified yesterday, sir. Your Honor, may we ask that the video be played at those specific timestamps?
I did an apology. And then, ang sabi po nila, I just have to do an MR. And I did an MR, but they did not rule on it. And then suddenly they have an order transferring me. When ang nauna naman na order ng final ng lawyers namin was an MR to lift that order of contempt. Because they said that was the procedure. If they were not able to rule on that, how were they able to come up with an order, to transfer me to the women's correctional in the dead of the night? I mean, bakit ganun? Wala na bang rights yung mga tao? They just go to your room and then just get... I don't understand.
Your Honor, may I ask that the video be stopped? Sir, do you know who that is in the screen in the video that you identified?
Attorney Zulaika, as far as I remember, sir.
And Attorney Zulaika, as far as you remember, Attorney Zulaika is who in relation to the Vice President? You may answer not a yes or no question.
As far as I remember, she is the COS.
COS meaning Chief of Staff,
Chief of
right?
Staff.
And she is there in that video because she was cited in contempt by the House of Representatives, correct? If you are aware, you're the investigator.
Prior to the...
Sir, my question again.
The witness
Let
is
the
about
witness
to answer.
Witness was in the process of answering.
Prior to the scene, I have no personal knowledge, but based on her statement during the video, I think it was mentioned.
So you didn't investigate the things that happened prior to the scene, correct? Sir, yes or no?
We have investigated, sir.
You didn't investigate.
Oh,
I did, sir. That's why there's an October 18, sir.
So what happened before that? If you investigated, what happened?
I don't have personal knowledge, sir. Because I'm not present during that time, sir.
Witness is not responsive. The question was, what happened prior to this video, this particular clip of the video, if you know, given that you investigated the incident, as you said?
As far as I remember, there is a hearing in the House of Representatives.
What committee, sir?
I can't remember the committee, sir.
What happened, sir?
COS was cited in contempt, sir.
By who, sir?
I can't remember the exact, sir.
But you investigated. I withdraw, Your Honor. Can we play, let me show you timestamps around 002832 to 002933. This is the same prosecution's exhibit P-4-10. That is the video you identified yesterday. Your Honor, may we request that that video be played?
Hindi ako lalabas. Hindi ako lalabas.
Pwede magtanong. And just very quick, Jason, if I may. Sorry. Go ahead. So after you pushed back attorney, they left the room, no? Tama ba? Did they appreciate that that detail accurately?
Because I think alam din naman nila na mali yung ginagawa nila. You don't put people in the dead of the night. What is that? It served, di ba? Official business hours. Because hindi naman po ako criminal eh. I am not a criminal. I am already here in their facility. I have assured them already that I will attend their hearing on Monday. So why will they treat me like that? So that's why I said I want my lawyer. I want my lawyer.
Stop, please. Sir, did you consider this in making your evaluation in the revised affidavit of investigation dated February 10, 2025?
Yes, sir.
Thank you. Now let me show you timestamps around 003305 to 003432 of the November 23, 2023 press briefing as contained in the video that you identified yesterday, the prosecution's exhibit P-4-10. Your Honor, may we request that
You're online, ma'am. Go ahead, ma'am. Go ahead.
I would not have pushed that there by myself if I did not feel that I was being threatened. My life is being threatened. And I'm sure you saw in the hearing that my back hurts. I cannot lift everything. I cannot. But dahil natakot ako, I feared for my life. I really pushed that by myself. Because hindi lang to harassment. This is really a threat to my life. They gang up on you in the middle of the night. Huh? How is that done? Isn't that a threat to my life? Alam nila na I'm sick. I have said that repeatedly when the doctor came here.
Stop. Thank you. Sir, did you investigate the threats to Attorney Zulaika's life?
We need a complaint for this one. That's why
Yes or no, sir? Did you investigate?
we did not, because there's no
You did not.
complaint.
Okay, thank you.
The motto pro.
No question, sir.
If the witness may be allowed to answer, Your Honor?
I had no question.
Already answered.
Did you consider this part in making your evaluation in the revised affidavit?
Asked and answered. He said
This is
yes
a different
earlier.
part, Your Honor. This is a
There's
different part. Did you
Witness may
consider
answer.
this part in your evaluation, the revised affidavit of investigation dated February 10, 2025?
Yes, sir.
Okay, so despite considering these parts of the aforesaid videos, the NBI still recommended the filing of complaints for grave threats and inciting to sedition only against the Vice President. Yes?
May I qualify my answer, sir?
No, sir. Yes or no?
there's a reason why I...
Sir, your counsel may ask you questions. This is my turn.
Proper
Sir?
subject matter for redirect.
So despite
Counsel,
considering these parts of the videos shown to you, the NBI still recommended the filing of complaints for grave threats and inciting to sedition against only the Vice President.
Yes, sir.
Now, in the revised affidavit of investigation dated February 10, 2025, in page 15, paragraph 40 thereof, it is stated there, and I quote, "We unanimously believe that Vice President Duterte may be held liable for grave threats defined and penalized under Article 282 of the Revised Penal Code, and inciting to sedition defined and penalized under Article 142 of the Revised Penal Code in relation to RA 10175, or the Cybercrime Prevention Act of 2012. You see that, sir, right?
Yes, sir.
This conclusion was reached by you together with other affiants of the revised affidavit of investigation dated February 10, 2025, correct?
Yes, sir.
Now, sir, you mentioned that you're not a lawyer, right?
Asked and answered.
Asked and answered.
To date,
Move on,
we are
counsel.
aware, are you aware if any court has convicted the Vice President for grave threats over what transpired on November 23, 2024?
As far as I know, not yet, sir.
Not yet.
As far as you know, Mr. Witness, as far as you know, no.
No, sir.
Proceed, counsel.
To date, thank you, Your Honor. To date, are you aware if any court has convicted the Vice President for inciting to sedition over what transpired on November 23, 2024?
No, on my personal knowledge, sir.
Thank you. But you're the complainant, right?
Argumentative, Your Honor.
I was just
Sustained.
asking.
Sustained. Move
Asked
on,
and
counsel.
answered. Argumentative. Then you withdraw your question. Improper.
Attached to the revised affidavit of investigation, which you identified and submitted to the DOJ and the Committee on Justice, is your affidavit of transcription of the press conference on November 23, 2024. I am showing you this now. For the record, sir, Your Honor, I will show the... Can you check? Sir, please take a look. Can you please say it for the record? This is your affidavit of transcription.
Yes, sir. This is a photocopy of my affidavit of transcription, sir.
This refers to the press conference on November 23, 2024.
Yes, sir.
You signed this on December 20, 2024.
Yes, sir.
Sir, please take a look at your paragraph 2. Let's read it together. In relation to the ongoing investigation, the undersigned was tasked to transcribe the screen-recorded video of the press conference of Vice President Sara Duterte on 23 November 2024, which was saved on a DVD. You read that, sir?
Yes, sir.
On paragraph 3 thereof, let's read it together. The undersigned transcribed the video mentioned above which resulted in a CCD transcript hereto attached.
Yes, sir.
You read that, sir? And 4, I hereby certify that the above-mentioned digital evidence has been faithfully transcribed and that has not been edited, altered, or changed in any way. Did you read that, sir?
Yes, sir.
And I am, on number 5, paragraph 5, I am executing this affidavit to attest to the truth of the foregoing facts and circumstances and for whatever legal intent and purpose it may serve.
Yes,
Did you read that, sir?
Yes, sir.
These statements of yours, this affidavit of yours, these were all done under oath, correct?
Yes, sir.
And you were offered as an expert in digital forensic examination with a whopping 2 weeks of training. Do you confirm that that transcription of the screen-recorded video the press conference of VP Sara Duterte on the 23 November 2024 has been faithfully transcribed?
I don't remember that I was introduced as expert by a competent witness.
Okay, sir, but my question is, the press conference of VP Sara Duterte, that the transcription of the screen-recorded video of the press conference of VP Sara Duterte on 23 November 2024 was faithfully transcribed by you?
Yes, sir.
Sir, attached to this affidavit is the transcript, correct? Can you please take a look?
Yes, sir.
And Your Honor, may I ask again that the video, parts of the video be played of the press conference on November 23, 2024. Let's go through it together, sir. Where's the timestamps? First, let's go to around timestamp 00446. Your Honor, may I request that the video be played? Sir, please.
Steps after this order, are you going to file? Are you going to trigger na po ba, ma'am, the filing?
I am not leaving this room. I am a here in the House of Representatives detention facility for 5 days until the hearing on Monday. Nobody can come in here and demand to transfer me in the middle of the night. I have my right.
Okay, ma'am.
Any crime. I am not leaving this room.
Stop.
Okay, yun lang po, ma'am.
You heard that, sir? Do you want to repeat it?
I heard it.
You heard it. Sir, in the first, you see also where that part is? Can you see it?
Start with the question with Red Mendoza, sir.
Okay, after the Zuleika Lopez. Did you hear that?
Yes, sir.
Okay.
Mr. Witness, kindly speak to the mic.
Yes, sir. Yes, Your Honor.
You heard, she said, I am not leaving this room. I am a detainee here in the House of Representatives detention facility for 5 days until the hearing on Monday. That is the first sentence, sir. My question is this. Does your transcript have the words a detainee?
Can you repeat the video, sir?
Okay, let's do it. Please play for the video again, please.
Instructed to kindly play the video timestamped identified by counsel for respondent.
You're going to trigger na po ba, ma'am, the filing?
I am not leaving this room. I am a here in the House of Representatives detention facility for 5 days.
That part that the detainee is inaudible. The only I heard. That's
You
why.
heard the, correct?
Yes.
Are the words or the sounds there?
Here.
Huh? Here.
Yes.
Here. Okay. Please play. How about the last part of the paragraph? She said, I have my rights. I am not accused of any crime. I am not leaving this room. Does your paragraph in your transcript have the word accused after not?
Can you play the video, sir?
Please play the video again.
Speak to the microphone.
Tech is instructed to play the video. Witness is instructed to speak to the mic.
Demand to transfer me in the middle of the night. I have my rights. I am not accused of any crime. I am not leaving this room.
More. Play, please.
Okay po, ma'am. Yun lang po, ma'am. Thank you po, ma'am.
Wait. Back.
Any other question?
0446, please.
I'm sorry, ma'am, kasi I understand, ma'am. Ma'am, this is my last question, and I'm very much sorry. I'm so triggered na po ba, ma'am, the filing?
I am not leaving this room. I am a here here in the House of Representatives detention facility for 5 days until the hearing on Monday. Nobody can just come in here and demand to transfer me in the middle of the night. I have my rights. I am not accused of any crime. I am not leaving this room.
Stop.
Okay po ba, ma'am?
Is the word accused in your transcript?
What I heard is root, sir,
The root.
of any crime.
The root of any crime.
Yes, sir.
Let's play 001238. Can you please go to 001238?
Correctional?
Sinabi nila sa iyo. Yung contempt. Diba? Sinabi nila sa iyo, isip namin yung contempt. I-produce mo yung apat.
Sabi nila sa akin, if you notice if you're in the hearing, sinuspend po ng Chairman Chua yung...
Wait.
Yung...
Stop, please.
Your Honor, please. Now, I'm now registering my objection as to the relevance, Your Honor, please. If I may explain, Your Honor, of this line of questioning, Your Honor, please, if I may.
Counsel may explain his objection.
Your Honor, please. This witness already identified the video containing the contents of that press conference on November 23, 2024. And the counsel is now confronting this witness whether there are minuscule portions of the 2-hour video, like detainee, accused, whether this appear in the transcription. Now the basis for the objection is irrelevant. How can it be relevant? How can it be relevant, assuming but not conceding that these two minuscule words, detainee and accused, are not reflected in the transcript, when in fact this witness said he investigated not only on the basis of the transcript, but on the basis of the video that he himself viewed? What's the relevance?
Overruled, part of cross to test the accuracy and the truthfulness of the witness insofar as his transcription of the video is concerned.
Thank you.
Counsel may proceed.
Thank you. Please play again 001238.
Sinabi nila sa iyo. Yung contempt. Diba? Sinabi nila sa iyo, isip namin yung contempt. I-produce mo yung apat.
Sabi nila sa akin, if you notice if you're in the hearing, di ba? Sinuspend po ng Chairman Chua yung session. Tapos, nung sinayin po ako ni Congressman Castro in contempt, then after that, nag-rule sila. Tapos, then sinuspend niya. Tapos, lumapit po sila. Nag-huddle sila. And then, they called my lawyer. And then, told him na kausapin ko. So, lumapit ako. And I really apologize. I said, you know, that letter to the Commission on Audit was really a position of the agency. It is our stand. Like all, di ba? Like, meron kang points na gusto mo i-raise. We respectfully parang raised our points to the Commission on Audit. Alam ko, hindi naman po yung mali kasi that was our right as an agency. Because there was an ongoing audit investigation. Pero hindi naman namin kinukuha.
Narinig mo ba? Narinig mo? Did you hear the Vice President speaking?
I don't hear.
Can you please play again?
Mr. Kalilong, you're reminded, please answer
I don't hear,
through
sir.
the microphone.
Can you please play it again?
MR ka, we will let you go. So we filed our MR. They did not rule on it. But suddenly, they were able to come out with an order ruling to transfer me to the Women's Correctional.
Sinabi nila sa iyo. Diba? Sinabi nila.
There. Did you hear that?
There are sounds, but I can't distinguish the words.
Can you play it again?
Your Honor, asked and answered. What's the point?
Okay, withdrawn, Your Honor. No further questions.
No further question
are
for
we
this
done?
witness. On cross, Counsel, do you have redirect?
Of course, Your Honor, please, for the utter failure
I
of
was
the...
hoping you won't. But Yes,
for the
please
utter
continue.
failure of the respondent to
Counsel,
debunk.
before I recognize counsel for the prosecutor,
Your Honor, we
Senator
need
Judge
to strike-
Tulfo Rafi is recognized.
Your Honor, sorry, may I move to strike that statement of the prosecutor?
How can it be, Your Honor? That's my manifestation. I'm about to answer the question of the presiding officer.
We will review the journal tomorrow. I did not even hear anything
Yes.
that is strikeable, counsel, but we will review the journal tomorrow.
Your Honor, he said for the utter failure of the respondent.
Yes, Your Honor,
We take
I said
exception
for
to
the
that.
utter failure of the respondent to debunk the material points testified to by the witness yesterday.
Your Honor,
I'm
he
not
is
yet
testifying.
done.
I'm not done either. He is
I'm about
still
to answer the
testifying.
question. I'm not yet done with the answer.
Counsels, please. The presiding officer has not recognized either of you.
Thank you.
Thank you.
Kindly settle down. Senator Judge Rafi Tulfo is recognized.
Thank you, Mr.
Sir,
Presiding
you may
Officer.
proceed.
Clarification naman po ito, Mr. Presiding Officer. Mr. Witness, what is your experience with regards to social media analytics?
I have training, sir.
What kind of training?
I have cybercrime investigation training, sir.
Okay. Are you familiar with Facebook, or do you have SOCMED accounts that would make you a little bit knowledgeable when it comes to SOCMED?
Yes, sir.
What is your account? What is your social media account? If
I have
any?
an account in Facebook, in Instagram,
Okay.
in X.
X. So that means pretty much you're a little bit familiar with Facebook, right?
Yes, Your Honor.
Okay. There were concerns, Mr. Witness, whether the videos presented yesterday are AI generated or authentic. So are you experienced enough analyzing whether a video is AI generated or authentic?
Yes, Your Honor.
What makes you say that?
Based on my experience, Your Honor, and the video itself, it's a 2 hours long. Normally, an AI-generated video will only last a short second, sir.
So the video that was presented yesterday, where we saw the VP was thing, or what kind of system did you observe or follow to ensure whether that video was AI generated or authentic?
Based on personal observation, sir.
Personal observation.
Yes, Your Honor.
Okay, a few more questions. Therefore, will you be able to say that the video presented yesterday were AI generated or authentic?
The video presented today is what it is being seen on the Facebook, sir.
Okay. So based on your affidavit, you mentioned that the NBI subpoenaed some members of the media who are participants of the online press con on November 23, 2024, right?
Yes, Your Honor.
And subsequently, you said that you questioned and investigated these persons regarding the conduct of that press con. So based on what you gathered from your investigation, so I have a few questions, right?
Yes, Your Honor.
Who set up the press conference?
Based on our interview, sir, it is the Office of the Vice President, sir.
So it wasn't spur of the moment? Press con?
I can't confirm, sir, but it's the response of the media personnel that we interviewed.
Okay, who invited the participants?
If my memory serves me right, it's JC Kahinhinan, sir.
Okay. Who is JC?
Staff of the Office of the Vice President, sir.
Okay. Who are the participants? And how many participants were there, if you can remember?
As far as I remember, it's at least 40.
40. Okay. Were there mainstream media or anybody from the broadsheets at that time?
There are, sir.
There were?
Yes, sir.
Do you know how many? Approximately, give or take?
We have the one that we have issued subpoena, sir. At least 6, sir.
6. Okay. What was the reach of the video on that very day? Like how many views on that very day, and then a few days later? Were you able to observe that?
I can't remember, sir.
You can't remember. Okay. How did it spread? O paano kumalat sa SOCMED yung videos that was presented yesterday, as far as you know, when you did an investigation?
It became trending, sir.
it became trending. And my last question is, kasi in-establish dito is inciting to sedition on top of yung sa sinasabing grave threat. Ano yung mga comments na napansin mo doon sa video? Can you give us an example?
One of the comments, because on the video November 23, there were mentioned about people power when asked a question by Princess Maui. And the Vice President agreed, and ang laban ay wala sa EDSA, nasa Malacanang, and there are responses from the comments, but it's not documented. That is agreeing, sir.
No further question, Mr. Presiding Officer.
Thank you, Senator Judge Tulfo. Senator Judge Aquino, thereafter Senator Judge Pangilinan. Senator Judge Aquino has 2 minutes. You may proceed, sir.
Maraming salamat, Mr. Presiding Officer. Mr. Kalilong, kanina may nabanggit na 2 affidavit, isang January at isang February. Yung January ay binalik sa inyo, tama po ba?
Yes, Your Honor.
And there were 7 grounds why it was returned to you, is that correct?
7 points.
Can you narrate what are the 7 points that you addressed? Is that the correct term, that you addressed in the second affidavit?
Yes, Your Honor.
Can you name them, please?
May I have the certificate, sir?
The certification, was it counsel for the respondent?
Your Honor, may I approach?
Yes, you may approach and show him the document being alluded to by Senator Judge Aquino.
Note 1. There is no affidavit of the person who recorded the video entitled BP November 23 Press Con at Batasan through Open Broadcast Super Studio and in turn stored in the DVD. Number 2. The press briefing conducted on October 18, 2024 was not recorded and or stored in DVD, and there was no TSN of the said briefing and the necessary affidavit of the person taking the TSN. Number 3, Annex I and K DVD with markings NBI CCN-C-24-12436-2 and NBI-CCN-C-24-12436-2 were not accompanied by an affidavit of the recorder and the TSN. Number 4, Annex L did not indicate who made the TSN. There was also no affidavit of the person who made the TSN. Number 5, the affidavit of Juan Patricia Morales mentioned that she stored the footage in a USB and submitted to the NBI. However, there was no USB attached to the complaint. Only DVD was attached. There was no detail regarding the content of this DVD. Number 6, only the minutes of meeting with several personalities and representatives from various media outfits were submitted. Although the minutes were signed, there was no individual affidavit executed regarding to the contents of the said minutes. Number 7, one of the elements of crime of grave threat is that the offender threatens another with the infliction upon the latter's person, honor, and property, or upon that of the latter's family, or if the wrong amounting into a crime. In the instant complaint, only the NBI executed an affidavit and there was no participation on the part of the offended party, as it appears in the NBI is not the offended party of the crime of grave threat.
Okay, so nakuha mo yung nag-submit kayo, yan yung binalik sa inyo, and then you did your best to correct all those items, is that correct?
Yes, Your Honor.
Okay, the first 6 are technical, no?
Yes, Your
Yung
Honor.
panghuli is a matter of who is the offended party.
Yes, Your Honor.
Hindi nyo na-correct yan? Or nung binalik ninyo, it was accepted already by the DOJ, is that correct?
There is an explanation, Your Honor, that was included in the letter of the former director, Judge Jaime Santiago, sir.
Okay.
Wherein
Go ahead.
in the filing for preliminary investigation, it is not required for the victim to execute an complaint affidavit.
Yan yung
sir.
sagot ng NBI.
Yes, Your Honor.
And once you submitted, it was accepted by the DOJ.
Yes, Your Honor, and we received a certification, Your Honor, that our evidence is enough for preliminary investigation, sir.
Okay, yun na yung second response to the second affidavit that you provided.
Yes, Your Honor.
Okay. May mga nabanggit dun sa mga statements tungkol sa hitman, no? Sa totoo lang, yung presensya ng hitman, mabigat yon. So, let me ask, are you the one who investigated just the video, or did you also investigate the presence of the hitman that was being mentioned in the videos of the Vice President?
I was only tasked for the video, sir.
Okay, may I direct this to the prosecution? Will you be presenting other witnesses that will pertain to this alleged hitman?
As to the alleged hitman, Your Honor, please. Yes.
Yes. So kayo, Mr. Kalilong, hindi kayo nag-imbestiga niyan. Wala kayong alam tungkol dun sa presensya ng hitman.
Yes, Your Honor.
Okay. Mr. President, I will refrain from my questions and wait for the witness pertaining to the hitman. Maraming salamat.
Noted and entered into records, Senator Judge Pangilinan, thereafter Senator Judge Ontiveros, and then Senator Judge Villanueva.
Thank you. Thank you.
You have 2 minutes.
Thank you, Mr. Presiding Officer. The question is to the witness. Kanina tinanong sa iyo ng Defense Counsel or Counsel for the Respondents na kung ikaw ay abogado. Ang sagot mo hindi.
Yes, sir.
Ikaw ba degree holder?
Yes, Your Honor.
Ano ang degree?
Bachelor of Science in Accountancy, Bachelor of Science in Accounting Technology, and I'm a certified public accountant, sir.
So you're a certified public accountant.
Yes, sir.
Kahapon, tinanong ko sa iyo yung training, no? Kasi nabanggit mo nagkaroon ka ng mga training. Ang nabanggit mo kahapon, 2 weeks ng training.
Yes,
pero on what matter?
Only on photo and video authentication, sir.
Okay. Meron pa bang ibang training na ikaw ay you went through bilang expert or competent witness sa usapin ng digital technology, cybersecurity, online training? Meron ba?
Yes, Your Honor.
Anong mga ito?
I mentioned that I have a training in Certified Computer Hacking Forensic Investigator. I have a training in Computer Forensic, Mobile Forensic, and Photo and Video Authentication training. I have also training in Cybercrime Investigation. We also undergone a 480 hours training on cybersecurity. And a training before we start the bureau, we have undergone the NBI Academy, which teach us all the aspects in investigation, sir.
Okay, and siguro last question. Ang training na ito, puro local ba o meron ding training sa ibang bansa?
I have an international, sir, recently.
Ano yan?
It's a training in Strasbourg.
Okay.
The name of the training is...
Saang lugar na lang, Mr. Witness?
Strasbourg, Germany? France?
Strasbourg, France, sir.
Oh.
It's a 5 days training, sir.
And meron pang ibang international seminars na inattendan mo?
International, sir, but it is conducted locally, the Interpol, sir.
Interpol?
Yes, Your Honor.
Okay. I have no further questions.
Thank you, Senator Judge
Salamat.
Pangilinan. Senator Judge Ontiveros is recognized. You may proceed, ma'am, and you have 2 minutes.
Salamat po, Mr. Presiding Officer. Para sa Counsel for the Defense, Mr. Presiding Officer, just for clarity, ano pong relevance nung video na ipinakita ni Attorney Zuleika Lopez? Sinasabi po ba ng depensa na yung mga alleged threats o alleged incitements ni VP Duterte ay prompted nung detention ni Attorney Lopez?
Yes, Your Honor. There was a systematic oppression made by the House of Representatives dating back from their even before their mini trial, Your Honor. the committee headed by Representative Joel Chua began investigating the vice president and her people, even when Attorney Zuleika Lopez was being interviewed by the House Committee of Quadcom Committee, Your Honor. Even if she was answering the questions faithfully and to the best of her ability, she was cited in contempt, detained. Her lawyer was not allowed. Her lawyer was not allowed to be with her when they were trying to detain her in the women's correctional facility, Your Honor.
So, Mr. Presiding Officer, Counsel for the Defense, position po ba ng depensa na pwedeng palampasin ang alleged grave threats kung may masasabing lehitimong dahilan para magbanta?
Your Honor, that is not the point.
No. Mr. Presiding Officer, I am making a point through my question and I am asking the good counsel for the defense dahil sinabi nila there was a systematic oppression that yes, yan po ang nag-prompt nung alleged grave threats and alleged incitements ng Vice President na prompt po ng detention ni Attorney Lopez na kanyang inilarawan sa ipinakitang video kanina. Kaya itinatanong ko kung yan ba ang posisyon ng depensa na pwedeng okay lang or pwedeng tanggapin ang grave threats kung may masasabing lehitimong dahilan para magbanta.
Yes, Your Honor.
Before Counsel
Yes, Mr. Presiding
responded answers, although he already answered in the affirmative.
Your Honor, I was just referring to before.
We'd like to remind the senator judges to be cautious in making counsels for either party make conclusions of law and fact instead of presenting evidence through a witness they will present or through direct, cross, redirect, or recross. Because if he answers Senator Judge Ontiveros, that would effectively place on record a conclusion of fact and law, not drawn from a witness, which they can very well do so during their closing remarks. And when I allow him to speak by way of repartee to the peroration yesterday and discussion yesterday by counsel for the prosecution. But other than that, as agreed with some of the senator judges, we would try to limit the answers of the counsels for the parties. With your indulgence, Senator Judge Ontiveros, please.
I submit, Mr. Presiding Officer, may I just in closing make of record that I also appreciated and also submitted to the ruling of the presiding officer yesterday because I appreciated that it partook of the history of impeachment proceedings in this court. Pinag-aralan ko rin po ng maigi ang mga nakaraang mga impeachment trials at di hamak na pati noon naging liberal ang pagpapahintulot nila sa mga katanungan ng mga senator judges para lang mas maliwanagan ang iba't ibang punto. So I again thank the good presiding officer and again reiterate my submission to his ruling and thank the good counsel for the defense for his response.
We thank Senator Ontiveros for indulgence and understanding. Senator Villanueva. And thereafter, Senate President Gatchalian. You may proceed, sir. You have 2 minutes.
Thank you, Mr. President, Mr. Presiding Officer. May I just point out something to the witness? Mr. President, Your Honors, the witness mentioned yesterday that reported statements of the Vice President were referred to the Presidential Security Command and evaluated in coordination with the National Security Council. Just to assist the court in evaluating the relevance and weight of the government security response in determining whether the respondent's conduct constitutes an impeachable offense. May we know from the witness could the witness explain yung threats po ba, how threats against the president are ordinarily assessed by the government. Kasi dito yung lumalabas yung pag-weigh natin whether or not meron bang bigat yung threat o ito'y ordinaryong threat na nangyayari sa pang-araw-araw nating buhay. Specifically, Mr. Witness, what factors are taken into account in evaluating a reported threat and in determining appropriate measures?
I can't answer on the part of the NSC or TNO because I'm not part of the institution.
In your in your capacity as an
In my
agent?
capacity,
Yes.
one of the consideration if it's a active threat, if it's the one giving the threat is capable of doing so.
Meaning,
if someone
high-ranking officials, and if you say an
high-ranking can have
official,
a capability or power over to implement those such threat, it is considered, sir.
example, a mayor, perhaps? Would you say a high-ranking official? A congressman? Or yung basihan po ng kanyang threat. Kunyari, ang threat ko, dadalhin kita doon sa buwan. Wala naman akong space shuttle. So, wala din pong bearing yon. Is that the correct assumption?
Not only, sir, but also how it was delivered, sir. Like what was mentioned in the that I mentioned previously, it was mentioned that no joke, no joke. It's a serious.
So that is the
one of the considerations,
that's
sir.
the consideration. Thank you very much. And lastly, Mr. Witness, you made mention na submit mo sa DOJ noong January 30. Is it the same affidavit that you submitted to the HOR?
The one that submitted to the HOR is the affidavit dated February, sir.
So that's the latest.
Yes, sir. The one that complied with the requirements of the DOJ, sir.
Thank you very much for that clarification. Thank you, Mr. President.
Thank you, Senator Villanueva. Before I recognize Senate President Gatchalian and thereafter Senator Erwin Tulfo, may I remind Attorney Narvasa that your 5 minutes, you will be given your 5 minutes after the questions of the senator judges and before we recognize the counsel for the prosecutor for his redirect. Senate President Gatchalian is recognized.
you,
You may
Honor.
proceed, sir. You have 2 minutes.
Thank you, Mr.
May I be
Presiding
clarified?
Officer.
I believe that we would do it after recross. So
You
it's-
want, I heard cross.
Sorry,
After
Your
we
Honor.
cross.
Yes, Your Honor. Thank you, Your Honor.
Better for us.
Yes, Your Honor.
Thank you, Mr. Presiding Officer. I just have a few questions, clarificatory questions. Narinig ko ho kanina ginong testigo na nasabi niyo may 40 media personalities doon sa press con. Tama po ba?
Yes, Your Honor.
Pero ang inyong inimbitahan, 6 lang.
Yes, Your Honor.
Bakit 6 lang?
The 40, we see the number of participants, but the number of person who asked the Vice President during that time, it's limited. And we consider who we sure that is present during that time, Your Honor.
Meron bang kayong criteria kung paano pipiliin itong mga media personalities or kung sino lang ang nagtanong? Kasi kahit hindi ka naman magtatanong, nandoon ka naman, naririnig mo yung mga diskusyon, meron ba kayong mga criteria kung paano pumipili ng media personalities?
Yung sure po namin na present during that time, kasi kapag hindi po kasi kayo nagtanong, hindi po magpa-pop up yung mukha nyo tsaka yung pangalan nyo.
Okay. At itong mga 6 na sinupina ninyo, ano yung kanyang common statement na ibinigay?
Kinonfirm po nila na present sila during the November 23, 2024 press conference, and yung utterance po ni Vice President narinig po nila.
Okay, I believe ilan dito sa mga personalities ay ipapatawag rin. So tatalon ako sa ibang topic. Nakita ko kanina itong tungkol sa max score interventures at nakita ko kanina pinakita yung Articles of Incorporation. Mukha siyang supplier ng equipment. Ngayon, nasabi rin na doon ka nag-training for 2 weeks. Sino nagbayad ng training?
Sir, the training is included in the procurement of digital forensic tools. In the procurement document, it ni-require po si MaxCore na mag-provide po ng training included in the equipment, sir.
Yung paggamit ng equipment.
Tsaka yung yung process po ng digital forensic as a whole.
Yung kanya lang sila ba ay 'di ba, sa mga IT, let's say Oracle, alam natin kilala yan pagdating sa IT. Si MaxCore ba ay kilala pagdating sa digital forensic training? Kasi sa alam, pag nakita ko kanina, talagang supplier sila, but are they a well-known or internationally renowned training organization?
It's not the mark score itself, but it's the trainer that they provide, sir, that is capable in training us, sir.
Itong trainer na ito, certified siya in this type of technology?
Yes, sir. The trainer has a lot of certifications in relation to digital forensics, sir.
Can you name a few certification na meron itong trainer na ito?
I can't remember,
Let's
sir.
say Oracle or let's say Microsoft, 'di ba? May mga ganyan
No,
yan.
sir. CompTIA, sir. CompTIA training. I believe he also have a certified ethical hacking certification and a lot more, sir. When it was presented to us, sir.
All right. So itong mga trainers nito ay certified trainers na pwedeng mag-train sa iyo at magiging certified ka rin.
Yes, sir. Initial na akong certificate, sir.
Lastly, Mr. Presiding Officer, after training, nakakuha ka ba ng certification na katulad sa kanila?
No, sir. But that certification that I was trained by them, sir.
Pero ikaw mismo, are you certified to do forensic examinations for your purpose and responsibility?
I have a certification, sir. I am a certified computer hacking forensic investigator, sir.
Itong forensic analysis, meron kang for this purpose, itong pinag-uusapan natin.
The computer, the authentication, sir, part or as a whole, sir?
As a whole.
I have a certification in computer hacking, sir, specific. But I have trainings in relation to the...
Iba yung hacking eh. Yung pinag-uusapan natin, forensic examination ng video, forensic examination ng mga ganitong bagay. Meron kang certification doon?
I have certificate, sir.
All right. Thank you, Mr. Presiding Officer.
Senator Judge Erwin Tulfo, thereafter Senator Judge Marcos. You may proceed, sir. You have 2 minutes.
Maraming salamat, Mr. Chair, Mr. Presiding Officer. Ang katanungan ko po ay para sa ating testigo. Batid ko po na sa ilalim ng Republic Act 10867, sa ilalim po ng Section 4, ang kapangyarihan po ng inyong ahensya na mag-imbestiga kapag ng mga krimen, partikular na tulad ng mga banta sa buhay ng Pangulo, ikalawang Pangulo, Senate President, Speaker of the House at Chief Justice. Tama po yun.
Yes, Your Honor.
Kahit na lalo pat pag ito ay may kaugnayan sa national security. Tama po?
Yes, Your Honor.
Pero ang tanong ko po, ang pagsasampa po ba ng kaso, nasa mandato rin po ba ng NBI na magsampa ng kaso doon sa mga tao na nagbanta sa buhay ng Pangulo, ikalawang Pangulo, Senate President, Speaker of the House, Chief Justice? Is it automatic or kailangan mag-request sila sa inyo? Matic ba yung pagsasampa ng kaso doon sa nagbanta? In this case, is it automatic or wala lang, kasama sa mandato niyo to file charges dahil binantaan mo Pangulo o si Vice Presidente kung sino mang yang 4 na matataas na opisyal natin or 5 matataas opisyal natin?
Ang basis namin doon, Your Honor, is yung primary objective namin to investigate cases to the threat to the President, Vice President, Senate President, Supreme Court. And if we found that the evidence is enough that there is a crime committed, we will file a case because that's the output of our investigation, sir.
Kahit po ba na hindi yung biktima, in this case yung Pangulo, biktima ng threat, kahit na hindi siya nagreklamo, automatic po yun? Kahit na hindi siya nagreklamo sa inyo?
Yes, Your Honor.
Okay. Hindi nyo na siya kailangan tanungin pa na, Sir, gusto nyo po bang kasuhan namin ito? Wala nang gano'n. You will never ask. Sabihin natin, hindi lang Pangulo, Vice Presidente. Nangyari din sa Vice Presidente o sa Speaker of the House, sa Senate President o sa Chief Justice. Hindi nyo naman lang siya afford to ask him like, Sir, will you go to the process? Kasi magpa-file ka po ng mga affidavit. This is a long process, etc. Kahit na Pangulo ka po, may pipirmahan ka mga affidavit. Is it automatic, Mr. Witness?
We submitted it, sir, even without a complaint in the for preliminary investigation, sir.
No further questions, Mr. Presiding
Thank you,
Officer.
Senator Judge Erwin Tulfo. Senator Judge Marcos is recognized. You may proceed, ma'am, and you have 2 minutes.
Yes, maraming salamat. Mahal na namumuna. Hihingi lang po ako ng dokumento para mas madali nating sundan ang mga pangyayari. Nalilito lahat pagkat wala po kaming papel. At ang nabigay sa amin, eto, Annex FFFGGG. Nalilito po kami kung alin dito yung mga papel. Kung maaari kaming bigyan, unang-una, yung unang tinutukoy, the first affidavit of investigation dated January 30, alleging grave threats inciting to sedition ng NBI. Ikalawa, yung napasok na yata sa record, pero nais rin namin bilang Senator Judge na magkaroon ng kopya ng DOJ certification signed by Prosecutor Bandung February 5 na nagbigay ng 7 grounds na insufficient for preliminary investigation. Ikatlo, yung naibigay na. Ito klaro to, naibigay po ni Mavic at ng iba pang staff natin. Yung February 10, yung ikalawang amended na ibinigay na revised affidavit of authentication, February 11. Ngunit sabi ni Testigo Kalilong na merong kasama ito na wala rito sa record natin at sana maibigay si Senator Judge. Ito yung sulat kasama nung second revised affidavit of authentication. Ito naman yung sinasabing sulat ni Santiago kay Padulyon ng DOJ na nagsasaad na hindi kailangan na may private complainant yung sina Presidente, ang First Lady at saka yung dating Speaker dahil base sa kaso ng Santos Concho versus DOJ na 2008, hindi daw kailangan yung private complainant. May we also have a copy of the same. Finally, may we urge that a copy also be given of February 14 certification of DOJ asserting that the revised affidavit of investigation was finally sufficient. Nais lang namin na makita yon at alamin yung investigation data, huling-huli, nung March 7, almost a month after the submission of the affidavit of authentication, kasi halos 1 buwan bago utusan na magkaroon ng investigation data form. Sana may kopya rin tayo noon.
To respond to Senator Judge Marcos, what the court has copies of are the pre-marked documents that the parties pre-marked during pre-trial, but not documents that have not yet been pre-marked. Most of the documents you mentioned that was discussed by counsel for respondent has not yet been pre-marked. They only used it to confront via cross-examination the witness of the prosecution. But the ones we have, we will furnish you with a reminder, of course, Senator Judge Marcos, that these documents have not yet been formally offered by either party. And we still have to await formal offer before the court rules on the admissibility, if at all, of these documents. But we will endeavor to furnish the good Senator Judge with whatever the clerk has.
Yes,
Your Honor, if I may.
if we could be provided with whatever the clerk has and adequately identified, not as GGGGG or FFFFF, at sana kung mabuo yung mga dokumentong sinasabi sa lalong madaling panahon. Maraming salamat.
We will endeavor to comply as best we can, Senator Judge Marcos.
Same issue.
Senator Judge Alan Cayetano,
Peram ng
what is your pleasure, sir?
Mr. President and Mr. Presiding Officer, before I ask to be allowed to ask a question, can I just follow up yung kay Senator Marcos, including the ruling yesterday? Just in the interest of all Senator judges being able to follow closely, especially kami sa first row kasi medyo nagkaka-stiff neck na kami. Mahirap tignan yung TV, so baka dun sa
Maglalagay
harap.
na po kami ng TV sa harap ng
And
lamesa
I
ng
don't know,
Counsel for Parties.
I think all of us own a iPad or a tablet. I don't know what the solution is, but if the Secretariat or the Clerk of Court, the Office of the Clerk of Court can work with our staff. Just to give you an example for today, no? if you look at the impeachment complaint on page 19, for example, it says that the affidavit we're looking for kanina, footnote number 72, is this one. In the impeachment complaint, no? It's found on Annex G. Okay, so this is Annex G. If you look at Annex G, it is a certification, not an affidavit. Okay, so where do you find the affidavit mentioned in the impeachment complaint? You actually find it in volume 14, Annex FFFFFFFF-GGGGGGGG. So before I can even
not
say
dash,
that,
that's FFFFFFF to GGGGGG.
yes. So even before we finish saying that, Your Honor, Mr. Presiding Judge, medyo mahirap. To further complicate, the annexes when delivered to us was labeled annexes. And then when it was pre-marked, iba na yung marking.
That is correct.
Okay. So to clarify, I'm not asking both the prosecution and defense to give us any documents in advance that will prejudice their presentation or the rebuttal. I do understand that it has to be offered, but to speed things up and to make sure we understand, in the same manner that they're asking the witness to examine it, maybe we can be given a copy to examine at the same time, whether digital or actual copy. I don't want to impose upon them to print 24 copies. But again, anyway, it's Wednesday. We have Thursday, Friday, Saturday, Sunday for our staff and the clerk of court to meet.
I think we already have a solution for you, Senator Judge Cayetano, as well as for Senator Judge Marcos. We will be furnishing the parties either via soft copy to your respective iPads or laptops, or we will enter their official emails as well. Kayo na po mag-print ng hard copy ng list of evidences as marked, as pre-marked by the prosecution na ipe-present for Article 4. And we will do this by article. However, insofar as I said, the documents presented by the counsel for respondent, these have not yet been pre-marked. But I don't think there's anything wrong with asking for a copy from the counsel for respondent.
On that point,
for our guidance, whether or not the same will be offered without prejudice to respond to
On
counsel
that
for
point-
respondent, deciding on whether or not they will offer it at the appropriate time.
on that point, Mr. Presiding Officer, even if it's pre-marked, if it will prejudice their presentation, I don't mind it be given in real time. And same, no? If it's being used on cross or recross on rebuttal and hindi to na pre-mark, as long as real time, para lang we can process it. If not, we have to review afterwards and it messes up our preparation for the hearing the next day. No?
Is that possible for the parties once the roles are reversed? May I get a response
Honor.
from the counsel for respondent?
Your Honor, first we'll clarify everything that was showed today was pre-marked by the respondent.
That's not my understanding because the DOJ letter you pre-marked is different from the DOJ letter that we have pre-marked. But we'll verify. So everything was pre-marked?
Yes, Your Honor.
But you presented a document that was not pre-marked either by the prosecution or the defense. Walang marking eh.
I presented all that.
So if it was pre-marked, it's our lookout. Then kindly, then there's no problem furnishing the senator judges with a copy of the same.
We have no problem with that, Your Honor.
Senator Judge Alan Cayetano's concern has no basis if it was all pre-marked. Yes. Apparently, it was our oversight.
Yes.
Counsel for the prosecutors, would that be possible?
Yes.
To furnish it? I think what counsel for respondent did earlier helped us out a lot. Plastering it on the screens, whatever affidavit you were presenting. I think counsel for the prosecutor should do the same.
Yes,
Hindi naman
Mr.
bawal
Presiding Officer.
magkopyahan dito eh. Okay lang. Senator Judge Cayetano?
Thank you. Yeah, and just to clarify, the 2 minutes is the question, not including
Yes,
the
yes, of
answer.
course.
No?
You have 2 minutes if you want to
if
start
they-
with asking questions.
Yes, if they ask to repeat the question, please don't count that. No, 2 minutes is long with short questions, but many of us want to get to the bottom of it, end up only asking 1 or 2 questions. So just a little bit liberality.
We will be lenient,
Yes. Thank you.
Senator Judge
Thank you
Alan
very much.
Cayetano. You
Appreciate
may
it.
proceed, sir. You have 2 minutes.
A question for the witness, and maybe to put all of us in check, I don't mind if any of the counsel says na medyo hindi maayos yung question. I mean, given what happened yesterday and today, and there are questions that could prejudice the case either way. As long as we call each other out respectfully, to the both counsels, you cannot correct a senator judge, but I don't mind if you think it prejudices. That's your duty to your client.
Yes, sure.
So this isn't the start of the 2 minutes yet. Sa magandang hapon, Mr. Witness.
Good afternoon, Your Honor.
Medyo mahaba na yung pag-upo mo dyan, but allow me a few questions. No? Yung circumstance lang, so paano nagsimula yung investigasyon na na-involve ka? Were you from the start o hindi? At written instructions ba to? O sinabi, oy, may investigasyon tayo? Just konting clarity, paano na-umpisa yung specific investigation? And was it based on the November 3 video? Tama ba?
November 23, Your Honor.
Okay.
It all started, I received a phone call, sir, from my executive officer that there is a video wherein there is a statement given by the Vice President, which is classified as threat, and I was tasked and assigned to investigate the case, sir.
Okay. So basically, ganun yung pagkasabi, na I'm tasking you to look at the video, investigate.
Yes, Your Honor.
Were you working alone or with a group?
With a group, Your Honor.
NBI group?
Yes, Your Honor.
And was this, is there an interagency also or just purely NBI?
Don't have personal knowledge. Maybe our chief, sir, has the
Okay.
knowledge on that, sir.
Yes. No, that's all I asked for naman, yung personal knowledge.
Yes, Your Honor.
So pakiulit mo yung sinabing, how exactly sinabi sa'yo na tignan mo yung video, imbestigahan mo, or may statement? So,
to be specific, sir, as far as I remember, may statement si Vice President regarding the November 23 press conference na kung saan may pagbabanta na naganap,
Okay.
pakiimbestigahan.
pakiimbestigahan. So ganun ka-general. May
Yes po.
pagbabantang naganap, pakiimbestigahan.
Yes po.
And you proceeded by watching the video.
Yes, Your Honor.
And when you watched the video, you got to the part na may pagbabanta.
No, Your Honor. I first don't know which part of that.
So you watched the whole video, of course.
First, the clippings, Your Honor.
Okay.
Then I look for the whole video, Your Honor.
Then you watched the whole video.
Yes, Your Honor.
And thank you for your honesty. So after the clipping, tapos the whole video, what did you do next? You reported or you made your recommendations? I don't understand the process lang kasi.
Upon identifying the whole video, I informed my executive officer that I identified the video, Your Honor.
And then yung sinabi mo yesterday, then you started looking for patterns. That's why you looked at yung dating mga video ni Vice President.
Yes, Your Honor.
So you started investigating the threat against the President, the First Lady, and the former Speaker of the House.
Yes, Your Honor.
Did you investigate the threat against the Vice President?
We tried, Your Honor.
How did you try?
It is included in our letter to the Vice President, Your Honor. That's why we're inviting her to proceed to our office to investigate the threats to her life, Your Honor.
How about the vlogger who asked her about Oplan or whatever they call that Romanov? Did you invite them?
Yes, Your Honor.
And did they testify?
The Princess Maui did not appear, Your Honor.
Did not appear. Did you also look for previous videos that are threatening to the Vice President?
We look on the Romanov part, Your Honor.
Okay.
But we identify a different person who first mentioned the Romanov, Your Honor.
Did you coordinate with the PSG?
I have no personal knowledge, Your Honor.
You yourself?
Yes, Your Honor. Maybe our chief, Your Honor.
Yeah. But you are aware that the primary responsibility of protecting both the President and the Vice President is the PSG?
Yes, Your Honor.
So isn't it fair to say that any investigation against a threat to the first family, the President or the Vice President, you would normally ask the PSG if they received any threat?
I have no personal knowledge, Your Honor.
No, I'm asking, hindi ba normal sa investigation kung sino yung primary agency na taga-protekta na lumalaban dun sa threat, ay tatanungin natin.
Yes, Your Honor.
So bakit hindi tinanong ng NBI ang PSG? Or in your case, why didn't you ask the PSG?
Maybe it can be answered by Chief, Your Honor.
No, I'm not. I will ask your chief also. I'm asking you, when they said, look at this, you looked at other videos, you tried to get Princess Maui, you tried to get the vice president, but you didn't contact the PSG for the first lady, for the president, and for all you know, the PSG will tell you right there and there, the threat is real, or the PSG will say, politika lang yan. Diba? Both the vice president and the president are protected by the PSG. So why wasn't so nakalimutan lang or wala sa procedure nyo or
Your Honor, there is already a statement from the National Security Council, Your Honor, that it is an active threat, Your Honor. That's why we start investigation.
Yes, and the primary group that will know if it's an active threat is the PSG. So if this was the United States, it will be the Secret Service. So whether the FBI or the CIA, state troopers, the federal marshals, kung sino man mag-iimbestiga, parati nilang tatanungin yung Secret Service. So I'm just curious why we did not ask the PSG input.
Kindly wind up, Senator Cayetano. Senator
Okay.
Judge Cayetano.
So my last question is, how did you characterize the threat of the Vice President to the President? Given that ang exact words niya, huwag kang mag-alala ma'am sa security ko kasi may kinausap na akong tao, sinabi ko sa kanya, kapag pinatay ako. So that I'll be fair to you and not vague, no? Did that phrase, kapag pinatay ako, have any bearing in your investigation?
Yes, Your Honor.
And what was that bearing or thoughts in your mind?
First of all po, dun sa statement, may nakausap na po. It already took place before pa yung mangyari yung meeting. And nung condition...
I'm not talking about yung may kinausap na para pumatay. Ang sinasabi ko yung sinabi niya na pag pinatay ako.
Yes, Your Honor.
How did that affect your investigation?
There is a condition na kapag pinatay siya. But as we can see, it's only applicable if there is only two parties. The statement make a loophole wherein a third party can use that na kapag namatay si BP, ma-execute ngayon yung statement ni BP na may nakausap na siya without the participation of the one mentioned, the President, the First Lady, and the Speaker of the House, Your Honor.
That's fair. But what I'm saying is that in your reports, did you characterize it as a conditional threat? Kasi kung hindi naman siya pinatay, the logical implication is that there's no threat against the... So I'm not saying it's not illegal, immoral to contract a killer. I'm just trying to follow the logic na pag sinabi kong pakukulong kita, Mr. Witness, pag nagsinungaling ka under oath, then it's actually not a threat. It's a legal... I'm just telling you the law, di ba? Pero pag sinabi kong pag hindi ka sumunod sa akin, anuin kita. So that's my last question lang. So how did you characterize that? It wasn't a conditional in your mind because may kinausap na?
Even with or without, sir, it's still considered a threat as long as the person...
I have no doubt there. I'm just asking, is it a conditional threat?
Based on our affidavit, sir, I believe it's conditional, which...
Based in your affidavit. But your initial assessment, yung personal mo as an investigator, this is an investigation of the whole NBI, but yung personal mo?
The threat is absolute, sir.
Okay. Thank you, Mr. President. Thank you.
Thank you, Senator Judge Cayetano. We now proceed. Senator Judge Padilla is recognized.
Maraming salamat po.
Thereafter, Senator Judge Zubiri.
Maraming salamat
Senator Judge
po.
Padilla, you have 2 minutes.
Opo. Nais ko lamang po magtanong sa ating saksi. Ginoong saksi, kanina po kasi habang nagkakaroon ng pagdinig, ako po'y laging iistorbo dahil tuwing may itatanong, mag-o-object, medyo magulo po eh. Pwede po bang sagutin po ninyo ako dahil Noong pong February 5, ang sabi po dito ay insufficient po yung na hindi dapat makarating na sa preliminary investigation. Tama po ba? February 5 po yon.
May certification, sir. Yes po.
Opo. Tapos nung February 14, naging sufficient na for conduct of preliminary investigation. Nasagot po ba yung 7 na sinabi dito na para, ang sinasabi po kasi dito nung February 5, merong 7 na kulang.
I believe so, sir. That's why we have received a certification, sir.
Ayun. Kasi po, parang narinig ko kanina, hindi po naibigay yung original copy nung sinagawang interview kay Vice President Sara Duterte. Yung original po, na kopya, kung sino po yung nag-record. Wala po kayong affidavit? Meron po ba kayong affidavit na nakuha nyo?
Yes, sir. Ako po yung ang inire-request po ng DOJ dyan is affidavit po nung nag-screen record, which is my affidavit, Your Honor.
Meron po siyang affidavit?
Ako, sir. Ako po yung nag-execute, sir.
Hindi po yung mismong tao?
Yes po. Ang hinihingi po kasi ni DOJ is kung sino yung nag-screen record through OBS, sir.
Hindi po yung mismong tao?
Yes, Your Honor.
Kayo lang po yung nag-affidavit?
Yes, Your Honor.
Pero meron po kayong ng pagkakataon ba na nakausap niyo yung tao at nagbigay siya ng affidavit?
May I clarify, Your Honor, if sinong tao yung tinutukoy?
Yung nag-record po?
Ako po yung nag-record through OBS, sir.
Hindi po. Yung mismong nag-record po kay Inday sa Vice President. Nakausap niyo po ba? Yung raw file po. Kasi napakahalaga po nun. Kasi doon po natin malalaman kung original ba o hindi.
The video itself, sir, is publicly available. That's why I performed the recording, sir.
Opo. Pakisagot na lang po, mahal na saksi, kung nakuha niyo po ba yung original. Yung original, hindi po yung galing sa internet.
The original, no, sir.
Yun lamang po. Maraming salamat po.
Thank you, Senator Judge Padilla. Senator Judge Zubiri, you are recognized, sir. You have 2 minutes.
Maraming salamat to our presiding officer. Magandang hapon po, Sir Witness.
Good afternoon, Your Honor.
Good afternoon. Gusto ko lang magtanong, clarificatory questions lang po ito. Dito ba sa ating bansa, dahil tinatanong ko po ito sa inyo, dahil kayo po investigating body, sa ating bansa, meron bang specific law pagdating sa mga banta sa Pangulo, Pangalawang Pangulo at kanyang mga successors? Or yan ba'y pasok lang sa grave threats, which is applied sa lahat? Applicable sa lahat ng tao?
Based on my personal knowledge, sir, it's only on the grave threat, Your Honor.
Which is applied to everyone, if I'm not mistaken. No? Kasi sa batas sa Amerika, sa Estados Unidos, meron po tinatawag na number 18 under the United States Code, Section 871. There is a specific law na pinagbabawal po itong mga threats to the President, Vice President, and its successors. May jail time po ito at may fine na malaki. As a matter of fact, dito sa panahon ni Pangulong Trump, marami na po silang kinasuhan at hinabla at napasok sa kulungan dahil sa paglabag nitong batas na ito. At Secret Service po ang sumasagawa ng investigasyon. Sa atin ba dito, ang NBI ba ang nabigyan po ng kapangyarihan para gawin itong investigasyon under your new NBI code?
Under our law, sir, the new NBI law, included po yung investigation to the threats to the life of the President, the Vice President, the Speaker, the Senate President, and the Supreme Court, sir.
So, klaro na kayo, nasa kapangyarihan ninyo. Kasi hindi pwede sa Presidential Security Group. Hindi katulad sa Estados Unidos, yung Secret Service ang talagang nanguhuli at nag-imbestiga. Sa atin dito sa Pilipinas, ang NBI po ang nangunguna sa investigasyon. Tama po ba yan o mali?
It is within our law, sir.
Okay. And this is just food for thought because not only are we senator judges, we're also legislators. It may be time that we also craft a law that will be specific on threats made to the President, Vice President, and its successors, meaning the Senate President, the Speaker of the House, and the Supreme Court Chief Justice. Sa Amerika kasi, sa batas po nila, and I'll just wrap up, the defendant, to secure conviction, the defendant communicated a threat. The defendant understood and intended the statement as a true threat. Hindi po niya sinabi joke only in the end. And pangatlo, the defendant knowingly and willfully makes the threat. So just food for thought as legislators as well. So maraming salamat po, Mr. President.
Thank you, Senator Judge Zubiri. We now proceed to where we left off. I believe that was the redirect of the counsel for the prosecutor. Just out of curiosity, without any pressure, because I promised I would declare a break somewhere in between, depending on how long your direct and recross would be. I can call the break after the recross and the statement of the counsel for respondent, so that we break on a good point before we call on the last witness for today. Yes, counsel for the prosecutors.
As to the question, if the prosecution will do the direct examination.
The redirect. Kung mahaba-haba
Sorry,
pa
the
yung
redirect examination after the cross-examination of the defense. The prosecution decides not to conduct a redirect, Your Honor, please.
Thank you, counsel for the prosecutor. Counsel for the respondent, do you want to begin to utilize your time now?
Your Honor, I will turn over the mic to my co-counsel. He will also be the cross-examiner for the next witness.
But Your Honor, please, sorry. May I make a manifestation, Your Honor, please, before we proceed, Your Honor, please? A manifestation as to the
In
statement
connection with what, counsel for the prosecutors?
that were
Yes.
presented to the witness. I believe that the defense said that all those exhibits were pre-marked. But based on our records, Your Honor, please, and then I hope the defense will clarify this for the record. We perused the documents and we don't see that the articles of partnership and the screenshots of the websites that were presented earlier, based on our tally, based on our records, these were not pre-marked, contrary to what the defense manifested. So we would like to seek clarification from the defense.
That is correct, Your Honor. Those three documents were not
Noted
pre-marked.
and entered into the records.
Thank you so much.
Given that there is no redirect and recross, counsel, can you state for the record your name?
Good afternoon, Your Honors. I am Mark Sivin Luan for the Vice President.
Sir, you're aware of the situation. Time was given to the counsel for the prosecutors to make a discussion about whether or not Article 4, the acts alleged in Article 4 constitute an impeachable offense. You have the same time of 4 minutes and 26 minutes, which will round. Before I allow you to continue, kawawa naman si Mr. Kalilong. Mr. Witness, Mr. Kalilong, Senator Judge Lacson, before we excuse. Senator Judge Soto is recognized. Sir, what is your pleasure, sir?
Mr. President, Mr. Presiding Officer, are we going to dispense with the witness already?
Unless you have questions. I believe Senator Lacson has questions to the witness. So not yet.
Well, it's a simple question.
The gentleman
You're
may proceed.
familiar. Thank you very much. You're familiar with the internet, of course.
Yes, Your Honor.
Have you noticed that lately all the AI-generated videos have a caption saying AI-generated?
Yes, Your Honor.
Kaya pag walang nakalagay na AI-generated, siguradong hindi AI-generated? Not
Yes, Your
exactly.
Honor. Today, Your Honor.
Yes, lately, no?
Lately, Your Honor.
Lahat nakalagay. Pag AI-generated, nakalagay AI-generated and Meta does not allow it. Right?
They allowed it, but there is a AI info part.
Correct.
On
Let's
the
say
post.
there is a manifestation.
Yes,
that
Your
it's
Honor. It is
AI-generated.
explicitly mentioned that AI.
So you're aware of that?
Yes, Your Honor.
Thank you. That's it.
Senator Judge Lacson, you likewise have 2 minutes, sir. You may proceed.
Thank you, Mr. Presiding Officer, Mr. Senate President. I have questions para sa ating testigo. Since you are presented here as an expert witness, alam nyo, nagkusort din ako sa digital forensics expert para lang makonvince sarili ko. No, my first question is, in this day and age of artificial intelligence, no, will you agree with me na it is almost impossible to distinguish an AI-generated video from the original? Almost impossible.
Yes, Your Honor, it is hard, Your Honor.
Yeah, very hard, di ba? Very difficult. So kasi ito, impeachment trial, ano? Kasi sa court, ginagamit talaga yung expert testimony ng digital or computer forensics expert. Now, you may or may not answer this question kung classified, ano? Gusto ko lang malaman, ano ba yung digital forensic tools na ginagamit din sa NBI?
Currently, I'm not familiar. But during the time na nandun po ako sa Digital Forensic Laboratory Division, meron kaming Encase Forensic, Celebrite, and Amped Authenticate, sir. Amped Authenticate, sir.
Ang balita ko, yung AMP 5 or AMP Authenticate, di ba?
Amped Authenticate, sir.
Ito yung ginagamit ninyo. Ito, capable ito na magsagawa ng reverse image, a photo or video, di ba?
Yes, Your Honor.
Okay. Ito ba yung ginamit mo?
For this part, Your Honor, the OBS only, Your Honor.
Bakit hindi nyo ginamit ito?
The duration is too large, Your Honor, the 2 hours. And the Amped Authenticate can only detect if there is a inconsistent FPS, Your Honor.
Yeah, kasi kaya ako tinanong yon dahil una maraming para mag-adhere na magamit sa korte, no. Likewise sa impeachment court. May mga requirements, di ba? Sinabi mo kasi meron kayong open source, di ba?
Yes,
Pero
Your Honor.
ang pinaka-importante yung chain of custody, of course, yung provenance.
Yes, Your Honor.
Yung original na pinanggalingan.
Yes, Your Honor.
Ang sabi mo, pinanggalingan lang Facebook.
The Facebook was captured, Your Honor.
So, hindi yun ang original, di ba?
The screen recording is the original itself as to my authentication, sir.
Yeah, and you can attest sa authenticity ng video.
Yes, Your Honor.
In spite of not being or not having originated from the original.
Yes, Your Honor. I compared the recorded with the original and ensured that the contents are identical, Your Honor.
Kasi nabanggit mo rin, ginamit mo yung manual comparison simultaneously ng dalawang videos.
Yes, Your Honor.
Pero again, I will insist na talagang hindi reliable yung manual. Ito yung sinabi sa akin ng digital forensics expert na nakausap ko, no? Ang pinaka mas importante, makuha mo yung original copy, yun nga, yung provenance, di ba? Para talagang, tapos masundan mo yung sa analysis, gagamitan mo ng tools para malaman mo na talagang authentic yung video. Of course, I'm not here to question the authenticity. I just want to be assured dahil sabi ko nga kanina, pagka sa artificial intelligence, napakahirap talaga. Almost impossible to distinguish it from the original video or yung source.
Yes, Your Honor.
And you are competent enough to ginagamit yung forensic tools or forensics tools at yung inyong yung competence mo through your training, you know.
And experience, Your Honor.
And experience. Kasi sabi mo nga, you've been with the NBI since 2021, di ba?
Yes, Your Honor.
And since then, you have appeared in some 20.
At least 30, Your Honor.
30.
Yes, Your
30 court hearings.
Yes, Your Honor.
So, thank you, Your Honor. Thank you, Mr. Presiding Officer.
Thank you, Your Honor.
Thank you, Senator Judge Lacson. Senator Judge Cayetano, what is your pleasure?
Just a clarification addressed to the presiding officer.
You may proceed, sir.
Apologies, I don't remember if it was one of the counsels or one of the senator judges who asked the witness a while ago whether he was an expert witness, and he said he was a competent witness.
That is correct.
And there's a
The
difference
presiding
between an
officer
expert
confirms that.
witness. So he's not an expert witness. He's an competent witness.
That is correct, Your Honor.
So that will have bearing because whether or not an AI video can be produced without an AI has to be testified by an expert witness.
If I may,
Wait, yeah, go ahead. That doesn't mean, I don't think you'll disagree with my second statement. That doesn't mean that this witness is not competent to testify on that. Second point, I just like to clarify for the record, my understanding of watching the video is that it was on StreamYard, then a link was shared sa Facebook.
Yes, Your Honor.
So if that's the case, Mr. Presiding Officer, the original video is with StreamYard, not with Facebook, or are both original?
It's Zoom, Your Honor.
Zoom?
Yes, Your Honor.
I was informed StreamYard, but just for the record, so that later on when we review everything, someone testified to it.
Duly noted.
Yeah, thank you.
One, you have your 4 minutes and 26 seconds, but we cannot use the seconds in our timer, so just look at the clock, sir, please.
Your Honor, please.
Before we... Yes, Mr. Kalilong, you are excused, sir.
Thank you, Your Honor.
And thank you for your time and cooperation with this impeachment court.
Thank you so
Your
much,
Honor.
NBI Senior Agent John Mark Calilong. Thank you so much.
Hold on, Mr. Kalilong. Yes, Senator Judge Padilla. What is your pleasure, sir?
Ginoong tagapamahala ng hukumang ito, nais ko lamang po sana hingin ang mga credentials ng ating saksi kung paano po lahat ng kanyang certification, lahat upang mapatunayan po natin lahat na
It's ready.
To it earlier, but kindly respond to the question of Senator Judge Padilla, Mr. Witness.
I have here, sir, my certifications during the time of my investigation, Your Honor.
Can you, mahaba ba?
I can read, Your Honor.
Mahaba ba? Hindi.
ibigay na lang po siguro sa
Kindly
atin.
just submit it to us. Yes, please.
Opo,
Yes,
submit
Your
na lang po.
Thank you, Your Honor.
If that is okay with Senator Judge Padilla. Thank you, sir. Mr. Kalilong, you are excused, sir, and thank you for your time and cooperation with the impeachment court.
Thank you, Your Honor.
The presiding officer will just wait for the witness to leave the premises before recognizing Attorney Binon. Okay, Attorney Binon, you have 4 minutes and 26 seconds. You may proceed, sir. Thereafter, we will call for a 15-minute break.
In the discourse yesterday, talking about VP Sara's statements during the November 23, 2024 press con, Senator Judge Risa Ontiveros stated, and I quote, "None of these statements are proof that the Vice President actually contracted an assassin or hired one. She is absolutely right." She then asked the question, why are these acts impeachable? To this question, the prosecution responded, "We understand that these statements may not actually 100% prove that she in fact contracted an assassin, end of quote. Hence, the prosecution admitted that the video does not prove any fact other than its existence. In simple words, there is no proof of any contracting of an assassin. The prosecution's admission before this honorable court made the respondent's position clear. The prosecution has no other competent evidence to prove that VP Sara contracted an assassin. Ang testimonya ni Kalilong, gaya ng iba pang ebidensya kuno ng prosecution, ay hindi sapat para patunayan ang paratang na ito. Trying to prove this stretched narrative using a hodgepodge of materials is a waste of this honorable court's time and the Filipino people's money. Si VP Sara na mismo ang nagsabi na hindi assassin ang kinausap niya. This term only came from people who took her statements out of their proper context and tried to exaggerate them for what they really meant. The truth of the matter is this: she and her family were threatened, and while her response was unconventional, it was justified. What triggered her response was a question about Operation Romanov, which is the plot to eliminate VP Sara and her entire family. The NBI's own records prove this. In the minutes of the meeting of Dempsey Reyes' interview, he said, and I quote, "May press con kasi earlier than that, sabi niya, parang hindi lang niya gusto daw, sabi lang niya gusto daw siyang patayin daw, according to her, ni Speaker. That was during a press conference the day before, November 2022. End of quote. During the virtual press con, Princess Maui mentioned Operation Romanov again and even warned her about her safety. Reyes talked about it, Princess Maui reiterated it, but the NBI gaslighted it. When VP Sara uttered those words, she was not responding as Sara Duterte, the Vice President, but Sara Duterte, the wife, mother, daughter, and sister, who only sought to protect her own and her family members' lives. Operation Romanov is in place, and the threat against their lives is real. VP Sara became the target of unauthorized intelligence and surveillance operations by government operatives that exposed her family to high-level risks and security threats, thereby causing intense trauma and uncontrollable fear. Her homes in Davao and Manila were profiled, and this is proven by classified casing reports. Her trusted security personnel were removed. Her schedule of official functions, like the one in Naga, was leaked by intelligence agents, and her security was heavily compromised. In sum, the prosecution was right in using the term culmination. But the prosecution's interpretation is wrong. Rather, when VP Sara left the administration, she suffered various forms of threats and harassment for many months from the powers that be, and the culmination was her statement on that fateful early morning in November 2024. She didn't commit an impeachable offense. She drew the line in the sand and said, "Enough is enough." That is the meaning, and that is the context. Finally, as to the alleged grave threats and inciting to sedition, these are defined by the revised penal code and are punishable by prisión correccional. Thus, these fall under the jurisdiction of the MTC or first-level courts. These charges are not other high crimes as contemplated by the Constitution as grounds for impeachment and are therefore not impeachable. After all, VP Sara was fighting two important battles that day. One against the threat to her family's life, and another against the life of the ordinary Filipino, constantly suffocated by the immense weight of corruption, which she talked about during the press con. She never incited sedition. She merely echoed the voice of ordinary Filipinos. Her message that day only reflected what was already in their hearts and minds. There was no betrayal of public trust. She actually upheld the people's trust as she spoke for and behalf of the people. Thank you, Your Honor.
Thank you, Attorney Vidluan. Chair declares the 50th. Senator Judge Bam Aquino, before we declare a recess.
Yes, just a quick manifestation, Mr. President.
You may proceed, sir.
Tapos na po tayo sa unang witness. It's taken us maybe a total of 9 hours for the first witness. Ito ho, isang pakiusap sa parehong grupo. Alam ko po may kanya-kanya tayong estilo, may kanya-kanya tayong strategy. But if possible, can we allow the testimonies to be heard? Can we have proceedings that will go straight to the point? Kasi po nanonood ang taong bayan, pati po kaming mga senator judge. Gusto rin ho naming makita itong mga proceedings, yung mga ebidensya na mas madali ring maintindihan. So ito naman po, di ho namin pwede itong idikta sa inyo. But if possible, the succeeding witnesses, and we have a long list, this goes for both parties, by the way. Let's have proceedings where we can go straight to the point, malaman natin yung puntos ng bawat grupo para makapagdesisyon rin po tayo ng maayos. Ito po this is a plea, no? This is not an order to both parties, but if we can This is the People's Tribunal. We're watching. Everybody's watching. Sana po, payagan natin na lumabas yung mga katotohanan, lumabas yung mga ebidensya upang maging mas madali at mas kaya-aya po yung ating proceedings. Yun lang po, Mr. President.
Thank you so much.
Noted and entered into the records. Chair would like to give Senator Bam, bibigyan ko ng konting pag-asa sa Senator Bam. Usually, ang mga paglilitis tulad nito, parang diesel yan. Sa simula, syempre dahil una pa lamang, nagkakasanayan, nagkakaestimahan, pero bibilis at bibilis ito sa pagdaloy din ng ilang araw lang ng trial natin. And you will be able to see that in the next couple of days. Chair declares a 15-minute recess. We
Your Honor,
all come
please.
back.
Your Honor,
Yes,
please.
counsel for the prosecutor.
Before the declaration of recess, I suppose that the reason is for the presentation of the next witness for
Yes.
the prosecution. We manifest, Your Honor, that John Mark Calilong will be our witness for this afternoon. We'll be presenting the next witness during the next hearing on Monday, Your Honor, please.
You won't present Attorney Lotok anymore?
Yes,
today?
Your Honor. On Monday, Your Honor, please. We will utilize the 11 days allotted to Article 4 for the prosecution, Your Honor, please.
So, no Attorney Lotok today?
Today, we'll do that on Monday, Your Honor, please.
So,
Your Honor.
Chair would like to, I guess there's no need to declare a recess.
Yes, Your
Senator
Honor,
Judge
please.
Lacson,
Your
thank you for
Honor.
that manifestation. Yes, counsel for the respondent.
Your
What
Honor,
do you want
maybe
to say?
just clarified if Attorney Lotok is the witness on Monday because they had already
Yes.
disclosed the witness.
I was about to ask that question.
Yes, Your Honor. Attorney Jeremy Lotok will be presented
On
by the
Monday?
prosecution on Monday, Your Honor, please.
Likewise, can you name us, you manifested that you will also be presenting next week or requesting a subpoena to, yes, to Attorney Lopez and Attorney Director Matibag.
That would be Captain Belinda Bello, Your Honor, please, and NBI Director
Matibag.
And then
Lotok first.
Lotok, Your Honor, please, and then
Matibag.
And then we'll disclose on Bello, Your Honor, please. Captain
Sergeant at Arms.
Belinda Bello of the House of Representatives, Your Honor, please.
So those two witnesses.
Yes, Your Honor.
We have 3 days, counsel.
No. Wait.
Name me one more.
Okay, that would be NBI Director Matibag, Your Honor, please.
Given the manifestation of the counsel for the prosecutor, chair hereby orders the issuance of subpoena once again to Attorney Lotok for the trial dates on July 13, 14, and 15, as well as for Attorney Melvin Matibag. No need for a subpoena for Miss Bella?
Your Honor.
Before I recognize counsel for respondent, no need for a subpoena?
There's no need for subpoena, Your Honor.
You did not request for a subpoena, counsel.
Yes, Your Honor.
So no need.
No need, Your Honor.
You will produce, can you state the name again for the record, counsel? Can you state the name of the witness again for the record?
Your Honor, the first witness will be Captain Belinda Bello. That would be Attorney Jeremy C. Lotok. Number 2 is Captain Belinda Bello. And number 3, NBI Director Matibag. And number 4.
Thank you.
That's for no.
Thank
For
you,
next
counsel.
week, those are the witnesses, Your Honor, please.
Thank you. Counsel for respondent,
Your
what
Honor,
is your pleasure?
Your Honor, considering the change in schedule, may we just confirm if that is the exact order of presentation next week?
I believe so. The chair would like to be the one to confirm that. To reiterate,
Your Honor, may I be recognized? I apologize.
yes, the member of the panel of prosecutors, Representative Defensor, what is your pleasure, sir?
Your Honor, may I just correct, since the private counsel is under the direct supervision and control of the
Yes, of
counsel
course.
prosecutor. For Monday, Your Honors, we will be presenting Attorney Jeremy Lotok. For Wednesday, we will be presenting Tuesday, we'll be presenting Attorney Zulaika Lopez. And for Wednesday, our third witness, we will be presenting Captain Belinda Bello.
Captain Belinda. So, Director Matibag is not yet going to be presented next week?
Not yet, Your Honor. We will manifest on Monday if we can consider him for the Wednesday's session, depending on how the trial goes or how long the testimonies will take for both parties.
Noted. What is the pleasure of council? Chair would like now to discuss and dispense with some administrative matters. The BIR box, which the chair ordered to be returned on July 6, has actually been returned to the BIR, sealed, untouched, and duly received accordingly. And the counsel for the prosecutors have filed a motion for the issuance of subpoena duces tecum at testificandum to the BIR concerning this box. Has a copy been furnished to the counsel for the respondents?
None yet, Your Honor.
None yet? I thought, yes.
Your Honor, we confirm that we emailed a copy to the respondents. Last
Kindly
Monday, Your
check
Honor.
so that we can dispense with the need of reading the subpoena. Having said that, given that this has been put in issue rather in the pre-trial brief of both parties, there is counsel for respondent, we will accord the same treatment to this with respect to the subpoena, request for subpoena for the bank accounts of the spouses, Vice President Sara Duterte and Attorney Mans Carpio. Therefore, the presiding officer orders both parties to submit a memoranda on the subject matter of the subpoena of the BIR records on Monday. And we will also schedule the oral arguments for deciding on this issue together with the bank records on Wednesday. Each party will be given 10 minutes without prejudice to a rebuttal and or a rebuttal by the other side for another 3 minutes before the court shall decide.
We will comply, Your Honor.
We will comply, Your Honor.
Thank you. So ordered. In regard to the request for the issuance of a motion for subpoena, asan yun? May I ask if counsel for the respondents were likewise furnished with a copy of the most request for subpoena, although this is ex parte because this is only with respect to witnesses. So there is no need to issue a subpoena to Attorney Melvin Matibag for next week. Honorable Defensor? No need?
No need, Your Honor.
So just Attorney Zulaika Lopez?
Yes, Your Honor.
Chair orders that subpoena be issued to Attorney Zulaika Lopez to appear on July 13, 14, as indicated by the counsel for the prosecutors, given that on the 15th, we might be arguing on the bank deposits and the BIR documents.
We submit, Your Honor.
So ordered. There being no other matters for consideration by the court, and given that the counsel for prosecution for the prosecutors have manifested that they will no longer present Attorney Latok today, but rather on Monday, the trial is hereby adjourned until 2 p.m. of Monday, July 13, 2026.